네, 이제 곧 개회식을 시작하도록 하겠습니다. 모두 자기 자리에 앉아주시면 감사하겠습니다. 네, 안녕하십니까. 2023 국제특허법원 콘퍼런스에 오신 것을 환영합니다. 저는 오늘 개회식의 사회를 맡은 손영원 판사입니다. 올해로 국제특허법원 콘퍼런스가 9회째를 맞게 되었습니다. 이렇게 큰 국제 행사에 이 자리에서 여러분을 뵙게 되어 영광입니다. 본 컨퍼런스는 세계 IP 전문 법관과 전문가들이 경험을 공유하고 상호 이해를 촉진하기 위해 마련되었습니다. 올해는 Court, IP and New Perspectives라는 주제 하에 지식재산권에 관한 실무를 심도 있게 토론해보고자 여러 세션을 구성하였습니다. 오늘 이 자리에는 지식재산 소송 분야에서 가장 명망이 있는 전 세계 각국의 법관과 전문가들이 참석해 주셨습니다. 시간 관계상 일일이 소개해드리지 못하는 점을 양해해 주시기 바랍니다. 주최 측을 대리해서 오늘 이 자리에 함께해 주신 발표자분들과 참석자분들께 깊이 감사드립니다. 네, 다음은 본 컨퍼런스를 주최하는 한국특허법원의 김용석 법원장님의 개회사가 있겠습니다. 김용석 법원장님을 큰 박수로 모시겠습니다.
멀리서 이번 컨퍼런스에 직접 참석하신 데이빗 캠벨 판사님, 에드먼드 챙 판사님, 클라우스 그라빈스키 법원장님, 리처드 헤이콘 판사님, 안나레나 클라인 판사님, 히로아키 이마이 판사님, 요시아키 시바타 판사님, 안드라스 요쿠티 와이포 국장님, 크리스토프 비간테 변호사님을 비롯하여 온라인과 오프라인으로 함께하고 계시는 모든 분들께도 깊은 감사의 말씀을 드립니다. 올해로 제9회를 맞이하는 국회 특허법원 콘퍼런스는 세계 지식재산권법 전문가들이 다양한 쟁점을 깊이 논의하는 국제학술 교류 행사로 자리 잡았습니다. 이번 컨퍼런스 대주제는 코트, IP and New Perspectives입니다. 전대미문의 코로나19 팬데믹을 극복한 인류는 이제 인공지능과 빅데이터 분석, 첨단 정보통신 기술들이 융합된 제4차 산업혁명 시대를 맞이하고 있습니다. 이러한 때 과학기술과 법에 관한 깊은 성찰을 토대로 여러 지식재산권 이슈에 관하여 논의하고 더 나아가 IP 전문법원이 나아가야 할 바람직한 방향을 모색해보는 기회를 가져보는 것은 매우 뜻깊은 일이라 할 것입니다. 이를 위하여 올해는 New Perspectives라는 대주제에 걸맞게 세계 여러 나라의 지식재산 소송의 관할과 전문법원, 2023년 6월 출범한 유럽 통합특허법원과의 성과와 비전에 대하여 논의하고 첨단 기술 시대에 그 중요성이 더욱 강조되고 있는 영업비밀 침해소송과 특허권자의 권리구제 방안으로서 실무상 활발히 논의되고 있는 금지명령의 요건과 범위 등에 관하여 새롭고 심도 있는 논의를 하기 위하여 내용과 형식을 구성하여 보았습니다. 올해 컨퍼런스는 미국, 유럽, 영국, 독일, 일본, 중국, 한국의 여러 법관들과 전문가들이 한자리에 모여 지혜와 경험을 나누는 소중한 기회가 될 것으로 기대합니다. 또 국제특허법원 컨퍼런스가 지식재산 전문법원과 법관과 전문가들 사이의 국제 네트워크의 중심으로 계속 발전해 나가기를 희망합니다. 이번 행사를 위해 헌신적으로 준비해 주신 각 세션의 사회자들과 발표자들께 감사의 말씀을 드립니다. 그리고 바쁘신 가운데 함께해 주신 참가자 여러분 모두에게 유익한 시간이 되기를 기원합니다. 감사합니다.
네, 김용석 법원장님 감사드립니다. 다음은 대법원장 권한대행이신 안철상 대법관님의 축사가 있겠습니다. 안철상 대법관님은 일정상 참석하지 못하셨지만 이번 행사를 축하하는 마음을 담은 동영상을 보내주셨습니다. 함께 시청하도록 하겠습니다.
안녕하십니까. 대법원장 권한대행 안철상 대법관입니다. 대한민국 사법부를 대표하여 2023년 국제 특허법원 콘퍼런스의 축사를 하게 되어 정말 기쁘게 생각합니다. 2015년 처음 개최되어 올해로 9회를 맡게 된 국제 특허법원 콘퍼런스는 이제 전 세계의 지식재산 전문법관과 전문가들이 서로의 지혜와 경험을 나누는 교류와 소통의 장으로 확고히 자리 잡았습니다. 전대미문의 코로나19 팬데믹이 종식된 이후 이곳 과학기술의 도시 대전에서 국내외 패널분들을 현장에 모시고 콘퍼런스를 진행할 수 있게 된 것은 매우 뜻깊은 일입니다. 이 자리에 함께 하시는 미국의 데이비드 캠벌 원로법관님, 에드먼드 창 판사님, 유럽 통합특허법원의 클라우스 그라빈스키 항소법원장님, 영국의 리처드 헤이컨 판사님, 독일의 안나 레나 클라인 판사님, 일본의 히로아키 이마이 판사님과 요시아키 시바타 판사님, 세계지식재산권기구의 안드라스 요쿠티 국장님, 그리고 독일의 크리스토프 비간트 변호사님께 깊이 감사드립니다. 또한 전 세계에서 온라인과 오프라인으로 이번 콘퍼런스를 함께하고 계시는 모든 분들께도 감사의 말씀을 드립니다. 아울러 이번 행사를 위하여 노고를 아끼지 않으신 특허법원 김용석 법원장님을 비롯한 모든 관계자 여러분께 경의를 표합니다. 오늘날 융합정보통신 및 인공지능기술의 급속한 발달은 우리의 일상생활에 지대한 영향을 미치고 있습니다. 그에 따라 전 세계적으로 관련 지식재산권의 중요성이 커지고 있으며 법적 분쟁 역시 증가하고 있습니다. 이러한 지식재산 분쟁을 해결하기 위해서는 첨단 과학기술에 대한 올바른 이해는 물론 사회 현상에 대한 깊은 통찰과 함께 능동적으로 대처할 수 있는 지식과 능력이 꼭 필요합니다. 나아가 급변하는 과학기술에 따른 여러 가지 부작용을 최소화하면서 기술을 통한 인류의 번영을 도모하기 위해서는 지식재산권 분야에 관한 지속적인 국제적 교류와 협력도 필요합니다. 여러 국가의 훌륭한 법관과 전문가들이 참여하는 2023년 콘퍼런스의 대주제는 Court, IP and New Perspectives입니다. 이번 콘퍼런스는 각국의 지식재산소송과 전문법원, 유럽 통합특허법원의 출범과 비전에 대하여 살펴보고 첨단 기술 시대에 실무상 매우 중요한 영업비밀 침해소송과 금지명령의 주요 쟁점에 대하여 각자의 풍부한 지식과 경험을 공유하고 토론하는 소중한 자리가 될 것입니다. 이러한 기회는 코로나19 팬데믹을 극복한 후 새로운 시대로 나아가고 있는 현 시점에서 매우 시의적절하고 유익한 것이라 생각합니다. 이틀간의 콘퍼런스를 통하여 지식재산권에 관한 바람직한 재판을 구현하기 위한 많은 지혜가 모이고 좋은 결실로 이어지기를 기대합니다. 이 자리에 함께하는 법관과 전문가 여러분들께서는 서로의 국적과 국경을 초월하여 따뜻한 마음을 나누는 친구이자 동반자가 될 것이라고 믿습니다. 다시 한번 2023년 국제특허법원 콘퍼런스의 성공적인 개최를 축하드리며 이번 콘퍼런스에 참가하신 여러분 모두의 건강과 행운을 기원합니다. 감사합니다.
네, 감사합니다. 다음으로 클라우스 그라빈스키 유럽 통합특허법원 항소법원장님의 축사가 있겠습니다. 클라우스 그라빈스키 법원장님은 오늘 이 세션에도 참석하셔서 유럽 통합특허법원에 관한 여러 논의를 해주시겠습니다. 큰 박수로 환영해 주시기 바랍니다.
Good morning, ladies and gentlemen. It's a great pleasure being here, and the music was really very nice that was introducing me. Intellectual property law is more harmonized worldwide than almost any other field of law. This is to quite some extent due to international agreements, like the Paris Convention for the Protection of Industrial Property, the Patent Cooperation Treaty, and the TRIPS Agreement. But it is also due to the fact that there is a constant global exchange of knowledge and views between the institutions that are responsible for putting IP law into practice, like patent offices, judicial authorities, the bar associations, and associations of patent attorneys. One of the most recognized fora of this global exchange of knowledge and views in IP law is the International IP Court Conference organized by the Korea IP High Court in Daejeon. The International IP Court Conference started in 2015. Since then, it gets together every year renowned IP judges and practitioners to learn from each other's experience in the application of IP law. Each of the conferences has a special overarching topic, and the panels deal with current issues of substantive, procedural, and enforcement IP law. This way, participants get most valuable insights on essential and current topics in IP law and can discuss and further develop certain aspects of it. I personally had the honor and pleasure to participate in the first conference of this series in 2015 and experienced an outstanding hospitality by the Korean organizers. The open and constructive atmosphere between all participants during the conference made a lasting impression on me. Being back 8 years later, I'm excited to continue the dialogue and knowledge exchange over the next 2 days. I wish us all a productive but also entertaining time. So let's learn, debate, and have fun. Don't forget the fun. Thank you very much for your attention.
네, 좋은 말씀 감사드립니다. 다시 한번 큰 박수 부탁드리겠습니다. 다음으로 백만기 국가지식재산위원회 공동위원장님의 축사가 있겠습니다. 백만기 위원장님은 현재 국가지식재산위원회에서 우리나라 지식재산 제도의 발전과 지식재산권 보호를 위한 지식재산 소송의 관할 확대 및 관할 집중 등의 논의를 이끌고 계십니다. 큰 박수로 환영해 주시기 바랍니다.
안녕하십니까. 방금 소개받은 국가지식재산위원회 위원장 백만기입니다. 먼저 올해로 9번째를 맞이한 국제 특허법원 콘퍼런스 개최를 진심으로 축하드립니다. 특히 뜻깊은 자리를 마련해 주신 김영석 특허법원 법원장님과 특허법원의 판사님들께 감사의 말씀을 드립니다. 아울러 오늘 국내외의 IP 전문 판사님들과 전문가 여러분들과 함께하게 되어서 영광으로 생각합니다. 특허법원이 1998년도에 설립된 이후에 우리나라의 지식재산 생태계는 본격적으로 선진적인 모습을 갖추게 되었던 것으로 기억합니다. 2011년에 우리나라에서 지식재산 기본법이 제정되고 국가지식재산위원회가 설치된 이후에 2016년에는 무효와 침해소송 사건을 특허법원으로 관할 집중하게 되면서 특허법원의 위상을 새롭게 할 수 있었습니다. 제 자신은 1978년 특허청 발족 직후부터 특허심사관으로 임명되면서 지식재산과 인연을 맺게 되었는데 IP 전문가의 한 사람으로서 특히 남다른 기대와 애정을 가지고 특허법원이 글로벌 IP5 체제에서 IP 전문법원으로 크게 발전하는 모습을 지켜봐 왔습니다. 국가지식재산위원회는 2012년부터 국가지식재산 5개년 계획을 수립하고 3차 계획의 시작연도인 2022년부터는 지식재산 기반 글로벌 혁신 선도국가라는 비전을 가지고 디지털 대전환 시대의 핵심 IP의 활용, 촉진 등 5대 추진 전략과 16대 추진 과제를 진행하고 있습니다. 그 중에서 IP소송의 전문성 강화는 UPC의 출범과 함께 변화하는 글로벌 환경에서 반드시 추진해야 될 과제로 보고 우리 위원회 산하에 IP소송 전문화 특별위원회를 설치하여 사법부, 행정부, 산업계, IP 전문가 등 참여하에 연말을 목표로 실현 가능한 대안을 준비 중에 있습니다. 아무쪼록 이를 통해서 특허법원이 글로벌 IP 생태계에서 또다시 한 단계 도약할 수 있는 계기가 되기를 희망합니다. 이번 9회 컨퍼런스의 주제가 Quote, IP and New Perspectives 이듯이 사실 지금 한국이 처해 있는 경제사회적 환경이야말로 IP에 대한 새로운 시각을 필요로 하고 있다고 생각합니다. 우리나라는 지난 1962년 경제개발계획이 본격적으로 추진되면서 섬유산업과 같은 낮은 임금에 의존한 경제성장 모델을 거쳐서 중화공업 중심으로 투자주도형 성장을 이루어냈습니다. 하지만 IMF 위기를 거치면서 본격적으로 기술 혁신과 지식의 축적이 경제 성장의 중심축을 이루는 성장 체제가 마련되었습니다. 2022년 기준으로 본다면 국가 전체의 GDP 대비 R&D 투자는 세계 2위로 급증하였으며 인구 규모에 대비한 내국인의 특허 출원 건수는 세계 1위가 되었습니다. 명실공히 우리는 혁신 주도형 국가가 된 것입니다. 여러 산업 분야에서 패스트 팔로워, 빠른 추격자 입장에서 이제는 퍼스트 무버, 시장 선도자의 입장으로 바뀌었습니다. 반도체와 디스플레이 그리고 배터리 분야가 그러한 첨단 산업의 좋은 예가 되겠습니다. 따라서 한국 기업의 R&D 투자는 시장에서 제대로 인정받는 특허로 보호되어야 지속적인 성장이 담보될 수 있습니다. 그래서 제가 보는 IP의 새로운 시각이라고 하는 것은 소위 시장 선도자에 부합하는 마인드셋의 변화가 일어나야 되겠다는 것이고 산업계와 정부, 법조계, 학계 모두가 이를 자각해야 한다고 생각합니다. 과거의 산업정책 모델은 정부가 승자를 선택해서 집중 지원하는 소위 피킹 더 위너 모델이었다고 한다면 이제는 혁신의 승자를 IP 쟁송에서 가려주는 것이 바로 혁신주도형 성장체제의 산업정책이라고 하겠습니다. 다시 말하면 WTO 출범 이전에는 산업부의 산업정책 담당자가 결정해주던 승자 결정 방식이 이제는 특허법원의 판사님들에 의해서 결정되는 방식으로 바뀌었다는 것입니다. IP 전문법원의 시대적인 역할은 글로벌 혁신의 경쟁 무대에서 진정한 혁신의 승자를 가려주는 것이므로 국제적인 조화 또한 점점 중요해지고 있다고 생각합니다. 이러한 관점에서 이번 컨퍼런스는 국내외의 저명한 IP 전문가들이 모여서 소통하고 교류하면서 공통 분모를 찾아가는 여정이라고 생각합니다. 아무쪼록 이번 컨퍼런스가 우리 모두에게 귀중한 지식 공유의 기회가 되기를 바라며 국제적으로 의미 있는 학술 대회로 계속 자리매김하게 되기를 바랍니다. 감사합니다.
네, 좋은 말씀 감사합니다. 다시 한번 큰 박수 부탁드립니다. 네, 이것으로 2023 국제특허법원 컨퍼런스 개회식을 마치겠습니다. 1세션을 시작하기 전에 내빈분들과 국내외 세션 참가자분들 사진 촬영이 있겠습니다. 모두 앞으로 나와주시기 바랍니다. We are going to have a small photo time. Participants from other countries, please come forward. Thank you. 원문과 영문 PDF 파일로 제작되어 있습니다. 태블릿이나 모바일 디바이스로 직접 다운로드 받으실 수 있습니다. 그걸로 하게 됐습니다.
이게 다시 또 바꿨어요. 내려온 거야 그렇게? 삐삐삐 울릴 수도 있는데 중간에 끊어갔어요.
세션 준비하시는 분들께서는 마이크를 컨트롤하지 않으셔도 되겠습니다. 네, 지금부터 2023 국제특허법원 콘퍼런스 1세션을 시작하겠습니다. 1세션은 각국의 IP소송 관할과 IP 전문법원의 운영 현황에 대해서 살펴보겠습니다. 1세션의 진행은 구자헌 특허법원 고법판사께서 맡아주시겠습니다. 큰 박수 부탁드리겠습니다.
네, 안녕하십니까. 1세션 진행을 맡은 구자헌 판사입니다. IP 소송은 기술과 법에 관한 전문 지식과 상당한 경험이 필요하고 판결이 산업에 미치는 영향을 고려할 때 전문화가 더욱 요구됩니다. 1세션에서는 각국에서 채택하고 있는 전문화 제도를 공유하고 바람직한 제도가 무엇인지 논의하는 시간을 마련하였습니다. 먼저 세션에 참여하시는 패널분들을 패밀리네임의 알파벳 순서에 따라 소개해드리겠습니다. 큰 박수로 환영해 주시기 바랍니다. 먼저 미국 애리조나 연방지방법원의 데이비드 캠벨 판사님이십니다. 영국 IPC의 리차드 헤이콘 판사님이십니다. 일본 지적재산 고등재판소의 히로아키 이마이 판사님이십니다. 한국 특허법원의 이지영 판사님이십니다. 특허법원의 한지윤 판사님이십니다. 네. 1세션은 각국의 지식재산 전문법원 제도, 관할, 지식재산 전문법관 제도, 기술조사관 로컬록 제도 등의 활용 현황, 전문심리위원 전문가 정인, 제3자 의견 진술 제도 등을 통한 전문화를 논의할 예정입니다. 5개 세부 주제에 대해 미리 각국의 패널분들에게 질문을 전달하였고 패널분들께서는 아주 상세한 답변을 보내주셨습니다. 질문과 답변은 자료집에 모두 포함되어 있고 오늘 질문과 토론은 자료집에 기재된 순서로 진행됩니다. 다만 원활한 행사 진행과 토론의 효율을 높이기 위해 세세한 질문은 모두 통합하여 각 세부 주제별로 하나의 질문만 드리도록 하겠습니다. 패널 분들께서는 패밀리 네임의 알파벳 순서로 답변해 주시기 바랍니다. 캠벨 판사님, 헤이콘 판사님, 이마이 판사님, 그리고 한국 판사님들 순위 되겠습니다. 먼저 첫 번째 토픽에 대해서 보면은 첫 번째 토픽은 IP 소송 전문 법원 제도를 다뤄보겠습니다. 패널 분들께서는 기국에 IP 소송 전문 법원이 있는지 있다면 구성 및 업무 영역을 소개해 주시고 전문 법원 내 재판부나 법관별로 담당 분야를 달리 정하고 있는지도 함께 알려주시면 감사하겠습니다. 각 4분 내로 발표해 주시면 되겠습니다. 먼저 미국의 데이비드 캠벨 판사님 부탁드리겠습니다.
Good morning. It's a pleasure to be with all of you. Can you hear okay? Okay. I am delighted to be with you. I am a federal judge from Arizona in the United States. I also chair the International Judicial Relations Committee for the federal courts in the United States. And in that capacity, I extend to you the greetings of federal judges from the United States. We are privileged to be able to participate in this program and to be invited to learn from so many experts here. The answer to the question of whether we have specialized IP courts in the United States is partially. Let me give you a bit of background. Traditionally, we are general jurisdiction courts in both the federal courts and the state courts of the United States. Federal district judges, which is the first instance trial court of the national court of the federal court, are appointed for life by the President, confirmed by the United States Senate, and they hear all categories of federal cases in the United States. So they hear criminal cases, civil cases, administrative cases, IP cases. There is no specialization. The decisions of these judges often is made with a jury trial where a jury decides the most central issues, and that's a constitutional right in our country. So of necessity, the Constitution dictates that we not have specialized courts in the first instance. The decisions of these federal district courts get appealed to regional circuit courts of appeals. There are 12 of them in the United States. I'm in the 9th Circuit, which is the western part of the United States. Judge Cheng is in the 7th Circuit, which is in the middle part of the United States. There are, however, against this backdrop of generalized courts, two areas in which we have IP specialization in our courts. The first is that in 1982, the United States Congress established a specialized appellate court for patent cases. That is known as the United States Court of Appeals for the Federal Circuit. It is the only specialized federal court of appeals and the only federal court of appeals that is not based on geography, but is based on subject matter. The Federal Circuit sits in Washington, D.C. It consists of 12 judges. It was created to provide expertise in patent matters and to establish national uniformity in the decision of patent cases. And so since 1982, that Federal Circuit has established a large body of case law on patent issues in the United States on matters such as how to interpret claims, how to determine infringement, how invalidity of a patent can be established, and what damages can be awarded in a patent case. The judges on the Federal Circuit Court of Appeals do not specialize in particular subject matter areas. They sit in panels of 3, and the cases are assigned to them randomly. We don't have specialized divisions within the Federal Circuit. A party dissatisfied with a 3-panel decision can appeal to the entire Federal Circuit, but that sort of appeal is rarely granted. And the Supreme Court of the United States can review the decisions of the Federal Circuit, although it doesn't do so very often because it recognizes that those are the specialist judges. That's my wife's phone telling me my time is up. There's a second category I will just mention of, it was very good, Stacy. There's a second category of specialized judges who are in administrative agencies of the United States, the Patent and Trademark Office, the International Trade Commission. I'll say more about those in a minute.
네, 감사합니다. 데이비드 캠벨 판사님께서 많은 준비를 해주셨는데 질문 시간이 너무 짧았던 것 같습니다. 다음으로 영국의 리차드 헤이컨 판사님께 부탁드리겠습니다.
Thank you very much. It's a great pleasure to be here. My second time at a conference, an IP conference in Korea. And my experience on both occasions is how well they've been organized and how useful I think they've been to all participants. And I expect this one to be exactly the same. I'm going to be speaking about the system in England and Wales. In the United Kingdom, there are 4 separate jurisdictions: England and Wales, Scotland, and Scotland and Northern Ireland. There's only one United Kingdom court, and that's the Supreme Court. So I'll be just discussing the system in England and Wales, or sometimes for short, England. Civil procedure in England is divided into 2 types of court: the High Court for more complex cases and the County Court. Almost all IP litigation happens in the High Court, so I'll be talking just about that. Are there specialized courts? Yes, we have specialized courts and specialized judges. We divide types of IP into 2 broad groups. There's one group which contains patents and registered designs, and it's in respect of those that we have specialized courts. They also deal with semiconductor topography rights and plant variety rights, but those last 2 hardly ever litigate, so I will say nothing about them. The more general IP cases, trademarks, copyright, unregistered design, database rights, performance rights, and trade secrets, they're treated separately. There are no specialized courts for those except one, and that's the one I sit in, and I'll say something about that in just a moment. So for patents and registered designs, there are 3 courts. There's the Patents Court. These are all in the High Court. These are Patents Court, which deals with more complex cases, usually substantial litigation between multinationals. There's the Intellectual Property Enterprise Court, IPEC, which deals with less complex cases and is designed to conduct litigation in IP more quickly and at less cost. Also, there are the general courts. The specialized courts have specialized judges. They all have been either barristers or solicitors who specialized in IP for their careers, like me, and they are selected from those people. There is also another court which deals with very simple cases, usually for litigants without professional representation, which is called the Small Claims Court. That doesn't do patents or registered designs, but it does all the other types of IP. There are 2 permanent judges in the Patents Court, 2 specialist judges. There's 1 permanent judge in IPEC, that's myself, but both courts have other judges who sit from time to time. For the general IP cases, that's to say trademark, copyright, and so on, those can be heard by judges who aren't specialists. It's a matter of chance whether a case goes to a specialist judge or a non-specialist judge. Specialist judges like myself sit not just in patents and registered designs. We do all kinds of IP. So if you've got a general IP case, you may get a specialist judge and you may not. Litigants are not allowed to present their cases in a language other than English. But in Wales, you're allowed to present your case in Welsh. Apart from that, everything has to happen in English. And that's broadly the system that we use in England to conduct IP cases. Thank you.
감사합니다. 다음으로 일본의 히로아키 이마이 판사님 부탁드리겠습니다.
Thank you. Okay. Ladies and gentlemen, thank you very much for me to. This is my great honor to participate in this conference. IP specialized code. Do you have specialized code in Japan? Asking. My answer is yes. IP High Court is a specialized court directed on to the IPR-related cases. And general cases, including patent infringement cases, are first tried in a district court. The judgment of the district court can be appealed to a high court and then to the Supreme Court. At first instance, two district courts have exclusive jurisdiction over patent cases. In Japan, claims of patent infringement occurring in Eastern Japan are subject to the exclusive jurisdiction of the Tokyo District Court. And those occurring in Western Japan are subject to the exclusive jurisdiction of the Osaka District Court. The Tokyo District Court has 4 special divisions, and the Osaka District Court has 2 special divisions for intellectual property matters. Appeals from district courts in patent infringement cases come under the exclusive jurisdiction of the Intellectual Property High Court, IP High Court. It was established in April 2005 as a special high court dealing with IP matters only. The IP High Court has 4 general divisions and 1 special division where a panel of 5 judges hears and decide cases. Final appeals from the IP High Court are filed with the Supreme Court. Supreme Court cases are usually heard by one of the 3 petty benches composed of 5 justices. And foreign language, allowing the foreign language question. The answer is no. Courts Act Article 74 stated that Japanese is the language used in court, so we don't have any foreign language divisions. Thank you. That's all my experience.
한국의 한지윤 판사님 부탁드립니다.
예, 저도 이런 자리에서 기빈 여러분들 모시고 또 저희 나라 제도에 대해서 잠깐 간략하게 설명드릴 수 있어서 기쁘게 생각합니다. 대한민국에서 지식재산권 관련 사건은 일단 청구의 내용과 권리의 종류에 따라서 특허심판원, 특허법원 또는 민사소송법에 따라 정해진 몇 개 지정된 법원에서 처리를 하고 있습니다. 다만 특허법원은 지식재산권 관련 사건을 전문적으로 처리하는 법원으로서 1998년 설립됐습니다. 특허법원은 이례적으로 전국을 관할하고 있고요. 특허법원의 심결에 대한 취소 소송의 제1심과 특허권 등에 관한 민사 본안 사건의 항소심을 전담하고 있습니다. 저희 특허법원은 총 5개의 재판부로 구성이 되어 있습니다. 재판부 또는 법관별로 담당 업무 분야가 특정이 되어 있는 것은 아니고요. 3인의 법관으로 이루어진 하나의 재판부에서 심결 취소 소송과 민사 항소 사건을 함께 처리하고 있습니다. 상표, 특허 등의 권리의 유형별 또는 어떤 기술의 영역별로 다른 사건, 이렇게 일정한 사건만을 전담하는 것은 아닙니다. 그리고 질문 중에 외국어 사용에 관한 질문이 있었는데요. 원칙적으로 대한민국에서 모든 소송 절차는 한국어로 진행이 됩니다. 다만 당사자를 외국인으로 하는 지식분쟁 사건이 점차 늘어나고 있는 추세이기 때문에 지금 특허법원과 서울중앙지방법원에 국제사건을 전담하는 국제재판부가 설치되었습니다. 그 당사자 일방이 외국인이거나 주요 증거조사가 외국어로 진행이 될 필요가 있을 때 양 당사자들이 동의를 하면 법원의 허가를 얻어서 외국어로 법정에서 변론을 할 수가 있습니다. 저희가 이러한 사건을 국제사건이라고 부르는데요. 앞서 말씀드렸던 특허법원에서는 5개 재판부 중에 일부가 국제재판부로 지정돼서 국제사건을 처리하고 있습니다. 허용되는 외국어는 원칙적으로 영어인데 당사자의 신청에 따라서 영어 외에 다른 언어가 사용이 될 수가 있습니다. 다만 법원은 그 외국어 변론으로 인해서 그 재판이 현저히 지연될 것으로 예상되는 경우에는 허가를 하지 않을 수 있고 이미 이루어진 허가를 취소를 할 수도 있습니다. 이상입니다.
이제 논의를 이어서 이번에는 토픽 2로 관할에 대해 살펴보겠습니다. 패널 분들께서는 특허권, 상표권, 디자인권의 등록 무효 및 취소, 등록 거절, 침해 금지 명령, 가처분 사건의 관할 법원을 소개하여 주시고 신급별로도 상세히 설명하여 주시기 바랍니다. 마찬가지로 4분 내에 발표 부탁드리겠습니다. 먼저 데이비드 캠벨 판사님 부탁드립니다.
Thank you. I think the easiest way for me to explain jurisdiction would be to go by subject matter for different categories of cases in the United States. Issues of patent registration or patent revocation or cancellation commonly are heard before, let me start that over. Issues of patent registration or patent cancellation or revocation are commonly heard before an administrative agency, the United States Patent and Trademark Office, that has about 200 administrative law judges within the agency to hear these matters. Decisions by that agency get appealed to the Federal Circuit that I mentioned a moment ago that specializes in patent matters. Cases that involve patent infringement typically are heard in federal district court before non-specialized judges and juries. And those decisions also get appealed to the Federal Circuit. So all patent cases from all parts of the United States go to the Federal Circuit. There is also another administrative agency that can hear infringement issues. That is the International Trade Commission that addresses allegations that a product being imported into the United States infringes a United States patent. And the ITC, as it is called, also has administrative judges who hear those patent matters. Their decisions get appealed to the Federal Circuit. With respect to copyright cases, a claim for copyright infringement is brought in the general jurisdiction federal district courts before non-specialized judges and juries. And the appeal of decisions in copyright cases goes to the regional circuit courts of appeal, not to the Federal Circuit. So the appeal goes to non-specialized judges as well. With respect to trademark matters, those are generally governed by a federal statute, the Lanham Act as it is called. There is a trademark trial and appeals board within the United States Patent and Trademark Office that will hear disputes about whether or not a trademark should be registered, and their decisions are appealed to the Federal Circuit. But claims of trademark infringement or related unfair competition are heard in the general jurisdiction district courts, and those decisions are appealed to the regional courts of appeals. Finally, with respect to trade secrets, trade secret law is often a matter of state law, can be heard by state court judges, but in the federal system, those trademark claims are heard by the general jurisdiction district courts, and appeals are made to the regional circuit courts of appeals. So as you can see, IP cases go in a variety of different directions in the United States and often are heard by non-specialized judges. The last question that was asked of us is whether the United States is contemplating further specialization. I think the general answer is no, because of our constitutional right to a jury trial in the first instance, although we did do a 10-year test of more specialized patent courts through what we call the Patent Pilot Project that I can describe later. Thank you.
네, 감사합니다. 다음으로 영국의 리차드 헤이쿤 판사님 부탁드립니다.
Thank you. Jurisdiction in England and Wales depends on the division in subject matter I mentioned a moment ago. On the one hand, patents and registered designs, which are heard by the specialist courts, and on the other, the more general IP, copyright, trademark, trade secrets, unregistered designs. Those are heard by the more general courts. So beginning with patents and registered designs, there are 3 tribunals which may hear a case. One is the Patents Court for large litigation between multinationals. The second is IPEC, which hears smaller cases and has a much more streamlined approach. The third tribunal is the UK Intellectual Property Office, which has control over the prosecution and grant of patents and registered designs. You can bring an action for infringement there, but it has no power to order an injunction, so it very rarely happens. But it's not unusual for an application in the UK Intellectual Property Office to be made for revocation of a patent or registered design. Where there are the same proceedings in the UK Intellectual Property Office and in a court, the UK Property Office will always decline jurisdiction, and it goes to the court to avoid 2 sets of proceedings being conducted at the same time. So what about the more general IP cases? Well, those are heard by, as I mentioned a moment ago, non-specialist judges or sometimes specialist judges, either in the General High Court or in IPEC, or sometimes in the Intellectual Property Office. And there's a 4th place you can bring proceedings for those, and that's in the Small Claims Division, which is for cases where damages are limited to £10,000. Usually they are not professionally represented, photographers and so on. So how do you pick which tribunal to bring your case? Well, the claimant, the plaintiff, gets to choose. They can pick whichever they prefer. A large multinational will always pick the Patents Court or the General High Court if it's not a patents case. And smaller litigants will pick a smaller court. But either party can always apply to transfer, and those applications happen quite often to move up or down or whichever direction. So far as appeals are concerned, appeals from the Patents Court, the General High Court, and from IPEC all go to the Court of Appeal. Appeals from the small claims go to IPEC. Appeals from the UK Intellectual Property Office go to either the Patents Court, if it's a patent or registered design case, or they go to the General High Court. You can appeal from the Court of Appeal to the Supreme Court, but only with permission of the Supreme Court. And the Supreme Court will only give permission if it's an appeal involving a point of law which is of general public interest. And they hear, I would guess, no more than 2 or 3 IP cases each year. So it's quite unusual to get an appeal to go that far. Thank you.
루아키 이마이 판사님 부탁드리겠습니다.
Okay. Our jurisdiction of IP litigation, I can say in one word, we have the bifurcation system, like German system and Korean system. So if you cannot understand my explanation, you can understand after me her explanation. You can understand the bifurcation system. So, and litigation for the IP infringement starts from the district court. I have already explained, and I will explain this time the litigation concerning invalidity. Patent law grants the Japan Patent Office the authority to determine patent invalidity. To invalidate a patent, a person must either file a trial with the JPO for invalidation or filed an opposition with the JPO for cancellation. In a patent infringement case, a court can also deny enforcement of the patent at issue if there are grounds for invalidation. However, a court judgment on patent invalidity under Article 104/3 is only binding on a patent to the particular cases, and the JPO still has the authority to declare the general invalidity of patents through a trial for invalidation. Any suit against appeal or trial decisions made by JPO is under the executive exclusive jurisdiction as a revocation action of IP High Court. Although the existence of two different procedural tracks for patent invalidity action raises the issue of how to resolve contradictions between the decisions of the courts and JPO. The IP High Court is expected to apply consistent interpretation as an appellate court for both infringement litigation and invalidity trials. Among IP-related civil cases, so-called non-technology related actions relating to design rights, trademark rights, the rights of authors, publication rights, and so on. Infringement of business interests caused by unfair competition are also that. They are under the jurisdiction of 50 district courts located throughout Japan, while the Tokyo District Court or the Osaka District Court concurrently has non-exclusive jurisdiction. Any appeal against decisions of those courts will be under the jurisdiction of one of the 8 high courts located throughout Japan that correspond to the district court in charge of the first instance. The Intellectual Property High Court will be in charge of any case that is under the jurisdiction of the Tokyo High Court. Okay, thank you.
네, 감사합니다. 다음으로 한국의 한지윤 판사님 부탁드립니다.
지식재산권 관련 사건의 청구의 내용과 권리 종류에 따라서 관할을 간략히 설명드리도록 하겠습니다. 먼저 특허권이나 상표권, 디자인권 등의 등록된 권리의 효력과 범위에 관하여 다투는 경우에는 먼저 당사자가 특허 심판원의 무효 심판 또는 그 거절 결정에 대한 불복 심판, 권리 범위 확인 심판을 청구를 해야 합니다. 그 특허 심판원은 특허청장에 소속된 행정 심판 기관에 해당하고요. 특허 심판원의 심결에 불복하려면 법원에 해당 심결에 대한 취소 소송을 제기해야 되는데 심결 취소 소송은 저희 특허법원에 관할이 있습니다. 다음으로 그 침해소송에 대해서 말씀을 드리겠는데요. 이제 보통 손해배상 청구와 그 금지 청구 등을 생각을 해보시면 되겠는데 그 앞서 말씀드렸던 특허권, 디자인권 등의 그런 등록된 권리의 경우에는 그 관할이 집중됩니다. 이러한 소를 제기하는 경우에 제1심은 서울중앙지방법원, 수원, 대전, 대구, 광주, 부산지방법원 중에 하나에 전속 관할이 있습니다. 다만 당사자의 선택에 따라서 서울중앙지방법원에도 중복 관할이 인정이 됩니다. 그리고 그 항소심은 아까 말씀드렸다시피 특허법원에 전속 관할이 있습니다. 다만 그 특허권 등을 제외한 지식재산권의 경우 이제 대표적으로 저작권을 생각을 해볼 수 있는데요. 이러한 경우에는 그 관할 집중이 이루어지지 않아서 일반 민사사건에서와 같이 민사소송법에 의해서 관할이 정해집니다. 다만 이에 더해서 해당 법원 소재지를 관할하는 고등법원이 있는 곳의 지방법원, 그 아까 말씀드렸던 그 6개 지방법원이 해당이 됩니다. 그러한 법원의 중복 관할이 인정이 되고 그 항소심은 제1심 법원 소재지를 관할하는 고등법원에서 처리를 하게 됩니다. 마지막으로 가처분 사건의 경우에는 권리 종류와 무관하게 관할이 집중이 되지 않습니다. 그래서 민사 가처분 사건은 그 일반 민사소송법에 따라서 관할이 결정이 되고요. 지금 현재 국내에서 형사사건과 부정경쟁방지법 위반 사건의 경우에는 지금 현재 관할이 집중되지는 않지만 이들 사건에 대한 관할 집중에 관한 논의가 이루어지는 것으로 알고 있습니다. 이상입니다.
네, 감사합니다. 다음으로 토픽 3으로 전문 법관 제도에 대해서 알아보겠습니다. 법원의 전문화 이외에도 사건을 맡은 법관이 기술에 대한 이해가 있어야 재판의 효율성이 높아지고 또 재판에 대한 신뢰도 높아질 것으로 생각이 됩니다. 기하의 국가에 IP 전문 법관 제도가 있다면 선발 기준, 자격 요건, 근무 형태, 현황 등을 포함하여 자세히 소개하여 주시기 바랍니다. 또 전문 법관 제도를 두지 않는 국가라면 IP 소송에서 요구되는 법관의 전문성을 어떻게 확보하는지, 별도의 법관 교육 프로그램을 운영하는지 알려주시기 바라고요. 또 기하가 생각하는 전문 법관 제도의 장점과 단점도 밝혀주시기 바랍니다. 그리고 캠벨 판사님께는 패턴 파일럿 프로그램에 대한 소개도 부탁드립니다. 먼저 미국의 데이비드 캠벨 판사님 부탁드리겠습니다.
Thank you. The two categories that I mentioned a moment ago, the federal circuits and the administrative agencies that have specialized judges within them, let me just say a word about the qualifications of those judges. Federal circuit judges, like other federal judges in the United States, are appointed by the President, confirmed by the Senate, and there is no requirement for judges going on the federal circuit to have a particular background in technology or science or patent-related issues. However, as you can imagine, often that's what a president looks to in appointing judges to that court. So many of them have that sort of background qualification, and they acquire expertise when they are on the court. The administrative judges within the Patent Trial and Appeal Board and the Trademark Trial and Appeal Board in those agencies that I mentioned are appointed by the Secretary of Commerce. They must have a college degree in engineering or a scientific discipline and at least 10 years of IP experience in order to be appointed to those positions. With respect to the rest of us who hear cases who are generalists, there are resources and training programs that can help us become more proficient in IP law. There is an arm of the federal courts called the Federal Judicial Center that is the training organization for federal judges. And the Federal Judicial Center holds a program every year on patent law and litigation that is available for judges to use. The Federal Judicial Center publishes a very comprehensive case management guide for patent cases that generalist judges can use when they are handling patent cases. And there are some courts in the United States that hear more patent cases than others just by virtue of where they are located. And they've promulgated local rules and practices that are often used by other judges around the country in patent matters. Let me say a word about this patent pilot program that I was specifically asked about. This was a pilot program established by Congress that ran from 2011 to 2021. The idea was to give some general jurisdiction district judges more experience in patent cases and see what effect that had on their efficiency, on the consistency of their decisions, the reversal rate when decisions went to the federal circuit. There are 94 federal districts in the United States, and 13 of them were put in this patent pilot program. And in those districts, judges could volunteer to be a patent pilot judge, in which case they would keep all of the patent cases that were assigned to them, and the non-patent pilot judges in their district could send them patent cases, so they got a heavier dose of patent cases. That practice was followed for 10 years, and the Federal Judicial Center that I mentioned a minute ago did a very thorough study of what effect it had on the cases that were handled by these pilot program judges who had more patent cases versus other generalists who did not. The finding of the study was somewhat mixed. The Federal Judicial Center found that patent cases moved faster in front of the judges who had this enhanced patent experience than in front of generalist judges. So that was beneficial. This study found that the decisions of the pilot judges were not appealed as often as the decisions of the non-pilot judges, suggesting that there was more dissatisfaction with the more generalist judges, although that wasn't a huge difference. Interestingly, though, in the cases that went from the pilot judges to the Federal Circuit and the generalist judges to the Federal Circuit, there was no difference in reversal rate. The reversal rate was the same. So I think the result of all of this is it hasn't resulted in a strong move to create more specialized judges, although time will tell. Maybe some will have that feeling. In terms of the advantages, you all understand the advantages of specialist judges. I do think there is some benefit that comes from non-specialized judges in that they can bring original thinking and principles from other areas of the law that often bear on cases that are involving IP.
네, 감사합니다. 다음으로 영국의 리차드 헤이콘 판사님 부탁드립니다.
Thank you. So far as the selection criteria are concerned for specialist judges, as I mentioned earlier, they're all drawn from practitioners, barristers and solicitors who have practiced in IP law previously. So they arrive at the bench with a very good knowledge of IP law. Most IP litigation is still in London, although there's an increasing tendency to try and move it outside London. But one of the difficulties is all the specializations tend to be in London, so there's resistance to doing that. What about the advantages and disadvantages of having specialized IP judges? Well, the advantages we've found, I think, reflect what David has just been saying about the pilot. The advantages are that the procedure leading up to the trial and the trial itself tend to be conducted more quickly and more efficiently if the trial judge is an expert, for two reasons. One, because he or she is familiar with the law, and two, because they tend to have a technical background. All the full-time specialist IP judges sitting at the moment have a science background. The judges who hear more general IP, trademarks, copyright, and so on, the majority have no science background at all. But I think it matters less than when you're hearing, for example, a patents case. But there's another reason, there's another advantage in having specialized judges which applies in the court of which I'm presiding judge. I sit in the patents court quite a lot, but I'm presiding judge of IPEC, which is designed to give less costly and more rapid access to justice for small and medium-sized enterprises. And that's only possible if the judge, in controlling the case, can make rulings about limiting the amount of evidence that can be used, the amount of documents that are going to be disclosed, and I even have the unusual power of being able to disallow certain arguments that a party wants to run, so that the case is focused down to the essentials of the case, and then it can be conducted more quickly, more efficiently, and at less expense. Now that is only possible if the judge making those rulings knows quite a lot about IP law, because if you don't, then you're faced with arguments from advocates that this or that argument is absolutely essential to their case. And unless you know quite a lot about IP law, it's difficult to give a reliable ruling disallowing them to run that case or limiting the amount of evidence. So that's one of the advantages of having specialist IP judges. Disadvantages? Well, I think when I used to practice as a barrister before I became a judge, I used to appear before judges who were not specialists in IP law. And occasionally I found it quite refreshing that they brought a new insight or a new approach to an aspect of IP law which had just become, everybody assumed that this was the correct approach, and sometimes it's a good idea to have a fresh perspective. And that can be useful. Finally, are there any education training programs? Yes, we have training programs, but they are not specifically designed for IP for the most part. They are more general judges training programs. Thank you.
네, 감사합니다. 다음으로 히로아키 이마이 판사님 부탁드립니다.
The question of the specialized IP judges, my answer is no. In Japan, the judges are legal experts appointed from among those who have passed a bar exam and completed the required legal apprenticeship in principle, but not specialized for the IP-related cases. So, our judicial research officials and technical advisors who have specialized knowledge on technical fields assist judges. I will explain later. Concerning about the advantages and disadvantages, normally said the advantages of the specialized IP judges are the expertise and the specialty, and there's no doubt about it. On the other hand, IP-related laws are part of the civil law system. General laws, including the Civil Code and the Civil Code of Civil Procedure and the Civil Execution Act, are also relevant to IPR enforcement in areas in which IPR has no special rule. For example, conflict from the trade secret acquired through collaborative research will be treated primarily as a breach of contract or tort. So, in my personal opinion, there will be disadvantages of specialized IP judge if he or she does not have some knowledge, if as a judge who have not enough experience in the civil law areas. And the educational programs for IP judges are now concerning about it. Judges who are appointed to the IP divisions are frequently transferred back to one of the IP special divisions and the IP court to further develop their IP-related law and technology experience. For my personal experience, I am here, I'm the judge of the IP High Court this April, but this is my second time as an IP High Court judge. I always have 2 times experience as the IP District Court judge at Tokyo District Court. Our Supreme Court, every year, a Supreme Court dispatches judges to the foreign institute and universities to learn IP laws and the foreign practices. This is our program. Thank you.
네, 감사합니다. 다음으로 한국특허법원의 이지영 판사님께 프레젠테이션 부탁드립니다.
예, 특허법원은 지식재산 전문 법원이긴 하지만 한국에서는 지식재산 전문법관이라는 명칭을 사용하는 제도는 없습니다. 따라서 선발 기준이나 자격 조건도 명시적인 것은 없다고 볼 수 있습니다. 현재 특허법원을 구성하는 법관들은 법원장님을 제외하고는 다음과 같이 구성되어 있습니다. 보시다시피 먼저 이제 판사는 법관 경력 15년 차 미만의 법관들로 지방법원에서 근무를 하다 순환 인사의 일환으로 특허법원에 3년 동안 근무를 하시고 다시 지방법원 판사로 돌아가시거나 대법원 재판연구관 등으로 또 보직이 변경됩니다. 그리고 특허법원에 근무하는 고등법원 판사의 경우에는 모두 법관 경력 15년 이상인데 그중 일부는 서울 고등법원에서 고등법원 판사로 선발된 이후 10년 이상 근무한 다음에 순환 근무의 일환으로 특허법원으로 다시 오십니다. 오셔서 3년 정도 근무하신 이후에 다시 또 서울 고등법원 등으로 복귀를 하십니다. 그리고 마지막 한 그룹으로는 저를 포함한 일부 고등법원 판사들이 있는데요. 지방법원 부장판사 혹은 부장판사가 될 시기에 특허법원에서 장기 근무를 하는 기회를 얻게 되는 경우입니다. 한국에서 특허법원, 지식재산 소송 법관의 전문성이라는 것은 대체로 전담재판부나 특허법원에서의 이전 근무 경력이라든지 혹은 법관이 되기 전에 IP 전문 변호사 또는 변리사로서의 어떤 경력 그리고 개인적으로 가지고 있는 어떤 이공학 전공 여부 또는 지식재산권법 전공 여부 등을 통해서 확보를 할 수 있는 것으로 보이는데요. 지금 특허법원 판사님들 중에서도 일단은 모두 다 법률 전문가들이시고 그 중에서 일부는 대학원 등에서 지식재산권을 전공하신 분도 계시고 또 일부는 약 한 40% 이상인 것으로 확인이 됐습니다만 대학이나 대학원에서 이공학을 전공하신 분들도 있습니다. 그래서 기계나 전기전자, 수학, 약학, 컴퓨터 사이언스, 수의학까지 다양한 분야를 전공하신 판사님들이 근무를 하고 계십니다. 전문법관 제도 자체는 전문성을 기반으로 한다면 신속한 결론 도출은 가장 큰 장점이 될 수는 있을 것 같습니다. 좀 전에 캠벨 판사님께서 말씀하셨던 그 PPP 프로젝트의 결과와도 비슷한 것 같습니다. 다만 이게 너무 전문성에 치중을 하다 보면 다른 법률과의 조화로운 해석을 놓치지 않도록 늘 조심을 해야 된다라는 점을 좀 생각하고 있다고 말씀드릴 수 있습니다. 그리고 법관 교육 프로그램에 대해서 말씀을 드리자면 일단 대법원 산하 지식재산권법을 연구하는 법관들의 연구 모임이 있습니다. 이것은 꼭 특허법원 소속이 아니더라도 희망하시는 모든 법관께서 참여를 해서 IP에 대해서 연구를 하실 수가 있습니다. 특허법원에서 운영하고 있는 교육 프로그램이라면 판사를 교육시킨다는 그런 의미는 아닙니다. 법관과 기술조사관, 로클럽 전부를 대상으로 해서 2020년부터 매년 약 16주에서 20주에 걸쳐서 일주일에 1회 정도 대학의 교수님들께서 직접 오셔서 다양한 첨단 기술 과목을 강의를 하고 계십니다. 지금까지 실시했던 그 과목으로는 약제학, 그리고 반도체, 유기화학, 인공지능, 에너지 분야 등을 들 수 있겠습니다. 이상입니다.
네, 감사합니다. 다음 소주제 토픽 4로 지식재산 소송 전문화를 위한 또 다른 방안에 대하여 알아보겠습니다. 지식재산 전문법관 제도를 두지 않는 국가이건 또 전문법관 제도를 채택한 국가이더라도 법관이 기술적인 배경이 없는 경우도 있고 설령 있더라도 모든 분야의 기술을 파악할 수는 없습니다. 따라서 법관의 기술적 이해를 돕기 위한 제도를 둘 필요가 있는데요. 기하의 국가에서 기술조사관 제도, IP소송 전문성을 가진 로클럭 선발, 그 밖에 법관의 기술적 이해를 돕기 위한 제도를 두고 있다면 각 3분 내에서 상세히 소개하여 주시기 바랍니다. 다만 전문심리위원 전문가 정인 제3자 의견 진술 제도는 다음 질문에서 다룰 예정이오니 이 부분은 제외하시기 바랍니다. 먼저 데이비드 캠벨 판사님 부탁드립니다.
In the United States, in federal court, we do not have technical examiners who assist judges. We do use expert witnesses, but that will be addressed in just a moment. Federal judges do have law clerks. These law clerks are hired by the judges themselves. They work for the judges, often for 1 year, although in some instances for longer periods of time. These law clerks are law school graduates, usually with excellent credentials. They've done well in law school, or they have additional work experience after law school. But they do not have, typically they do not have technical expertise, because they assist the general jurisdiction judge in the full general jurisdiction calendar and have to be able to provide research and writing assistance in all of those areas. Within the federal circuit that I mentioned a minute ago, those judges, each of those judges on the federal circuit has 4 law clerks that work for them, and they often do look to hire law clerks who have some technical background or experience, although it's not a requirement. The judges make their own hiring decisions. The Patent Trial and Appeals Board judges within the Patent and Trademark Office also have a law clerk experience, or pardon me, a law clerk program where law clerks are hired after law school to come and work for them and specifically to gain patent experience. That's really the only direct assistance that judges receive.
감사합니다. 다음으로 리차드 헤이콘 판사님 부탁드립니다.
The procedure. Thank you. I'll try from a little further away. The procedure in England allows judges to have technical assistants, that's to say, a technical expert sitting with them on the bench. The judge can ask for it, or the parties can suggest it. The judge has to approve. But it's almost never happens. It's really quite rare. We tend to rely on the experts who are appearing with the parties. Each party on each side has a technical expert, where it's a technical case, obviously, and the judge relies on their evidence, weighing up their evidence, to be informed about the technology and to reach a conclusion. What's more common than a technical assistant sitting with a judge is to ask the parties to agree what we call a technical primer, that's to say, an agreed written explanation of the technology in question, which is provided to the judge in advance of the trial. For example, early next year, this is a case in the Patents Court. It's a semiconductor case. It's not possible to assess infringement by direct measurement of anything or looking at anything. It'll be done by reference to mathematical models. So I've asked for a technical explanation of how the mathematical models are constructed in advance, so that I will have some chance of understanding the cross-examination of the experts when it happens. If a technical assistant does sit with the judge, they are strictly not allowed to say anything about the rights and wrongs of the case or the result. They are just there to give technical assistance. We don't have law clerks at first instance, or in the Court of Appeal, actually, unfortunately. First instance judges are expected just to do everything by themselves and write the judgments by themselves, with this slight exception. There are junior lawyers who are in the court building who are not attached to any particular judge, but can be requested to do particular tasks for first instance judges. But otherwise, we're left to get on with it ourselves.
네, 감사합니다. 다음으로 히로아키 이마이 판사님 부탁드립니다.
Okay. We adopt a system of judicial research officials. Full-time judicial research officials are court staff members assigned to the IP High Court and also the intellectual property divisions of the Tokyo and Osaka District Court, consisting of former Japan Patent Office trial examiners and patent attorneys who have specialized knowledge in technical fields. IP High Court has 11 judicial research officials. Yesterday, at the welcome dinner table, I explained 17 judicial research officials. I have the anxiety, and I came back to the hotel room and I counted from this level, I counted from this photo. That was 11. I'm very sorry about the member of the table. So, judicial research officials assigned to the court conduct researches by order of judges on technical matters as required to conduct proceedings and render judgment in case relating to patents, utility models, and other intellectual property. From April 2005, they may, with permission of the presiding judge, ask questions to the parties during oral arguments or other occasions in order to clarify the facts of the case. So we don't have law clerk for IP litigation, but I have heard the explanation. I personally want to be helped by law clerk. Thank you.
네, 감사합니다. 다음으로 이지영 판사님 부탁드리겠습니다.
예, 특허 사건은 관련 기술에 대한 이해가 전제되어야 합니다. 그래서 한국에서는 판사님들의 기술적 이해를 돕기 위해서 기술 심리관과 조사관 제도를 도입했습니다. 그래서 이분들은 전문 과학 분야를 가진 법원의 구성원들입니다. 기술 심리관 분들은 주로 특허 심판원, 심판관 등의 경력이 있는 분들입니다. 심판원에서 일시 사직하신 후 2 내지 3년간 특허법원에서 서기관으로 근무를 하고 계십니다. 그리고 일부 기술 심리관 및 조사관 분들은 법원에서 직접 채용하기도 합니다. 이분들 역시 박사급 이상의 전문 기술 지식 분야를 가진 분들입니다. 특허 소송이 제기가 되면 여기 PPT 표에 나와 있는 것처럼 기술 심리관 분들에게 가장 적합한 그 기술 지식을 가진 분들에게 사건이 배당이 됩니다. 그럼 이분들은 기술 내용과 쟁점을 정리한 기술 검토서를 법관에게 제출을 하고 재판부에게 직접 설명을 하십니다. 그리고 법정에 출석하셔서 재판장의 허락을 받아서 직접 질문을 하는 경우도 있습니다. 기술 심리관 분들이 그런 역할을 하고 계시고요. 또 오른쪽 그래프에서 보시는 바와 같이 기술 심리관 조사관 분들은 이렇게 다양한 전공 분야를 가지고 계십니다. 그래서 이분들을 통해서 법관의 어떤 기술적 이해에 많은 도움을 얻고 있다라고 말씀드릴 수 있습니다. 다음으로 로클럭 제도에 대해서 말씀을 드리자면 특허법원에는 현재 4분의 로클럭 분들이 근무를 하고 계십니다. 다만 미국과는 달리 로클럭은 법관 개개인이 선발을 하지 않고 사법부에서 고등법원 단위로 선발을 하고 있습니다. 따라서 특허법원 로클럭만의 특별한 선발 요건이나 자격은 현재로서는 없는 것으로 알고 있습니다. 다만 로클럭 지원하시는 분들은 희망 근무 법원을 밝힐 수 있고요. 그리고 로클럭을 배치할 때에는 이분들의 희망뿐만 아니라 전공 여부까지도 모두 감안하는 것으로 알고 있습니다. 그래서 현재 근무하시는 분들 중에서 2분의 로클럭 분들은 화학공학과 컴퓨터 사이언스를 전공하신 또 이공계 경력이 있는 분들입니다. 다만 로클럭 분들은 보통 상표나 디자인 사건 혹은 민사 침해 소송의 검토를 담당을 하시는데 재판부가 희망하는 경우에는 특허 사건에 대해서도 조사를 해 오시기도 합니다. 이런 경우에는 이공계 경력 부분도 상당히 도움이 되지 않나라고 생각하고 있습니다. 이상입니다.
네, 감사합니다. 마지막 토픽 5로 앞서 논의한 내용들 이외에도 지식재산 소송의 전문화를 위해 기국에서 채택하고 있는 제도가 있다면 소개를 바랍니다. 예를 들면 전문심리위원, 전문가 증인, 제3자 의견 제출 제도, 지식재산 소송을 위한 법정의 시설 등을 중심으로 말씀해 주시면 감사하겠습니다. 배심제를 운영하는 국가의 경우 IP 소송 전문성을 확보하기 위한 별도의 방안이나 배심원을 기술적으로 보조하는 제도 등이 있으면 소개해 주시면 좋겠습니다. 3분 정도 범위 내에서 발표를 부탁드리겠습니다. 먼저 데이비드 캠벨 판사님 부탁드립니다.
Thank you. When a party applies for a patent at the Patent and Trademark Office in the United States, they make that application before a specialized patent examiner. These examiners are skilled engineers and scientists who work with the applicant over a period of time to determine and sometimes refine the patent and ultimately decide whether a patent can be issued. When a patent case comes to our general jurisdiction federal courts, as Richard mentioned, in England, judges do have the ability under our civil procedure rules to appoint an expert for the court to advise on technical matters, although that is almost never done. More commonly, as was also mentioned, we rely upon experts that the parties provide, and it's common for each party in a case to come forward with an expert. It's a good technique, in my view, case management technique, to do what Richard describes, and that is bring both experts in at the same time and talk about the science and educate the judge on the science, but that's discretionary to a judge. As to whether third parties can provide input to courts, they can. We have an amicus brief or friend of court brief practice in the United States. It doesn't happen often in the trial courts, although sometimes it does. On appeal, parties will file amicus briefs, often academics or businesses or government entities or nonprofit organizations with an interest in the outcome of the case will file a friend of court brief, and the judge can read it for what benefit it provides. With respect to jurors, juries who decide cases, there are no specialized criteria for selecting technically trained jurors. Jurors in the United States typically are drawn from the voter rolls and the driver's license rolls, and they're regular citizens who are called in at random to appear for jury trial. There are no specialized procedures for training them in patent matters. There are no specialized programs for training them. Instead, it's the responsibility of the judge to give them the legal instructions on the law that applies, including the claim construction in a patent case. And the jurors will hear from expert witnesses that the parties provide to help educate them, but there is no other special qualification or training for jurors.
네, 감사합니다. 리차드 헤이콘 판사님 부탁드립니다.
So far as expert examiners are concerned, we have no expert examiner of witnesses in the court. As in the US, and I think in most jurisdictions, when a party applies for the patent, it goes to an expert examiner in the intellectual property office. But in the court, there's no such thing. As I mentioned a moment ago, the judge is almost always instructed in the technology by evidence given from the expert witness, or sometimes more than one expert on each side. If it's a technically complex case, there may be different aspects to the technology, so you may get 2 and occasionally even 3 expert witnesses on each side, and those are cross-examined by the advocate on the opposing side, which just means sometimes there's a misunderstanding of cross-examination. It just means questions asked by the advocate on the opposing side. And in IP courts, that's usually a reasonably polite exercise. It's not an aggressive approach. One of the advantages of the cross-examination system, though, is that the expert who's giving evidence knows it's going to be tested, which means they don't give lightly evidence that they can't back up, can't justify in court. So even before you get to court, it provides a corrective to the experts to make sure that what they say is accurate, because it's going to be tested. Third-party amicus briefs, it's possible under the system. It's very unusual in IP cases. A third party must have a very good reason to intervene, but if there's a good reason, it's allowed, and it does happen. Court facilities for IP litigation. All the courts have large screens so that witnesses can appear by video link. This happens more frequently than it used to, especially since COVID. It's become quite common. Instead of having the expert flown in from Seoul or Tokyo or wherever the expert professor lives, they instead appear by video link in the court, and the evidence is taken that way. It saves time and trouble. So all the courts are equipped to do that. And short hearings, if it's a very short, just a short hearing, it's common to have the entire thing conducted by video link so that nobody has to travel to the court. If the case is, say, a half a day or less, it's common just to have the entire thing done by video link. Thank you.
네, 감사합니다. 다음으로 히로아키 이마이 판사님 부탁드립니다.
So I would like to explain the technical advisor system I have already mentioned. The technical advisor system aims at achieving higher quality of court proceedings and judgment in specialized fields of lawsuit, such as intellectual property cases, in which scientific and technological matters are often disputed. And at this time, this system, experts who have a wealth of knowledge in relevant scientific fields are asked to participate in court proceedings as technical advisors. They provide judges and parties from the viewpoint of a fair and neutral advisor with explanations on the technical matters involved in the lawsuit. These explanations are helpful for judges to have a better understanding on the technical aspects and to narrow down legal and factual issues of the case. About 200 technical advisors appointed nationwide. About expert witness. Expert witness about infringement may be designed by the courts provide their opinion on matters requested by the courts. However, these expert witnesses are rarely used in actual cases in practice. Rather, parties submit a document private expert opinion, which is an opinion letter of an expert requested by the parties. But the petition of the expert opinion for calculation of damages shall be accepted if in need. Patent Act Article 105/2 prescribes that litigation involving the infringement of a patent right or violation of or exclusive license, if the court, at the motion of a party, orders an expert opinion in order to calculate the damages from the act of infringement, the party must explain to the expert witness the details that need to be explained in order for the expert witness to give an expert opinion. This provision applies mutatis by Trademark Act Article 39 and Design Act Article also. Third party opinion, amicus brief. Amicus brief proceeding is one of the procedures for the collection of evidence that was newly introduced by the amendment to the Patent Act in 2021, but it is very rare. And we have documentary evidence, and we have another court facility for IP litigation system called MINT, but it is under the booklet, so I didn't explain. I don't explain. Concerning the jury system of IP trials, we don't have jury system. Thank you.
네, 감사합니다. 한국의 이지영 판사님께 부탁드리겠습니다.
네. 먼저 전문 심리위원 제도를 말씀드리겠습니다. 민사소송법에 기해서 법원은 특허소송에서도 전문 심리위원을 활용할 수 있습니다. 오른쪽 그래프에서 보시는 바와 같이 기술과 관련된 여러 전문 심리위원 후보님들이 확보가 되어 있습니다. 전공 분야도 다양하시고 대학 교수나 박사 이상의 기술 전문가들이라고 할 수가 있습니다. 재판부는 해당 사건에 가장 적합한 전문 심리위원 후보들을 선정을 해서 전문 심리위원으로 활동하시게 합니다. 이분들은 주로 해당 사건을 검토한 후 기술 관련 설명과 의견을 제시한 서면을 제출할 수도 있고요. 또 기일에 출석해서 또 직접 설명이나 의견을 하시기도 합니다. 또 재판장의 허가를 받아서 소송 관계인에게 또 여러 가지 질문도 하실 수 있습니다. 다음으로 전문가 증인에 대해서 말씀을 드리자면 역시 민사소송법에 근거해서 특허소송에서도 전문가 증인을 선정할 수 있습니다. 주로 통상의 기술자의 기술 수준이나 실시료, 그다음에 선행 발명의 내용이라든지 기술 대비 등을 위해서 선정을 하고 있습니다. 법원이 직권으로 선정하는 경우보다는 당사자들이 신청에 이어서 이루어지는 경우들이 더 많다고 말씀드리겠습니다. 다음으로는 그 전에 이제 제3자 의견 제출 제도에 대해서 말씀을 드리자면 한국은 미국과 같은 제3자 의견 제출 제도는 없습니다. 다만 원고와 피고가 본인의 주장에 부합하는 전문가들의 의견을 준비 서면에 담아서 주장을 하거나 그런 의견들을 증거로 제출할 수는 있습니다. 그러면 법원에서는 여타 다른 증거와 마찬가지로 자유롭게 선정해서 결론을 내릴 수 있다라고 말씀을 드리겠습니다. 마지막으로 지식재산 소송을 위한 법정 시설을 말씀드리자면 2021년부터 한국은 전자소송을 시행해 왔고요. 지금 현재 특허법원의 소송은 전부 전자로 진행하고 있습니다. 그래서 기본적으로 화상 실물화 장치라든지 컴퓨터 등은 당연히 설치가 되어 있습니다. 특히 특허소송의 변론기일에서는 원피고가 직접 기술 설명을 합니다. 오늘 참가하신 많은 변호사님들께서 이런 역할을 담당해 주시는데요. 변론기일에 직접 파워포인트 등을 이용해서 기술 관련 쟁점, 법률적인 쟁점을 모두 설명을 하고 계십니다. 가끔은 직접 물건을 가지고 나와서 보여주시기도 하고 관련 동영상도 보여주시고요. 사진, 도면을 직접 제시하기도 합니다. 이런 과정을 통해서 법관은 좀 더 기술을 쉽게 파악할 수 있다라고 말씀드리겠습니다. 이상입니다.
네, 감사합니다. 벌써 예정된 시간이 거의 다 됐는데요. 자료집을 보시면 아시겠지만은 패널 분들께서는 각국의 IP 소송 전문화 방안에 대하여 서면으로 아주 자세한 설명을 해주셨습니다. 아마 소중한 자료가 될 것 같습니다. 그렇게 자세한 설명을 해주셨는데 불구하고 한정된 시간으로 인하여 준비하신 답변에 비하여 너무 짧은 발표 시간밖에 못 드려 죄송하게 생각을 합니다. 패널 분들로부터 마무리 말씀을 청해 듣는 것으로 1세션은 마치도록 하겠습니다. 마무리 말씀은 좌석에 착석한 순서대로 듣도록 하겠습니다. 먼저 이지영 판사님 부탁드립니다.
예, 1세션이 끝났습니다. 먼저 참석하신 판사님들이 너무나 유명하신 분들이라 마이크가 놀라지 않았나 싶습니다. 초반에 원치 않은 하울링 때문에 많이 고생하셨을 것 같은데 패널 분들 그리고 청중 여러분께 주최 측을 대표해서 양해의 말씀 구하겠습니다. 1세션 잘했지만 무엇보다 가장 잘한 것은 여러분들의 소중한 점심시간을 지켜드린 게 아닌가 생각합니다. 예, 들어주시느라 너무 고생 많으셨습니다. 감사합니다.
네, 데이비드 캠벨 판사님 부탁드리겠습니다.
Well, I guess I'm done. I've appreciated the chance to be a part of this panel and to hear the similarities and the differences among our various countries. I look forward to discussions the rest of today and tomorrow to learn more so that we can take valuable ideas back to our courts and our country.
네, 감사합니다. 리처드 헤이콘 판사님 부탁드립니다.
Is it on? Ah, so. Well, no, it's yeah. I think this morning's conference has proved what I've often found when speakers from different jurisdictions discuss their procedures and approaches to matters of IP law. It's always very valuable to learn from other jurisdictions. I think all of us, especially lawyers perhaps, have a tendency to think that a particular approach must be the right approach because that's how we've always done it and we've never really thought about anything else. Well, I always find it very useful to hear from other judges that there is a different approach, and I think that is a healthy way of encouraging us all to think about our own systems and whether they can improve, and there is always room for improvement. I would lastly say that this has been conducted, I think, almost exactly on time, so I congratulate the moderator in particular.
네, 감사합니다. 히로아키 이마이 판사님 부탁드립니다.
Yeah, thank you very much. And I have learned a lot of things from them, and we have to continue the continuous effort to make the litigation system more efficient. So thank you very much.
네, 감사합니다. 한지윤 판사님 부탁드리겠습니다.
예, 그 각국의 지식재산 전문법원의 운영 현황과 그 관할을 비교해 볼 수 있는 상당히 뜻깊은 시간이었습니다. 특히 저는 많이 배울 수 있어서 감사드리고요. 그 경청해 주신 청중분들과 또 많은 시간을 할애하셔서 준비해 주신 우리 패널 분들께 특별히 감사드립니다. 감사합니다.
네, 1세션은 이것으로 마무리하도록 하겠습니다. 오프라인으로 모두 참석해 주시는 여러분 모두에게도 감사드립니다. 네.
We are now about to start the second session of this conference. This is a special session on the European Unified Patent Court, launched in June 2023, and this session will be conducted in English. The moderator for session 2 is Honorable High Court Presiding Judge Kang Jin-baek of Jeonju Branch of Gwangju High Court. And the speaker is the President Klaus Grabinski of the Court of Appeal of the Unified Patent Court. Please join me in welcoming them. First, President Klaus Grabinski is going to give us a presentation on the Unified Patent Court. And then Judge Beck and President Grabinski will discuss the UPC in more depth. Now I'd like to turn the floor over to President Grabinski. Please give him a big round of applause. Slides, please.
Thank you very much for your kind introduction. Good afternoon, everyone. It's a great pleasure being here, and I'm very grateful that I have the opportunity to present to you hopefully the main features of the Unified Patent Court, a patent court for Europe. But before getting to the court itself, it is good to have a look back. So what was the situation before the agreement, which is the legal basis for the court, entered into force? So let's turn to the state of play until 31st May 2023. There was one beauty of the European patent system that concerned the pre-grant phase of a patent. So instead of having to go to each national patent office in Europe, like the situation was before the 70s, so you wanted to have patent protection in France, you had to go to the French patent office to get a French patent. You have to go for getting protection in Germany to the German patent office for getting a German patent. On the basis of the European Patent Convention, as of 1977, when the convention came into force, the signature date was 5th October 1973, it was only one office where you could go. And filing and getting a patent from that office gave you protection in all the contracting member states. At the beginning, there were less than 38, but now it's 38 member states of the European Patent Convention. However, what you got? So once the patent has been granted, the patent gives you the effect of a national patent granted in each of the contracting member states, provided the patent has been validated and maintained in each of these states. So the downside of this was that you had to pay a lot of money for fees when you wanted to get protection in a number of contracting member states. So it can be up to 38 member states if a patent owner wants to have protection in these member states. They have to pay fees in all these member states. And on top of that, as the European patent gives protection like a national patent in each of the contracting member states, in practice, it boils down to a situation that when the patent has to be enforced because there is infringement in the member states, that you have to go state by state. So in order to enforce the German part of the European patent, in practice, it is very often necessary to litigate in Germany. When it's about the enforcement of the French part, you have to litigate before the French national courts. There are some exceptions to this, but in general, that is the practice. And when it comes to the validity of the patent, so someone is attacking the validity of the patent by filing a revocation action, again, this has to be done state by state. So when filing a revocation action with regard to the German part of the European patent, the case has to be brought before a German court, the competent court, and when it is about the French part, the action has to be filed with the French court. So, in short, to sum it up, pre-grant, there's a centralized procedure before one patent office, one-stop shop only, but after grant, when it comes to validation and maintenance of the patent, it goes state by state, and also when it comes to enforcement, it normally goes state by state. And the idea of the UPC and also of the unified patent is to improve this situation. And this is how it works, or what is the new offer since 1st of June 2023. When it, concerning the patent court, since 1st of June 2023, based on the agreement of a unified patent court, which entered into force as of that date, there is a court before which the patent can be enforced with regard to the contracting member states, which are at the beginning 17 out of 27 EU member states. And at the same time, those who have a patent application and the patent has already been granted can opt for, instead of having a European patent, the bundle patent, state by state, they can opt for the 17 contracting member states of the Unified Patent Court agreement. They can opt for unitary protection. So it is only one patent and only one patent office who takes care of maintenance of the validation and maintenance of the patent, which is the European Patent Office. So the idea of the Unified Patent Court is essentially that this is a court of the contracting member states. So the Unified Patent Court, in other words, is at the same time a French court, a German court, a Dutch court, and I could name all the 17 contracting member states that has jurisdiction with regard to European patents. So the UPC has exclusive jurisdiction where the court of a contracting member state would have jurisdiction in European patent matters if the UPC agreement had not transferred that competence to the UPC. So to give you a scenario, there is an alleged infringement that takes place in France, in Germany and in the Netherlands of a European patent. Before, you had to go, in order to enforce the patent, to the French, the German and the Dutch court. Now, it is possible to bring the case before one court only, which is the UPC. And that, of course, is the other side of the coin, that also when a competitor wants to attack the validity of the patent, the action can be filed with just one court. So also attacking the validity of the patent with the French, with the German and the Dutch part, in my example, before only one court, because this court is considered to be at the same time a French, a Dutch, and a German court, and so on. There's one exception to this. Patent owners who don't like the new system have and had the opportunity to opt the patent out. When the patent is opted out from this system, which is done by a simple declaration in front of the court, of the UPC, then for that European patent, everything applies that I've told you applied before 1st June of this year. So all patent owners who don't like the system can opt out from the system with their European patent. And have done so also already. When you look at the numbers, potentially there are about 1.5 million European patents and published European patent applications that potentially can be opted out. And out of these 1.5 million, roughly, about a third has been opted out. But there's also the possibility to opt in again unless there is a case pending before a national jurisdiction. Then it is no longer possible to withdraw from the opt-out. Now, let's have a brief look at the unitary patent. Unitary patent, as mentioned, can be in the after-grant period can be maintained with only one patent office, which is the European Patent Office. These patents, for these patents, it is only the Unified Patent Court who is the competent court with regard to, on the one side, infringement actions, and on the other side, the revocation actions. And the unitary patent confers to its proprietor protection throughout the territory of the contracting member states and reduces complexity and lower costs. When you go to the website of the European Patent Office, they did a calculation with regards to fees, and they compared the maintenance fees over a certain duration of the patent in the 4 member states where most of the patents are validated and maintained in practice during the last years. So these were Germany, France, Italy, and the Netherlands. And the maintenance fee costs for, when you compare this for a certain duration of time with the maintenance fee you have to pay for a unitary patent, the result was that it is 29% lower fees for a unitary patent, with which you have coverage of 17 contracting member states, compared to the maintenance fees for only these 4 states. Now let's have a closer look at the structure of the court. As you can see, the Unified Patent Court has a court of first instance and a court of appeal, and it also has a patent mediation arbitration center. Actually, this is not yet set up, but it is going to come very soon. So the court of first instance splits up into local division, central division, and regional divisions. So what does it mean? Local division means that there is one contracting member state hosting a local division. Regional division means that more than one contracting member states share a regional division, and there is a central division. The local infringement actions normally are brought before local divisions or regional divisions, depending on where the infringement occurred, the place where the infringement occurred. While central division essentially has jurisdiction on the revocation actions, isolated revocation actions, as well as actions for declaration of non-infringement of a patent. as you can see on the right-hand side, there is also the European Court of Justice mentioned. That is an interesting and important aspect. In the European Union, the interpretation of European law is exclusively falls into the competence of the European Court of Justice, and therefore the national courts make referrals to the European Court of Justice when a legal question of interpretation of EU law is either unclear or has not been clarified by the European Court of Justice. And the same system applies also to the Unified Patent Court, because the Unified Patent Court is nothing else, nothing different from a national court. It is just a court not only of one EU member state, but of a number of EU member states. But apart from this, the same principle, relation between the Unified Patent Court towards the CJU is the same like a national court towards the CJU. So when an issue of EU law, interpretation of issue of EU law comes up, and it is not clear and not clarified, then also the UPC has to make a referral to the CJU. But at the same time, I should mention that a large part of European patent law are not EU law. They are law under the European Patent Convention, which is not part of EU law. Here you see a map of Europe, and the dark blue states are the contracting member states where the UPC agreement has been ratified. So these are the 17 contracting member states. You see in a slightly brighter blue those states, contracting member states that, those member states that signed the agreement but not have yet ratified the agreement. And then in the very bright blue, Croatia, Poland and Spain are those EU states that have not neither signed nor ratified the agreement. If you allow me a very short remark in that regard, when you look at the European Patent Convention, it also started with a few European states and then more and more joined. That's a rather normal way how this develops. There was a minimum number of contracting member states for this new court, for the agreement, which was 13. And at the beginning, it were 17 who started this. And the system is open for all those EU member states that not have yet joined the system at all time. And I was informed from Ireland that they will have a referendum soon on whether to ratify the agreement or not. That there's an it is under their constitutional system, it is necessary for them to have a referendum before ratifying an international agreement. You also see on the map the locations of the local, central, and regional divisions. You also see the two places of the PMAC, the Center for Arbitration and Mediation, and you also see the place of the training center in Hungary. This is actually not also not realized at the moment because Hungary preferred not to ratify the system at the moment. Now, how is the composition of the panels that are going to decide in the cases? As you can see, Central Division, it is a panel of 3 judges, 2, we call them LQG, so legally qualified judges, and 1 technically qualified judge. So the technically qualified judge, of course, is from the field of the technology of the patent. Patents are classified under the IPC classification system, and accordingly, the technically qualified judge of the field of the patent in litigation joins the 2 legally qualified judges. In the local and regional division, you usually have 3 legally qualified judges. Sometimes they can be two of them can be from the member state hosting the local division. Sometimes it's only one. And they are always joined by either one or two legally qualified judges from another contracting member states, which means that the panel is always an international panel. It is never only the judges come from one member state. And most of the time, they are also joined by a technically qualified judge from the technology of the case. At the Court of Appeal level, a panel of 5 judges is sitting on the case, and it is 3 legally qualified judges and 2 technically qualified judges from the respective field. If you ask me about the background of the technically qualified judges, partly they are technically qualified judges from the national jurisdictions. They are technically qualified judges in Sweden and in Germany in particular. But in other countries, there are no national technically qualified judges. So from these countries, they normally come from the ranks of practitioners, so patent attorneys. But they can also be retired EPO Board of Appeal members, not active Board of Appeal members, or they can also be sometimes examiners from national patent offices. There can be issues of conflict of interest when they are patent attorneys, but there is one rule in the Code of Conduct that provides that you cannot, when you are a technically qualified judge in the UPC, you cannot represent the case before the UPC. You can represent the case before a national court, before a national office, or before the EPO, but not before the UPCA. So you cannot be on Monday a technically qualified judge and on Tuesday represent the case before the UPC. That is not allowed under the Code of Conduct. Well, as to languages, you all know in Europe we speak a lot of languages. So what is the language of proceeding before the UPC? In the central division, it's always the language of the patent. And the European Patent Office has 3 official languages, and the patent applicant can use one of these. And that language is always the language of proceeding before the central division. Before the local and regional division, it is either the official language of the contracting member states hosting the local division or sharing the regional division, or when the contracting member states designate a second or third language, it can be one of the official EPO languages. So in practice, there were respective designations from all contracting member states hosting a local division. It is the official language and English. So before the local divisions in Germany, for example, it's German and English. Before the Dutch, it is Dutch and English, and so on. The one exception is the regional division. There's only one regional division, which is located in Stockholm. It's a regional division of Sweden and the 3 Baltic states, and they all decided it is only English. It is not Swedish, it is not one of the Baltic languages, it is only English before the regional division. And there's another example maybe worth mentioning, that's in Brussels, as they have 3 official languages. In Belgium is the 3 official languages and plus English. So you even have 4 languages at your choice as a claimant. There is one provision that's maybe also interesting. Of course, when the parties agree and the court agrees, they can agree on the language of the patent instead of the official language of the member state hosting the local division. But even at the request of one party and after having heard the other parties, the President of the Court of First Instance may decide on the language in which the patent was granted instead of the official language of the state hosting the local division. And this has been played already in one case. So in this case, I think it was in The Hague. It was originally Dutch, and then the president decided it should be English. Court of Appeal normally follows the language of the Court of First Instance. Well, the court is up and running since 1st of June of this year. And since then, 90 cases have been filed with the Court of First Instance as of 24th of October 2023. And here you see the kinds of cases that have been filed: 47 actions for infringement, 6 counterclaims for revocation, 23 actions for revocation, and of course also preliminary measures, preserving evidence, and requests for inspections. Now, a very brief look at the proceedings. Important is that it is a front-loading system, which means already in the written procedure, all facts and all evidence has to be submitted to the court. So when you come later, that may be a problem. You may be asked, why do you come later? And it might be that the fact or the evidence is not allowed. So the idea, of course, is to have it all up front, so that at the end the oral procedure can be done no longer than 1 day. Then there's an interim procedure which mainly has as purpose the preparation of the oral hearing, so summoning witnesses or experts if necessary, setting the date of the oral hearing, but also exploring possibilities whether the case can be settled. And then of the oral procedure, which is, I guess, quite similar to the oral procedures as you know it in the courts here in Korea. It can start by a preliminary introduction to the case by the judges. So the judges, the judges are supposed to have read everything that has been submitted, and based on this and maybe a deliberation a day before the oral hearing, they may give an introduction to the case, make transparent their preliminary view on the case, and invite the parties to focus on those issues that, from the perspective of the panel, are decisive to decide the case, are relevant to decide the case. So that right from the beginning, the discussion, the pleadings are focused on the issues that have been identified by the panel to be the decisive issues of the case. Then this, of course, is followed by pleadings of the parties. Time limits may be set in advance. This is, if I may say so, a heritage from the UK. The UK took a very active part in the drafting of the rules of procedure. And this is unknown, at least from a German perspective, but everyone was convinced that this may also be a good idea to keep the oral hearing short, but at the same time focus on the issues that are decisive for deciding the case. Then, of course, hearing of witnesses and experts, judges and parties may put questions, and then endeavor to complete the oral hearing in 1 day, which does not mean, of course, when it's a very complex case and the panel feels that they need more pleadings and need more facts in order to decide the case, then of course it can also take 2 days. Or they adjourn and they hear witnesses and come back and have a final hearing. That's always possible, but in principle, when we talk about an average case, it should be completed, the oral hearing, in 1 day. Video conferencing is available, but the principle is that the judges are present in the courtroom. Representatives and parties may be allowed to attend the oral hearing by video conference. And complete video hearing that is completely run by video conferencing is possible only in an exceptional situation like a pandemic, or with consent of everyone concerned, of course. Then there's public access to the electronic register. Decisions and orders are published. Written pleadings and evidence are available upon the reasoned request by decision of the judge rapporteur after consulting the parties. And of course, a party may request that certain information be kept confidential. protection of confidential information is possible. Confidentiality clauses are available. If there's a need, that may of course in particular arise in SEP cases. But it cannot be completely kept away from the other party. There's always one national party from each party that has access to also this confidential information and the representatives. Pre-trial procedure, well, no pre-trial discovery US style available. It is more focused. Order to preserve evidence or inspections are available. And we already had cases, as I mentioned. And provisional protective measures are also available. Experts, party experts or appointed experts are available. I don't expect many court-appointed experts, as there are already technically qualified judges on the panel. A permanent injunction. Yes, it is of course available, and there is no eBay test US style available. That's case law in the US, but not applicable in Europe. But also injunctive relief has to be proportionate if argued. So that can also can become an issue. Award of damages, you know the three ways of calculation of damages: lost profits, return of infringers' profits, royalties, but no punitive damages. And this is maybe the last slide I would like to cover. Well, the judges come from different jurisdictions, from France, from the Netherlands, from Germany, Italy, and so on. And they all have their particular format of decisions. For example, in Germany, you have the operative part of the decision, the order, in front of the reasoning. So you first have the operative part, then you have the facts, and then you have the reasoning. While in France, it's different. They have the facts, they have the reasoning, and then the operative part. So in order to have a unified patent court, so have the same approach, have the same format, the court has had to develop some kind of uniform format for it. And there are templates and also guidances available on the UPC website. And this is an invitation to the judges, but not only to the judges, also to the representatives, to use a particular format that's not about content, but is more about format. And so the decision was that the operative part, according to that template, has to be at the end, always, of the decision, not to continue following the German tradition to have it at the beginning. So it's a bit like in traffic. You have to decide whether you have that you drive on the left side or on the right side. So but this kind of decision had to be taken in order to have it really a uniform court, also with a uniform format. But it's also getting a bit more important than rather have it at the front or at the end of the decision, the operative part. For example, how to draft an injunction. There are some in some countries you do it by repeating the wording of the patent claim. In some countries you simply say, well, stop or making use of the patent, and then only the number follows. But also in this regard, there are guidances and the purpose of these guidances is to invite representatives to draft their requests according to the guidances, but also invite judges to draft their operative part and decisions according to the guidances. And one more slide. Here you see a few locations where you have local and regional divisions. In Europe, I ask the audience, do you know where the places are? But here in Korea, I just lead you through the pictures. So on the first line, first picture, this is the regional division in Stockholm. The next one is the local division in Vienna. The next one is the local division in Düsseldorf. The lower line, you may have a feeling for this. This is a view on Ile de la Cité in Paris, but it is not the place where the local division is located, but is the view from the local division on the Ile de la Cité, but they have courtrooms there. And the next one is the Court of Appeal in Luxembourg, former parliament building of the EU. And the final one is the local division in Milano. Thank you very much for your attention.
Thank you very much for the wonderful presentation. Big applause, please, again. Now I'd like to hand over the mic to our moderator, Honorable Judge Kang Jin-baek. Please welcome him with a big applause.
Please turn on my mic. Hello? Okay. So you're in Luxembourg, right?
That's true, that's true, yes.
So the whole building is an appeal court building, or you're
No, it's just a floor of this at the moment, and we get another one in the near future.
So how many cases you have now?
At the Court of Appeal level, we have currently 2 appeals, one pending and one already decided. That is something unknown from a German perspective, but available under the rules of procedure of the UPC, that we also have procedural appeals. And the first decision was on a procedural appeal issued by we have 2 panels at the Court of Appeal, and this decided by the panel, the other panel, where we have a colleague of mine here.
So in Korean perspective, it's amazing. After 4 months, you have already appeal case. So it's very fast court, in my view. And thank you very much for the comprehensive presentation. It's very informative, and we learned a lot from your presentation. And I know this is really a precious, unique opportunity for us. We saw this morning session that each country has their different systems, and even for us, experts like us, it's very complicated and hard to understand. So this kind of unified court is ideal, like dreams come true, really. And we have here today the Chief Justice of that court. How lucky we are. So, but I guess this is the most popular time during your tenure, right?
Sorry to interrupt, but it's a mic again, so can you give us a few times, please?
Yeah. So, it's
Thank
better?
you so much. Yes, please continue.
So, I know your audience have many questions, and unfortunately we have time until 3, so it means 10, 24, around 40 minutes, right? Yeah, so let me ask Dr. Gravinsky some very basic general questions, and then the last 20 minutes will go to the floor, and I'll take question as a moderator. So I already feel it's running out of time, so I'd like to begin with a very basic question. So I told you this is very ideal and very promising, but how is the reality? Isn't there any concern this system add more complexity on the existing system? If not, what is your measure to make this patent application or revocation system more efficient, simple, or faster? So please.
Actually, it is a kind of offer at the moment. You can, it makes possible if you want to litigate in more than one contracting member state, that you can do it before one court. That is the offer. but in a transitional period for 7 years, every proprietor of a patent can decide which way he or she wants to go. So you can, on the one hand, you can decide you don't like the system at all, then you opt out. You decide, okay, I like the system, I want to make use of it, but I also have the possibility at the same time to bring cases still to the national courts. That is another offer, then you stay in the system. Or you like the unitary patent, you have a patent granted, and then you have 1 month's time to decide, okay, I don't want to have the conventional bundled patent, I want to have a unitary patent because, well, I pay the price for 3 to 4 and get protection in 17 contracting member states, which may be an advantage for your economic concept. And then you may opt for unitary protection. And then, of course, when the patent has to be enforced, then it is only the Unified Patent Court where you can do this. At the same time, you have to take into consideration that the judges that have been appointed for the Unified Patent Court are, at least most of them, are the judges litigators already know from the national jurisdictions. So they are not new judges, but they are experienced judges. And some of them became full-time judges in the UPC, and others became part-time judges, so meaning they have a hat as a UPC judge, at the same time have a hat as a national judge. And you may ask, why is this that you have this part-time system? Well, the idea is, at the beginning, nobody knew how many cases will be brought to the court. But at the same time, judges have to be paid for. And so the idea was, well, we wait and see. When there are more cases, the working time of the judges in the UPC will be increased. And we are currently already at that, in the situation where we think, and we already did so, and we increase the working time of the judges because it is not sufficient working time at the moment. Yeah.
Okay, so I understand you're ready to make process more efficient and try to give more options to the patent applicants, like opt out, and even after opt out, you can opt in again, right? So
yes, under one condition, when you opt out, and then the patent is litigated. Either you base an infringement action on the patent, or the patent is against the patent, a revocation action is filed before a national court, then you can no longer opt in.
Okay. In terms of European patent, you have option whether you have the patent with unitary effect or without. But how about national patent? Is it wise to keep national patent at the same time with European unitary patent?
Well, with regard, it was always possible to file for a national patent, for example, for a German patent, and at the same time for a conventional European patent. But when and normally it was first the national patent that was granted. So, for example, the German patent, and then later also the European patent was granted. And then, of course, you have the overlap between the German patent and the European patent. And in that regard, at least in Germany, there was a prohibition of double protection, which means that then the German patent has no longer any effect. It only helped you to have it earlier than the European patent.
Okay.
But after the European patent has been granted, and of course only when it really overlapped, then it was only the European patent that was still existent. Now with the new patent system, it is different. You can even have double protection. So you can always have the national patent, but you can even have double protection. The only thing which is not possible is to litigate at the same time. For example, for patent infringement based on the German patent before a German court, and based on the unitary patent before the UPC. That is not possible.
Okay, so it means it's a more stronger protection
Yes.
could be given by UPC. So to the contrary, if you, in terms of revocation, invalidation, if your unitary patent was held invalid, it means it was killed by one shot. So it's patent holders' perspective, it's very risky choice could be. And also I found that your EPO's opposition process to patent still exists. It means that you have two tracks. You can file opposition to EPO, and at the same time you initiate the revocation suit in UPC. So what is the relation between two processes?
That's true, but this is has always been true. So also in the old system, it is possible that you file in parallel an opposition, and then in most member states of the European Patent Office, so of the European Patent Convention, you can in parallel also file a revocation action. There's one exception: you cannot do this in Germany. So you can only file a revocation action in Germany when either no opposition has been filed or opposition has come to an end. Before you cannot do this. So the situation now with the UPC is that indeed you can file opposition and in parallel also a revocation action. With regard to the first argument you mentioned, that you now can file a revocation action before the UPC and then in one action have the patent invalidated, while before you had to go to the national courts for your revocation case. That is formally true. However, when you look at the practice also in the past years, when the revocation action was successful in one or two of the main jurisdictions, then what is the patent still worth? It is no longer respected in the market anymore. I very often hear the example saying, "Okay, don't put all your eggs in the basket."
Right.
And I know this from financial situation. You mean then you have different asset classes, and when you have different asset classes, so with the one asset class goes the wrong way, then you still have the two. But this means that the asset classes are independent from each other. While when we talk about one patent, and as said, it is has been revoked in two of the major jurisdictions, then okay, then it is not respected that much any longer. So we are not talking about different assets classes.
Okay, follow-up question. So if EPO declares that this patent is invalid, later in the revocation process, UPC can say, no, this is valid. This is
no. When the EPO declares a patent invalid, then it is gone.
Gone.
So the only interesting situation is when the patent is revoked in part before the EPO and also in part before the UPC. So what remains, and it is a bit like overlapping. You see, okay, this part remained before the in opposition, this part remained before the UPC, and then where it overlaps, that's the remaining part at the end of the day.
Yeah. So, to my knowledge, the opposition process has time limit, right? It should be filed within
9 months.
9 months, right? So usually opposition process start first if you attack a patent.
Not necessarily. Within you can also file a revocation within the 9 months, even earlier. That's not necessarily the case. But then you have it in many countries that you can file, not in Germany as mentioned, but that you can file the revocation and opposition, and then the question in the revocation case comes up about how to deal with the parallel opposition proceeding, and the practice in many countries is well to look well how long will it take for the in opposition proceeding to decide the case. If it takes long, then they go ahead and decide in the national jurisdiction and don't wait for the opposition proceeding.
That would be the same case in UPC.
Probably yes. Yeah,
okay.
More or less, yeah.
Right. Only 10 minutes left, and I have only 2 questions. But this is the most interesting part in relation to what we discussed this morning. Many speakers mentioned the technical advisors, experts, but in UPC, we noticed there's a technically qualified judges.
Right.
You explained who they are and where they come from, but my question is whether they have same vote or same quality of voice on the legal matters in the deliberation, for example.
Well, you don't find anything on this in the agreement. I think the agreement is based on the assumption that, of course, every judge has the same vote. But I would not expect that the technically qualified judges take care only about the technical issues and the legally only take care about the legal issues. But my expectation will be that they are all they are responsible in both regards, technical and legally, and so they should be involved equally in both regards. So the legally qualified judges have to understand also about the technology and at the end be in the position to decide the case in that respect, as the technically qualified judges have also to understand the legal implications of the case and also be able to decide on this.
Okay, so I heard that patent attorneys can represent the parties in UPC, so they can represent parties alone without joint representation with lawyers. Is it true?
That's true. If they have a further qualification, essentially, when one requirement to represent the case as a patent attorney before the UPC, then probably the decisive requirement is that you are allowed to represent the case before the EPO. So, and if that requirement is given, then you can represent the case. For example, interestingly enough, patent attorneys from the UK, even though, as you know, UK is not part of the UPC, patent attorneys who are qualified to represent the case in opposition proceedings before the EPO, and they have the extra qualification, can also represent the case before the UPC, while, for example, UK lawyers cannot represent a case before the UPC when they are only admitted to in the UK, because lawyers have to admit it in one contracting member state of the UPC.
So it's interesting fact. To represent parties as a patent attorney, he or she needs some certificate, like legal education or some extra training, or he or she just can file a permission, then get a license?
Well, they need a certain qualification. That's laid down in the agreement, and you can have respective training, and then you are qualified.
But I guess that leads to the technically qualified judges.
Yeah.
The whole system is even the technical expert can learn some legal skills during the process.
I was speaking about the representation. So the technically qualified judges is a different thing. They don't need this qualification. The qualification they need is they have to be national from one of the contracting member states, and they have to have a graduation from a technical university, these kind of requirements. And then the system how to become a judge in the UPC is it's clear. Well, this is for the technically qualified judges. For the legally qualified judges, you have to be eligible to become a judge in one of the contracting member states, and then you can apply to become a judge. And then there is an advisory committee, and they publish codes, and then they did interviews with the judges. Of course, there's also written application, and then they put you on a list or they don't. And based on this list, then you can be appointed to be a judge by the administrative committee.
Okay, it's very interesting part of UPC in my view. And we have four minutes. As a judge, I find it very interesting when you talk about the operative part of the judgment. I have experience working as an United Nations international judge, and my colleague was French, and the court, the decision, the operative part comes last. But in Korea, the operative part comes first. So sometimes the decision, the judgment is like 500 pages. You don't know until you read the last page. What is the conclusion of this case? So it's very interesting. So in that sense, as a chief judge, how do you conceive to harmonize the multicultural judges and how make the process efficient? Sometimes you can use multiple languages in a session. So is there any idea or vision on that?
I think there are different ways to deal with this. As mentioned, the panels are, as provided for in the agreement, will be multinational all the time. Sometimes there may be two coming from the same countries. Sometimes all are coming from different countries, at least the legally qualified judges. And well, they influence each other. They learn from each other. And what I during a training told them, well, please stop thinking, okay, we do this in my home country like this, but better look at what the agreement tells you, what the rules of procedure of the UPC tell you, and try to follow that way. But at the same time, of course, there is already case law in the contracting member states existing, and very often it is already aligned. There is not much different because they are all based on the same provisions. That the European Patent Convention is in place almost 50 years now. Also the definition of what is a direct infringement or indirect infringement is, even though it is part of the national law, has been harmonized already quite some years ago. So the court can build on these aligned provisions and interpretations. But at the same time, particularly with regard to procedural law, they now have to become familiar with the rules and develop their own style. And if it goes differently in different local divisions, I don't know, the one in the north is different from the one in the south, then at the end it's the role of the Court of Appeal to find the right way, and then the normal idea would that they then follow the harmonized approach taken by the Court of Appeal.
So I saw in your presentation there's no eBay, no discovery, like you have your sui generis procedural rules and of course agreement. So you can confidently say this system is harmonized all the system of the world, including US. So in the sense, so judges think the educational background are very different, but this is not possible. But if judges in a country has got education from USA and insist on US system, so you can say our UPC stick to the rules. This is a very harmonized, neutral system. So,
at least I would consider this to be the common ground for developing the case law, and yes, I think that's the way forward. Yeah.
All right. So it's already run out of time, so I have many questions to ask, but I know this is not the session dedicated to me, so this is session for the floor, for more engaging and more interactive discussion. So now I'd like to open the floor for questions. Okay, the microphones are ready? Yes. Okay, please raise your hand if you have questions. Okay. State your name and affiliation before asking a question, please.
Yeah, thank you very much. Thank you very much, President Grabinsky, for your great presentation. It was so informative and it helped me a lot to understand how the Unified Patent Court of Europe was created and its features and benefits as well. My name is Joe Kwok. I'm a partner of Intellectual Property Practice Group of Lee & Co. based in Seoul. And I also serve as Secretary General of KIPLA, Korean Intellectual Property Lawyer Association. I have a couple of questions regarding the impact of the UPC from a big picture perspective. So the first one is, could the introduction of the UPC institutionally make the European IP market more attractive than the US IP market in the future or in the near future? I would appreciate your views on this. And the second one is, there are a lot of countries in the EU, and each country may have different advantage or benefit in perspective of adopting the UPC. So I would like to know if you have any experience of analysis on that. And from the same perspective, I also wondered how the advantage and disadvantage of large companies and small companies, relatively middle-sized and small companies, and as well as European companies and foreign companies. So thank you very much.
So you have 3 questions already.
Yeah. Yes, well, when I look at the US, but we can also speak of other big markets, you normally have the principle, okay, there's a big market, and you have one patent for the market, and you have protection all over, and when you want to enforce the patent, you go to one court, and you enforce it in the whole market. The problem in Europe before 1st June has been, well, there's one single market, but there are many courts in the different national jurisdictions, and when you want to enforce the patent, you have to go country by country. Sometimes, of course, it was good enough to get an injunction in one of the big jurisdictions because of the kind of product. But some products, if you have an injunction in one jurisdiction, they continue to use the patent or infringe the patent in the other jurisdictions. And now with the UPC, Europe is well, leveling up, getting to the same level like other big markets, but offering to patent owners the possibility to enforce their patent before one court. And well, we already discussed, and then the argument is very often raised that, okay, the downside is it can be attacked centrally, but well, in the US market or in other big markets, you also attack a patent centrally, so that's not a different. So it's it goes both ways. So when you want to have the advantage of enforcing a patent before one court, of course you can also attack before one court. That's a normal thing. So I think that's I hope a fair comparison to the U.S. Situation. And with regards to small and middle-sized companies, there were also raised concerns in Europe about whether this is going to be a court for the big companies, for the rich companies, for the deep pockets. I would not think so, because before 1st of June, at least in Germany, I've seen a lot of litigation, small and middle-sized companies before the German courts. And they had to pay, when you bring a litigation before a German court, you have to pay a quite significant court fee. And now with the UPC, I did at another occasion a comparison with regard to fees. Also court fees, when you litigate the patent, it is less. When you take the same value of litigation, that's the basis for the calculation of court fees in Germany, and it is also the basis before the UPC, and you see what fees you have to pay, you pay less when you have the same value of litigation. So in that regard, I don't see a disadvantage from the perspective of a small and middle-sized companies. There's another aspect to be mentioned, that is the reimbursement of representation costs when you win the case. Because in Europe, that is, I think, a difference from the US system. The winning party can get reimbursed for the costs they have with the litigation, so appropriate costs for representing in the litigation. So this cost shift principle is applicable in Europe, and and there, when you look what fees can be reimbursed, then they are quite high also compared to the German numbers. But these numbers are ceilings, so it does not necessarily mean that you have to get the full numbers that you can see as a reimbursement. So also in that regard, I would suggest to wait and see how this will develop. And what was the other question? Sorry, I forgot one, I guess.
I forget too, please. What was it, the second question? You answered the last question, right?
Yes, yeah.
What is the second question exactly?
Yeah, actually, my second question is, is there any different interest or benefit in adopting UPC between the large company and small company? And the second one, and the third one is European and foreign companies. Is there any difference between them?
No, there's no difference between European and foreign companies, no.
Thank you for your explanation.
Okay.
Thank you.
Excellent. Next question, please raise your hand. Okay, okay, the right corner, please, go ahead.
Okay, thank you for your outstanding presentation. And my name is Sang-Hyun Lee, Korean attorney of Beck, Kim & Lee, LLC. This might be a little bit minor or specific question. And it is very interesting for me that the current UPC system now recognizes the possibility of conflict with the EPO proceedings. So, do you have any legal ground that the UPC can stay its own proceedings due to the EPO proceedings?
Well, the UPC can stay. Yeah. And as mentioned, one important aspect, whether to stay or not to stay, will be whether a decision in opposition proceedings or appeal in opposition proceeding can be expected very soon, or whether it takes some time. The UPC panel also has the possibility to ask for expedited proceedings in opposition proceedings. So that may be another way to deal with the situation. Of course, that should be done at an early stage of proceedings. So when you, for example, expect a revocation action to take 1 year, then it would be make sense if such a request from the UPC to the EPO, to the boards of appeal, or to the opposition division is issued at early stage. And EPO is very willing to expedite cases if such a request comes from the UPC.
Okay, next question. Okay, go ahead, please.
My name is S.W. Han, the attorney from Kim and Cheng law firm. And very quick question for the permanent injunction requirement. So your slide 20, page 20 has the explanation of no eBay test, US style, but the injunction has to be proportionate. So I understand that in the past, German court, like the Düsseldorf Munen, has a tendency to issue the injunction without considering the eBay test, as you explained. But under the UPC system, do you have any cautious expectation or insight on the direction of the UPC court for the permanent injunction requirement, if any? Thank you.
Yeah, maybe with regard to eBay requirement, this is part of the US law. As I understand, it is a part of the equity concept of injunctive relief. The system in all currently 17 contracting member states, they have a civil law background.
Okay.
So they simply don't have the system of equity. But what is existent and has to be respected is the principle of proportionality. This is part of the enforcement directive. In Article 3, paragraph 2, it is mentioned all means, and this includes injunctions, have to be proportionate. At the same time, it should also be mentioned, however, that of course this has to be argued by a party. If it is not argued, the court has no need to worry about proportionality, because in principle, when the court finds, yes, that the patent has been infringed, and the patent is an exclusive right, then I would think it is a natural consequence that a person who infringes an exclusive right has to be stopped continuing with the infringement. And only when this is disproportionate, then the court may either wait with stay the injunction for some time, or even don't issue an injunction at all. But these are exceptional cases. So there has to be an extra harm. Well, normally an injunction is a harm to a party. That's clear. But it is to stop an unlawful situation. So only if this then causes an extra harm which goes beyond the normal harm that is concerned, then I think the aspect of disproportionality comes into play. But we have to wait and see how this boils down in very precise situation. But one, of course, is a very classical situation that actually was a case from the UK. It concerned a hard valve. And there was only the product of the infringing product on the market, and then the argument, and this was the finding of the court in this case, was that a certain group of patients, if you stop issuing the hard valve, then surgeons were not able to implant a hard valve so a certain group of patients as it should be, and there was an alternative, but the surgeons were not trained to use the alternative, at least for some time. So the decision was, okay, you can continue selling the hard valves until the surgeons are able to implant a new one, which was a good alternative. And this kind of situation, of course, would fall under the requirement of proportionality. And then you, of course, can discuss this proportionality here.
Yes, great. No debate does not mean that, automatic injunction, right? Yeah, so you have proportionality and balancing interest, of course, public interest. Yeah, that's pretty persuasive. And another question? Maybe you can take one last question. Okay. Thank you. Go ahead, please.
My name is Ki-jung Kang. I'm from also BKL Korean law firm. Thank you for the great presentation. I want to ask about the protective letter issue. As you may know, what I'm talking about.
마이크 다시 켜주시죠.
Hi, thank you. As you know, that protective letter system is originated from Germany, but the UPC decision is a little different. It seems a little different because the defendant submitted the protective letter, but the court said that it is not sufficient. So they issued the ex parte preliminary injunction, I think, yeah. What do you think about that? That might be the UPC law, will be the UPC standard about the protective letters?
Yeah, maybe if I explain protective letter a bit, what the concept is.
So you should explain what is protective letter.
Yes.
It's from German practice?
Yes.
Okay.
Yes.
Please.
Well, the idea is it addresses a situation that there is a request for a preliminary injunction in an ex parte proceeding. And so you only hear the one party that is requesting the preliminary injunction. But of course, as a judge, you should always try to get also the other party heard. And one way of having the other party heard is the protective letter. So when the other party has the feeling, okay, the patent owner may go to court and ask for a preliminary injunction, we want to be prepared and we want to be heard. And for that purpose, you can, like a preemptive submission, you can file a protective letter with the court in the register, and there your line of argumentation is outlined. So you say, okay, you should not issue a preliminary injunction because I'm not infringing and the patent is not valid because of this prior art and so on. This is normally on the background of a discussion between the parties that has already been happened outside of the court. Okay, and then the request really comes for the preliminary injunction, and the judges are, the registry is supposed to do so. They check, is there a protective letter, and they say, okay, yes, there is a protective letter. Then it is forwarded to the judge, and the judge reads the request for a preliminary injunction, and of course also reads the protective letter, and then forms the view on the case. And now also this way, having also heard the other party. And then the judge has to answer a few questions, I guess. The one is, well, do I still want to decide on what I read in the protective letter ex parte? That may be the first one. You can see, okay, the arguments, I don't know exactly about this, but at least I want to now to have a hearing, or at least hear the other party again.
Okay, all right.
So that could be one reason to have this protective letter. Or the judge says, okay, the arguments are so good, I deny the preliminary injunction. Or third possibility, well, they are not convincing at all. They brought the arguments, but they are not convincing at all. I issue the ex parte preliminary injunction. So that can be these are the three ways how to handle with the situation.
Yeah, is it officially adopted in UPC? Or?
Yes, it is.
Okay.
Yes, it is. This is particularly relevant in cases where it's really very urgent cases. For example, you have a trade fair. It is the trade fair duration of the trade fair is 4 days. on day 1, they discover the alleged infringement. On day 2, they file the request for preliminary injunction. Then it gets to the court, and they cannot get in contact with the other parties, and it's very urgent because all the deals are made on the trade fair, for this situation, this would be a typical situation where protective letter would make sense.
Most of cases is recommendable, but when you have bad feelings when you visit. All right. Okay, so I said last question, but we have 1 minute. If you have one more question, I will take that. All right. Okay. Thank you.
My name is Doksun Chang, a lawyer at Kim & Chang here in Seoul, Korea. My question relates to how to enforce or execute the remedies or judgment granted by the UPC in an infringement action. I agree that the UPC is very effective in that the remedies will be given effect in 17 countries out of 27 EU member countries. But I understand that each country has different systems in terms of how to enforce or secure the compliance of the court's order by the losing defendant. So, for example, if the losing defendant is located in France, I'm wondering whether the UPC has the harmonized enforcement system as well, or the enforcement would be subject to the local law or procedures for the enforcement of the civil judgment.
Thank you. So it depends a bit on what you're going to enforce. If it is an injunction, then the way how to enforce it is that when you don't respect the injunction, then then the other party can come back to the court, and they come back to the UPC and ask for penalty payments because so this is decided by the UPC, and then only when if they were ordered to pay penalty payments, and then they are not going to pay, then of course you have to go to the national system and enforce this request for payment. A different situation is, for example, when we speak about seizure, because seizure is not about payment. It is really about enforcing physically an order of the court. And when we talk about seizure, then my recommendation, well, the court, it depends a bit on what the request of the lawyer, of the representative is. So the representative should know under which conditions seizure is enforced in France, in your example. And then should draft the request respectively, and then convince the court, okay, it is the way how it's done in France, and then the court will follow, and then they can enforce it in France as a judgment of a French court, because, as I mentioned already, the UPC is also a French court. It's a German court, a French court, a Dutch court. So this principle applies.
Okay, thank you very much. Thank you for all your insightful questions. The clock stops means we passed the time. And I'd like to again express my sincere gratitude, Dr. Grabinsky, to sharing your insight and your perspective with us today. Your presence really makes this session exceptional, and I firmly believe that the UPC will be the model court for all IP courts all over the world. Thank you very much.
Thank you. I'm sure everyone in this place got some insights and deeper knowledge about Unified Patent Court through this session. Let's give a big round of applause again. Thank you so much. We'll now take a break, which is always a good thing, and we'll begin the third session at 3:20 p.m. Please return to your seats before then. Thank you.
하나 둘 테스팅 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 네. 말씀해 보세요. How are you?
然后我们再看一下现场的音响能不能听到。이거 꺼도 돼? 喂，法官您好，还能听到吗？
听到了，听到了。你听到我说话吗？
啊，可以听到，可以听到。麻烦您继续再说一下，以免我们这个音响出问题。
就是我的问题就是说，到时候主持人应该会有一个引导，就是说下面就是中国的这个法官进行发言，他会这么讲。英文。
맞아요. 안 한대요. 就是事情是这样子，这昨天也说过的，我们这边就是主持人他会用英文跟你讲，然后到时候跟你问一下，就是中国方的一些立场啊，或中国方的回答会怎么样的，他会用英文跟你提出问题的。
那个还有一个问题，
请说。
委员您在吗？就是说到时候主持人会在他之前给我们发的一些问题当中挑选一个问题让我回答，是这个意思吗？
稍等一下啊。就是您想说的问题，就是是不是要把所有的问题都回答，还是怎么样的？
对，因为他之前给到我们的那个 email 里面，比如说 question 1，它就有很多个小问题，1、2、3、4、5、6、7，7个小问题。然后呢，然后就是到时候那个主持人他是需要我回答所有的问题，还是说他会挑其中一个问题来问我？
稍等一下啊。판사님. 손 판사님. 혹시 중국 쪽에다가 질문을
이제 테스트는 끝났으니까 요
네, 잠시 후 3세션을 시작하겠습니다. 여러분께서는 모두 입장하셔서 자리에 착석해 주시기 바랍니다. Please sit in. 네, 잠시 후 3세션을 시작하겠습니다. 여러분께서는 모두 입장하셔서 자리에 착석해 주시기 바랍니다. Ladies and gentlemen, we'll begin session 3 in just a few minutes. Please be seated. 네, 잠시 후 3세션을 진행하도록 하겠습니다. 모두 입장해 주시기 바랍니다. 네, 잠시 후 3세션을 시작하겠습니다. 모두 자리에 앉아주시면 감사하겠습니다. 네, 감사합니다. 이제 3세션을 시작하도록 하겠습니다. 3세션의 주제는 영업비밀 침해소송의 주요 쟁점으로서 특히 영업비밀의 공동보유자 문제, 심리 절차상의 특수 문제 등에 대해서 다룰 예정입니다. 진행은 임영우 특허법원 고법판사님께서 맡아주시겠습니다. 큰 박수 부탁드립니다.
예, 안녕하십니까. 방금 소개받은 특허법원의 임영우 판사입니다. 영업비밀 침해 소송의 주요 쟁점에 대해서 세계 최고의 전문가분들께 고견을 청하는 역할을 맡게 되어 개인적으로 무척 영광입니다. 영업비밀의 중요성이 날로 커져가고 있고 영업비밀 침해 소송이 점점 복잡해지는 가운데 세계 주요 국가들의 실무를 알아보고 그 차이점을 살펴보는 것은 대단히 유익할 것입니다. 오후 4시 40분까지 예정된 3세션 시작에 앞서 패널 분들을 패밀리 네임의 알파벳 순서에 따라 차례로 소개해 드리겠습니다. 청중들께서는 박수로 환영해 주시기를 부탁드립니다. 예, 먼저 미국 일리노이 연방법원의 에드먼드 챙 판사님이십니다. 일본 지적재산재판소의 히로아키 이마이 판사님이십니다. 와이포의 안드로아시 요쿠티 국장님이십니다. 독일 에스캅의 시바르츠의 크리스토프 비간트 변호사님이십니다. 중국 광동성 고급 인민법원의 단예 판사님이십니다. 단예 판사님은 온라인으로 참여해 주셨는데요. 한 가지 양해 말씀을 좀 드리면 한국과 중국 사이의 네트워크 상황이 여의치 않아 혹시 온라인 연결이 원활하지 않을 수 있음을 미리 말씀을 드리겠습니다. 이어서 서울고등법원의 김강남 고등법원 판사님이십니다. 마지막으로 대정지방법원의 박은희 판사님이십니다. 네, 그러면 3세션은 각국의 영업비밀 보호 법제에 대한 개관, 또 영업비밀에 대한 와이포의 정책, 영업비밀 공동보유자 사이의 침해 문제, 마지막으로 영업비밀 침해소송의 절차적 문제 순서로 진행될 예정입니다. 논의에 들어가기에 앞서 각국의 패널들께서 저희가 준비하신 모든 질문에 대해 전문적이고도 상세한 서면 답변을 보내오셨습니다. 상세한 답변을 주신 패널 분들께 깊이 감사드리고 그 내용은 영문과 또 번역문으로 자료집 속에 있음을 알려드리겠습니다. 저희 3세션에 주어진 시간이 약 80분인 관계로 패널들에게 발언 시간을 가능한 많이 드리기 위해 제가 각 소주제별로 질문을 통합 요약하여 한 번의 질문을 드린 다음에 각 패널들로부터 답변을 듣는 순서로 진행하겠습니다. 패널들의 답변 순서는 앞서 소개드린 것처럼 패밀리 네임의 알파벳 순서에 따라 답변을 듣겠습니다. 자료집도 비슷한 방식으로 질문과 답변을 편집해 두었습니다. 청중들께서는 세션 진행에 맞추어 자료집을 참고하시면 도움이 될 것 같습니다. 네, 그러면은 첫 주제부터 시작하겠습니다. 대부분의 나라에서 영업비밀을 보호하고 있지만 그 구체적인 보호의 방법, 또 보호의 수준, 나라별로 차이가 분명히 있습니다. 따라서 영업비밀 침해 소송의 구체적인 실체적, 절차적 쟁점을 다루기 전에 영업비밀 보호에 대한 각국의 법제를 개괄적으로 살펴서 그 공통점과 차이점을 이해하는 것은 중요할 것이라고 생각됩니다. 각국의 패널 분들께 자국의 영업비밀 보호 법제의 개요와 최근의 변화, 그리고 주목할 만한 판결의 소개를 부탁드리고자 합니다. 패널 한 분당 4분 정도의 범위 내에서 발표해 주시면 감사하겠습니다. 그러면 먼저 에드먼드 챙 판사님 발표 부탁드립니다.
Okay, thank you very much, and thank you, Chief Judge Kim, for convening this conference, and to Judge Lim for organizing us and putting the time limits on us. So we will have to move quickly, and thank you to the fellow panelists. It's an honor to be here as well. I do also want to thank, last but not least, very quickly, the interpreters who have a very difficult job with simultaneous interpretation. So if the New Yorker in me comes out and I speak too quickly, please wave or shout at me or throw something at me and I will try to slow down. In the United States, trade secret protection arises primarily by statutes, both federal and state. And these statutes protect non-public information that derives its economic value from the very fact that it is secret. It's true that there can be private arrangements between corporations and corporations and individuals to protect confidential information. So we do see sometimes in trade secret cases contract claims as well. but primarily it really is statutes that govern and protect trade secrets in the United States. And the protection is quite robust. In 1996, Congress passed the Economic Espionage Act, and that applies for federal criminal law enforcement. Espionage sounds like James Bond spy, but it applies also to trade secret theft. And there is a maximum penalty of 10 years imprisonment for criminal theft of trade secrets. For federal civil enforcement by private parties, the Defend Trade Secrets Act, of course, was passed in 2016. And that added a provision to the Economic Espionage Act that allows for private parties to bring a civil lawsuit in federal court to protect a trade secret, so long as the trade secret is related to interstate commerce, which it almost always is. So now there is federal court jurisdiction to protect trade secrets. And the protection is quite robust. The trade secret owner may recover actual loss and unjust enrichment to the unjust enrichment that the defendant received from the theft, or the trade secret owner can obtain a reasonable royalty as well. And in cases of willful theft of trade secrets, the punitive damages are allowable as well in the United States system. I should also point out that for the state statutes, there is a Uniform Trade Secrets Act. The Uniform Trade Secrets Act was drafted by a commission of nonpartisan lawyers who wanted to promote trade secret protection in state courts. And this Uniform Trade Secrets Act has been very successful. 47 states have adopted it so far. So you do find state trade secret cases as well. To qualify as a trade secret, of course, the information does need to be non-public. As I said before, derives its economic value from its secrecy, and the trade secret owner must make reasonable efforts to protect the trade secret. What types of acts constitute infringement? Of course, acquisition, obtaining the trade secret by someone who knows or has reason to know that the trade secret was obtained by improper means, and that, of course, is misappropriation. And it is also misappropriation to disclose or use a trade secret if that person who uses or discloses the trade secret, again, has obtained it by improper means or has reason to know that it has been obtained by improper means. Civil actions are much more common than criminal prosecutions, and these typically the Defend Trade Secrets Act cases are, of course, brought in federal court. And I should point out that there is no specialized court for trade secrets. Trade secrets are, they're like the fourth favorite child of intellectual property law, patent, trademark, copyrights, and now trade secrets. But so we have no specialized courts for trade secrets. Each year there's only around 10 to 15 criminal prosecutions under the Economic Espionage Act. So it is not frequently prosecuted. I did prosecute one when I was a federal prosecutor many years ago over some software, but it is very rare, and I only prosecuted the one case. Under the Federal Defend Trade Secrets Act, 1,000 to 1,400 cases are filed each year. So obviously many, many more federal civil cases are filed under the Defend Trade Secrets Act compared to the Economic Espionage Act. Thank you.
네, 감사합니다. 그다음에 이어서 히로아키 이마이 판사님 발표 부탁드립니다.
Okay, thank you very much. This is my great honor to go back again here. I will explain Japanese situation. In Japan, Unfair Competition Prevention Act, hereinafter UCPA, protects trade secrets. Article 2, paragraph 6 of the UCPA defines the trade secrets as technical or business information that is, first, kept secret, secrecy management has to be done. Second one, useful for business activities, for example, methods of manufacturing or marketing. So that's usefulness. And the third one, not publicly known, non-public domain. All three requirements are necessary in order to secure legal protection. Article 2, paragraph 1, item 4 to item 10 of the UCPA defines a trade secret infringement as an unfair competition. That is too long, so I'd like to explain two types. Items 4, acquisition of a trade secret by theft, fraud, duress, or any other wrongful method or use of disclosure of trade secret acquired through wrongful acquisition. The same, that is the first I would like to explain as an infringement act of unfair competition. The second one is item 7. I will explain later as a co-holder of the joint holder of the trade secret. Item 7 explains use or disclosure of the trade secret disclosed by the business operator holding such trade secret, hereinafter referred as a holder, for the purpose of acquiring an illicit gain or causing injury to such holder. Now, I'd like to go on to the remedies. The first remedy is civil remedies. Possible civil remedies are the right to claim damages in tort, the right to seek measures to restore credibility in tort, the right to claim for restitution of unjust enrichment, and the right to seek injunction. Injunctions are available to eliminate present and future infringements. These remedies can be sought separately or together, and a holder of the trade secret may consider what remedy or remedies will most effectively cure the wrongful acts that the infringer has done. The second one is criminal punishment. Infringer of the trade secret is subject to imprisonment with labor and not exceeding 10 years, a fine not exceeding Japan yen 2,000. How much is that? I have noted that. And the third one is administrative remedies. Customs Act prohibits the import and export of goods that compose the acts set forth in any of Article 2, Paragraph 1, Item 10 of UCPA. And we don't have specialized code for the trade secret lawsuits. That doesn't exist. The number of the unfair competition lawsuits that includes other than unfair competition cases filed at this district court in the year 2021 is 117. We don't have any specific statistics on the trade secret dispute. And the recent changes and notable cases. Recent changes, I have already noticed that the third time revisions of UCPA. I'd like to explain the final revision of 2023. This revision clarifies the jurisdiction of an international trade secret infringement case. A provision has been established to apply Japanese UCPA to cause where an infringement of a Japanese company's trade secret outside of Japan, allowing a Japanese court to take action. However, this provision does not apply if the trade secret is exclusively used for business purposes outside of Japan. And that is my explanation. Thank you.
예, 감사합니다. 이어서 크리스토프 비간트 변호사님 발표 부탁드립니다. 준비하신 PPT를 활용해서 발표하실 수도 있습니다.
First of all, thank you very much for having me at your conference and giving me the opportunity to speak at this today. I want to focus on trade secret protection in Germany, and just wanted to give you an overview about the trade secret protection in Germany as well. So, German trade secret protection is subject to the German Trade Secrets Protection Act, which implements the EU directive, and therefore we have harmonized European law, and national acts need to be interpreted in the light of the European directive. It is still an important topic for German companies, and to be honest, I'm not sure if all firms already be aware of the recent development in this field of law. To qualify as a trade secret, you need to fulfill some requirements which have to be cumulative in place and are determined by the EU law and the GTSPA. So first of all, the information should not be generally known, and the holder of the secret information should have an interest in the secrecy. But the most important prerequisite in praxis is the necessary reasonable secrecy measures, because only the person who actively protects the secret information enjoys the protection of the legal system. So what we can understand as a reasonable secrecy measure is not determined by the GTSPA or the EU directive. So, and it's still partly terra incognita and constantly subject to recent case law. Nevertheless, I want to give you some examples and some overview about reasonable secrecy measures, what we know so far. So generally, the more important a trade secret qualifies, the stronger the secrecy measures have to be adopted. And there is no optimal solution required, but you should adopt multiple measures. So in the end, reasonable secrecy measures depend on the situation and on the trade secret itself. And just to give you a few example criteria. So
other judges should share the microphone or something. Thank you.
Okay, it's working again. Thank you. So the criteria could be the value of the trade secret and its development costs, nature of the information, the importance for the company, the size of the company, and the usual secrecy measures of the company. So we can divide the measures in organizational ones, in legal ones. So on the organizational side, I would say sensitive information have to be kept locked away. You should adopt a need-to-know principle and to document your secrecy measures. And these organizational measures are linked to the technical ones. So the electronic access barriers should be adopted, passwords, IT security measures. These are just a few examples what you should do. And on the legal side, confidentiality clauses, NDAs, confidentiality clauses in employment agreements. But recently, some German courts decided that catch-all clauses are non-transparent, and therefore we have invalid clauses. So just a few words about three categories of trade secret infringement. The GTSPA provides for civil and criminal remedies. So general civil claims are claims for injunctive relief, removal, destruction, withdrawal from the market, information, or compensation. And subject to the GTSPA is the unlawful conduct which comprises unlawful acquisition, use, and disclosure. What you should consider is that the GTSPA allows reverse engineering.
예, 감사합니다. 그러면 이어서 중국의 단예 판사님 연결해 보겠습니다. 단예 판사님 발표 부탁드립니다. Judge Ye, I'd like to ask your opinion on topic 1.
Thank you very much. Good afternoon, everyone. It's a pleasure to be here to share our perspectives of China's IP work. Nowadays, China attaches more and more importance to the protection of trade secrets. Anti-unfair competition law governs the protection of trade secrets, and there is also a judicial interpretation issued by the Supreme People's Court for trade secret infringement cases. This interpretation is known as the rule concerning the application of law, trial of civil cases involving infringement upon trade secrets. The latter one is the newest judicial interpretation for the court's application according to the trade secret infringement cases. It came into force on September 12, 2020. In China, trade secrets are protected by the courts as a form of legal interest for ensuring fair competition. This differs from exclusive rights such as copyrights, commercial trademarks, and patents. Article 9 of the Anti-Unfair Competition Law provides a definition of trade secrets. According to this law, trade secret means technical, operational, or other commercial information unknown to the public and holds commercial value for which the holder has taken corresponding confidentiality measures. Therefore, for certain information to qualify as a trade secret, it must meet 3 legal requirements. 1 is it must not be public known. 2 is it must have commercial value to the holder. And the 3 is the holder must have implemented measures to keep it confidential. The judicial interpretation by the Supreme People's Court further clarifies the legal definition of trade secret. Article 1 of this interpretation stipulates that, firstly, a court may determine the information on structure, raw materials, components, formulas, materials, samples, styles, propagation materials of new plant varieties, processes, methods of their steps, algorithms, data, computer programs, and their relevant documents, among others, relating to technology as technical information. Secondly, a court may determine the information on creativity, management, sale, finance, plans, samples, leading materials, science information, and data, among others, related to business activities as business information. Thirdly, about the client information includes a client's name, address, contact information, and trading practices, intention, intent, and other information. According to the law and the judicial interpretation, the acts below are considered as trade secret infringement. 1 is acquiring a trade secret from the holder by theft, bribery, fraud, coercion, electronic intrusion, or any other illicit means. 2 is disclosing, using, or allowing others to use a trade secret acquired from the holder by any means as one specified. 3. disclosing, using, or allowing others to use a trade secret in its possession in violation of its confidentiality obligation or requirements of the holder for keeping the trade secret confidential. 4. Beating a person, attempting or aiding a person into or in acquiring, disclosing, using, or allowing others to use the trade secret of the holder, violation of his or her non-disclosure obligation or the requirements of the holder for keeping the trade secret confidential. Article 17 of the Anti-Unfair Competition Law stipulates that a business causing any damages to another person in violation of this law shall assume legal liability according to the law. A business whose lawful rights and interests are damaged by any act of unfair competition may institute an action in the court. The amount of compensation for the damage shall be determined as the actual loss of the business or the benefits acquired by the tortfeasor. The amount of compensation shall also include reasonable disbursements made by the business to prevent the infringement, such as the attorney's fee. If the infringement is too serious, the tortfeasor will be imposed a criminal punishment of 3 years below or 3 to 10 years penalty up to the serious degree. In China, there are 4 specialized courts for IP cases, including trade secret cases. They are in Beijing, Shanghai, Guangzhou, and Hainan. Also, there are 26 specialized tribunals set in intermediate people's courts around China, which have the jurisdiction for trade secret cases. The high people's courts are the appeal courts for those cases. So far, we don't have a complete statistic on trade secret infringement cases nationwide. That's all. Thank you.
땡큐 저지에 이어서 김광남 판사님 발표 부탁드립니다.
서울고등법원 김광남 판사입니다. 멋진 분들과 함께 3세션을 하게 되어 기쁘고 또 평소 존경하던 분들 앞에서 한국의 영업비밀 제도를 소개해드리게 되어 매우 영광입니다. 한국은 1991년 부정경쟁방지법을 개정하면서 영업비밀 보호 규정을 갖추게 되었습니다. 영업비밀을 보호하는 방식은 크게 특허권과 같이 배타적 권리로 인정하는 보호 방식, 그리고 특정 유형의 영업비밀 침해 행위를 불법 행위로 규율하는 방식이 있습니다. 한국은 행위 규제형 보호 방식을 선택하였고 통상 민법상 불법 행위의 특수한 형태로 보는 것이 일반적입니다. 먼저 영업비밀에 관한 부정경쟁방지법 규정을 살펴보겠습니다. 먼저 정의 규정입니다. 영업비밀로 인정받기 위해서는 다른 국가들과 마찬가지로 비공지성, 경제적 유용성, 비밀관리성 요건을 충족하여야 합니다. 다음으로 영업비밀 침해 행위 규정을 두고 있는데요. 영업비밀 부정취득, 공개, 사용 등을 침해 행위로 규정하고 있습니다. 민사적 구제 방안으로 금지 청구, 손해배상 청구, 신용회복 청구가 있고 이 외에도 형사처벌 규정이 있습니다. 보시다시피 영업비밀에 관한 규정은 많지 않고 그 구조도 매우 간단합니다. 영업비밀에 해당하는지, 침해 행위에 해당하는지, 그리고 손해액이 얼마인지만 살펴보면 될 것 같습니다. 하지만 영업비밀 사건은 생각보다 쉽지 않습니다. 저 개인적으로는 IP 사건 중에 가장 혼돈스럽고 어려운 분야 중 하나가 아닐까 생각합니다. 바로 이런 느낌입니다. 굉장히 혼돈스럽죠. 사건 유형이 너무나도 다양하고 어떤 사건은 영업비밀이 특정조차 안 되는 경우도 있습니다. 저도 한 사건에서 1년 가까이 여러 차례 변론기일을 진행하고 성명준비 명령을 수차례 보냈음에도 끝내 영업비밀이 특정되지 않은 사건도 있었습니다. 결국 당당하게 후임자에게 넘겨주고 다른 법원으로 갈 수밖에 없었는데요. 최근에 살펴보니까 잘 처리된 것 같습니다. 마지막으로 한국의 영업비밀 보호제도의 최근 변화에 대해서 알려드리도록 하겠습니다. 예. 먼저 비밀관리성 요건을 2차례 완화한 바 있습니다. 최초 입법 시에는 상당한 노력으로 비밀로 관리할 것을 요구하였으나 2015년 개정으로 상당한 노력을 합리적인 노력으로 완화하였고 2019년 개정에는 합리적 노력이라는 문구조차 삭제하였습니다. 2019년에는 증액배상 제도가 도입되었습니다. 즉 영업비밀 침해 행위가 고의적이라고 인정되면 법원은 3배까지 증액하여 손해액을 산정할 수 있습니다. 형사처벌 규정을 최근 대폭 강화했습니다. 징역형 상한을 국내 침해 행위의 경우 5년에서 10년으로 해외 침해 행위의 경우 10년에서 15년으로 상향하였고 벌금형의 경우 더욱 드라마틱하게 높였습니다. 국내 침해 행위의 경우에는 5천만 원에서 그 10배인 5억 원으로 해외 침해 행위에 대해서는 1억 원에서 그 15배인 15억으로 상향한 것입니다. 최근에 이런 변화들은 모두 영업비밀의 보호를 강화하기 위한 일련의 조치라고 생각됩니다. 감사합니다.
예, 모두 수고하셨습니다. 그러면 다음 주제 영업비밀에 관한 와이포의 정책에 대해서 알아보도록 하겠습니다. 와이포가 영업비밀과 관련해서 그동안 해온 활동 또 앞으로 추진하고 있는 정책 방향에 대한 소개를 안드라시 요쿠티 국장님에게 부탁합니다. 요쿠티 국장님께서 사전에 보내주신 PPT 분량이 상당히 많은데요. 지금 조금 시간이 지체돼서 한 13분 정도 범위 내에서 발표를 부탁드립니다.
Thank you so much. I share the sentiment of my fellow panelists about the honor of being here. Because I only have 13 minutes, I will cut to the chase, and I hope I will not fall victim to the squid game of microphones that we have here. So the little misunderstanding relating to the title of my presentation is a good springboard for me to start the presentation. I was asked to talk about WIPO's policies, but actually WIPO as an international organization does not have a policy on trade secrets, but we have a perspective, and that is consisting of a new focus on trade secrets and also a set of activities that WIPO is pursuing in the area of trade secrets. But first, what is really WIPO? What is WIPO? It's a United Nations specialized agency. It's an international organization with 193 member states. It does not grant IP rights per se, but it has the mission of promoting and developing intellectual property rights for the benefit of all countries and to foster innovation and creativity. Now, why am I highlighting this? Because WIPO as an international organization has this hive mind of 193 member states, and the International Bureau, where I'm working, is like the beehive itself, where the bees reside, and it is the supporting organ of WIPO as the international organization, serving as the secretariat to the meetings of the member states, and also serving as the operational arm of the institution for the functioning of the global services, such as the operation of the PCT system. So in this context, we do not have policies because the policies are made by the member states or the regional organizations of the member states, but we do have a focus and we do have a set of supporting activities that could make the policy discussions around trade secrets more dynamic and raise the understanding around this topic in each and every member state of WIPO. So, where is it? So WIPO's new focus in the trade secrets area came a couple of years ago. Even though trade secrets have very different roots in the different legal systems and the different jurisdictions, as we could hear today, trade secrets have found their way to the set of IP tools that are available to businesses. And this is, of course, also due to the fact that the TRIPS agreement, that is an annex to the agreement on the World Trade Organization, specifically requires the member states of the WTO to cater for the protection of trade secrets in the member countries, excuse me. Now, WIPO is trying to be a better parent than that one that Judge Chang just mentioned, and WIPO does not rank IP rights. And WIPO should not also be perceived as kind of a patent or a trademark factory, but WIPO is really works towards making available the IP tools to everyone, everywhere, and raise the understanding around these topics. Now, the role of trade secrets in innovation, and also to a growing extent in technology transfer, needs to be explored, and WIPO deploys a couple of activities that serve this very purpose as well. So we have heard from my fellow panelists here that trade secret protection can be approached from very different angles. It can be regarded as something rooting in unfair competition or breach of confidence or protection of personal rights relating to secrecy. But the bottom line is that trade secret protection regimes provide legal recourse against misappropriation of undisclosed information that is somehow well guarded. The reasonable steps have been taken to protect them, and all these characteristics are stemming from the TRIPS agreement. Now, we also see, if we compare trade secrets to patents, that territoriality does not apply to trade secret protection in the same way as it applies to patents. So when there is a trade secret infringement case somewhere, one cannot point to a particular national right that they would like to enforce, but they have to argue their case according to the legal system, according to the legal rules of the country where they go and where they would like to have this litigation happen. So the cross-border aspects of trade secret protection are also in the forefront of attention. Key questions on a policy level often get raised about the limits of trade secret protection, not just the classical ones like reverse engineering or independent development, but whether there are other public policy goals that could somehow justify the curtailment of trade secret protection, and is there some kind of an overriding public interest that would go against granting a strong protection for undisclosed information. Somewhat related issue is to what extent should regulatory test data, so data submitted to marketing approval authorities, be treated as trade secrets? There is a little bit of a confusion in certain regions because the very same article of the TRIPS agreement regulates the classical or the basic trade secret protection, and our paragraph 3 of Article 39 is talking about the protection of regulatory test data, and sometimes these two topics get a little bit convoluted, even though certain regulatory authorities have opted for the disclosure of test data, which doesn't mean that they don't have to cater for the protection of that information that has been submitted to them. So I'm just flagging this issue here. These two things are not the same, even though they are both related to information that where the availability is somewhat limited. Now, trade secret protection also raises very interesting questions relating to research collaboration and technology licensing because of the very differences that have been mentioned by panelists and myself as well. Valuation of trade secrets is also something that is a little bit underexplored and should be discussed more. And of course, the enforcement, this is why we are here, raises very similar issues as well. Now, WIPO's activities in the trade secrets area have intensified in the last couple of years. WIPO has held 2 global symposia, one in 2019, the other in 2022, and of course there are others in the pipeline, not every year, but maybe every 2 or 3 years. We will gather people together from all parts of the world to discuss current topics about trade secrets. We also hold regional events for member states. The latest one was last month in Kyrgyzstan. We do provide legislative assistance to all those member states that request that from the Secretariat, from the International Bureau, if they want to shape their trade secret protection regimes or they want to amend their legal framework to serve their economic interests better, they can come to WIPO and ask for assistance, ask for some kind of coaching in this area so that we can assist them in drafting their legislation in this field. there is, of course, a general awareness-raising activity around trade secrets, a dedicated website to trade secrets, and also through other means. And two examples of these other means are there in red on the slide. One is the Guide on Trade Secrets and Innovation, that is actually financed very generously by the Funds in Trust program by the Republic of Korea. So KIPO is a very good partner for us in the trade secret field as well. I'm very happy to be here. I also had a chance to discuss the state of play regarding this guide with the KIPO colleagues. This is more like a teaser today because the publication itself will come out in the first quarter of next year. There will be a launch event relating to this guide in Geneva and probably online as well. And there is a recently published discussion paper as well, being part of WIPO's COVID-19 response package, which discusses the interplay between patents and trade secrets in medical technologies. It is already available on WIPO's website, and it's a very, very interesting read. If I have time, which I doubt, I might share with you a couple of insights or findings coming from that paper. Yeah, these are the slides that I can very gracefully skip because my colleagues have covered most of the main characteristics of trade secret protection. But I wanted to show you Batman and Robin. I like to compare patents and trade secrets to Batman and Robin. They have very different superpowers. They have very different characteristics. And I also think that there is not enough time to actually explain this metaphor to you. But they do have different policy functions, and there is also a very, very old US Supreme Court decision from 1974, which is actually already discussing the differences between these two protections and why they can actually be applied together and why one does not preempt the application of another on a policy level. The evergreen question about this is whether disclosure of the technological information should be a precondition to any kind of legal protection or not. The Supreme Court in the US in the 70s came to the conclusion that no, this is not necessarily the case, and the two systems can coexist one next to the other, and they can actually have a synergistic effect. Now, of course, the 70s were the 70s, 50 years ago, and there are also new technological developments that we are facing, and these pose challenges to the IP system, and they also pose challenges to the patent system. So trade secrets are resurfacing in this area, and businesses around the world are looking at trade secret protection with a fresh pair of eyes, and they realize that for certain type of information, trade secrets might serve the purpose better than patents. But actually, these two guys should work together and be as synergistic as possible. But their interplay does pose very interesting questions. What are the cases where they operate as alternatives to each other? So, for example, when a startup company has to decide whether they should go the patenting route or whether they should keep some information secret, they can select from the two. When is it when they operate as complements, so the two together should be deployed in the framework of a sound IP strategy, and when are those cases where they are mutually exclusive? And the very good example of this, of course, is the sufficient disclosure of the invention in the patent law area. There cannot be information kept secret that would render the disclosure not enabling to the person skilled in the art. This, of course, doesn't mean that companies or research organizations do not keep some kind of a layer of secrecy over their inventions or their implementation, but at least the core idea, the core inventive concept in an enabling manner should be disclosed in patent applications, and in this area, trade secrets can play no role. I will skip this slide as well. I'm sure that they will all be made available to everyone in the room. This is just a recap of when it is better to go for patents and when it is better to go for trade secrets. This is a slide on the WIPO guide that I mentioned that is going to be published early next year. It's going to be a comprehensive handbook. It will be somewhere between a general awareness-raising brochure and an academic treatise. It will be somewhere in between, 150-page, give or take, and it will contain not only policy-related information, but practical data, practical guidance on trade secret management as well, with annexes such as country sheets, checklists, or specific use cases. And finally, the discussion paper on the interplay between patents and trade secrets in medical technologies. I'm turning to our kind moderator to ask whether I have a couple of minutes to present this, or I will just rely on the audience to read the publication, which has a very good executive summary. So I think maybe it would be just repeating that if I went on with this.
1분 정도 가능하실 것 같습니다.
1 minute. All right. I will go to some key findings. So this is kind of the structure of the paper. And I think I can skip the different innovation cycles in various fields of medical technology and the policy goals that we all know behind the patent system and trade secret protection. These are just some interesting insights that the study has. Where is the interplay between patents and trade secrets plays a special role? Some highlights: clinical trial data. I have mentioned it already. It's something that is the object of heightened attention these days. Limited transparency in drug pricing is also something that might be observed as hindering market forces. And I just have to maybe highlight that as in closing, that the debates around IP and global health are featuring in many cases the effect what trade secrets have in this area. On the one hand, some argue that the limited transfusion of manufacturing know-how, for example, in vaccine technology, is hindering access to life-saving technologies in certain underprivileged markets. On the other hand, the proponents of the IP system say that actually a robust trade secret protection in any country can facilitate and encourage technology transfer because knowledge can be shared under controlled conditions. So I think this is a good closing for my presentation. I really urge everyone to access and read the paper, which also proposes some areas for further research and policy debate. It's really insightful. Thank you very much for your attention.
네, 요코티 국장님 감사합니다. 그리고 제한된 시간 내에 발표하시느라고 고생 많으셨습니다. 지금 요쿠티 국장님 자료를 포함해서 저희 3세션에 참여하신 패널분께서는 사실은 굉장히 자세하고도 좋은 내용이 많은 자료를 보내주셨는데요. 다들 아시는 것처럼 저희가 제한된 시간 내에 진행을 하다 보니 부득이 발표 시간을 좀 제한하게 된 점 다시 한번 양해 말씀을 드리겠습니다. 예, 그럼 바로 이어서 세 번째 주제로 넘어가겠습니다. 예, 다수의 기업과 같이 복수의 주체가 공동 연구를 통해 어떤 기술을 개발하고 이를 영업비밀로 관리한다면 그 기술 정보에 대한 영업비밀은 복수 주체가 공동으로 보유한다고 볼 것입니다. 그런데 영업비밀의 공동 보유자 중 1인이 다른 공동 보유자의 동의 없이 자신이 보유하고 있는 영업비밀을 어떠한 범위에서 사용할 수 있는지가 문제될 수 있습니다. 예를 들어 영업비밀의 공동보유자 중 1인이 다른 공동보유자를 상대로 영업비밀 침해소송을 제기한 경우처럼 영업비밀 공동보유자 사이의 분쟁에서 이와 같은 쟁점이 문제될 수 있다고 생각합니다. 각국의 영업비밀 보호 법제에서 이와 같은 문제를 어떻게 해결하시는지 또 패널들의 의견을 들어보도록 하겠습니다. 패널 한 분당 이 주제에 대해서는 3분 정도 범위 내에서 발표해 주시면 감사하겠습니다. 먼저 에드먼드 챙 판사님 발표 부탁드립니다.
All right, thank you. And I might not even use the 3 minutes, so if I have extra time, I hope I can put it in the bank, Judge Lim, for my other answers. The Supreme Court has not directly decided this issue. We do not have controlling law on this joint ownership issue on trade secrets. Many district courts at the trial level have held that trade secrets may be jointly owned. And this is consistent with the other intellectual favored childs of intellectual property, patent, trademark, and copyright. The Patent Act explicitly, there's an explicit statute, Section 262, entitled 35 of the United States Code, that explicitly acknowledges that there may be joint ownership of patents, and that the joint owners may practice the patent without the consent of the other. Same thing goes for the Copyright Act. The Copyright explicitly acknowledges that there may be authors of a joint work, and the federal law deems them to be co-owners of the copyright in the work. And then when it comes to trademarks, there is not an explicit federal law on joint ownership for trademark, but the U.S. Patent and Trademark Office has for many, many years recognized that joint ventures may jointly own a trademark. So I think it is consistent with the rest of intellectual property and the other categories of intellectual property for there to be joint ownership of trade secrets. But as I said, we have very little precedent in this particular area. Thank you.
네, 감사합니다. 이어서 히로아키 이마이 판사님 발표 부탁드립니다.
First of all, I would like to point out one thing, that the existence of or lack of secrecy management is determined by each company. UCPA uses the concept of the holder I have already mentioned, UPC Articles 2, Paragraph 1, Item 7, and stipulates that management is performed on a company basis. Normally, the establishment of a non-disclosure agreement that identifies the trade secret clarifies the holder undertaking an intent to manage its secrets. UCPA Article 2, Paragraph 1, Item 7 provides that use or disclosure of trade secret disclosed by the business operator holding such trade secret for the purposes of acquiring an illicit gain or causing injury to such holder as the unfair competition. When a corporation's trade secret made by a collaborative research is wrongfully used by another company, for the holder undertaking to claim an injunction or similar disposition on said another company requires that another company is someone to whom the trade secret holder has disclosed the trade secrets as set forth in the article. In cases where Company B was disclosed trade secret by Company A and used it for the purpose of acquiring an illicit gain or causing injury to such holders, causes an unfair competition, Company B may seek an injunction and other sanctions necessary for suspending or preventing the infringement. Patents and trademarks can be jointly owned, and concerning the copyright, when the work is collaboratively created by two or more persons with respect to which the contribution of each person cannot be served and separately exploited, the work is called work for joint authorship. A joint copyright may not be exercised without an unanimous agreement of all the co-owners. So, the infringement and remedies, if Company A conducts an unfair competition, cited UCPA Article 2, Paragraph 1, Item 7, Company B can pursue an injunction of the act and make a claim to destroy things that constitute the act of infringement. In such case, Company A intentionally or negligently infringes on the business interests of Company B through unfair competition is liable to compensate loss or damage resulting therefrom. Criminal action should be occurred. Thank you.
예, 그럼 이어서 감사합니다. 크리스토프 비간트 변호사님 발표 부탁드립니다.
GTSPA defines the term trade secret holder as any natural or legal person lawfully controlling a trade secret. So I would say that this generally allows for the possibility of a joint holdership of trade secrets under German law. Unlike, for instance, patent law or copyright law, there's no explicit regulation of this concept of joint holders of trade secrets mentioned in the GTSPA. However, in the absence of specific agreements, it is deemed that joint holders of trade secrets qualify as co-owners, so-called tenancy in common. Whereas if we have a contractual basis, it is regulated as a partnership, so a community of joint holders. This equals basically the approach for trademarks and patents. Where remedies contractually determined in a partnership, what about remedies between joint holders in a co-ownership? Well, as said, the GTSPA does not provide for any details in such an infringing constellation. It rather stipulates the rights and claims between the trade secret owner on the one side and third parties on the other side. But I would say it is conceivable that a co-owner takes action against another co-owner if he is infringing the trade secret. The co-owner must have the opportunity to defend himself against impairments of the right of use by means of a claim for injunctive relief. But the co-owner usually got legally in the possession of the trade secret, so I would question whether he can be subject to the infringing conduct lying down under the GTSPA. In such constellation, it can be deemed that these needed to be solved by applying general German civil code procedures. So in a case of infringement, each co-owner may sue in his own name for injunctive relief and for payment of damages to all owners, especially or even against other infringing co-owners. It follows from the German civil code provisions that it is generally no infringement committed by a co-owner who uses the trade secret without the consent of the owners. So the trade secret can be used to the extent that the joint use of the other co-owners is not impaired. But a use that permanently excludes the other co-owners is not permitted. And I personally think that this might mostly exclude the right to disclose the trade secret, as this will probably impair the other joint holders. So having said this, and due to this legal uncertainty, I would highly recommend to arrange for any contractual provisions and agreements in order to avoid difficulties on a later stage. Thank you.
네, 감사합니다. 그럼 이어서 중국의 또 단예 판사님 발표 부탁드립니다. Judge Ye, I'd like to ask your opinion on topic 3. Judge Ye, would you please finish your presentation in 3 minutes?
Yes, thank you. Regarding the issue of how to exercise the right by joint owners, the patent law of the PRC stipulates that if there is any agreement between the joint owners of the right to apply for a patent or patent right regarding the exercise of the relevant right, the agreement shall be followed. If there is no such agreement, any of the joint owners may exploit the patent independently or license others to exploit the patent by means of ordinary license. In the case of licensing others to exploit the patent, license fee shall be distributed among the joint owners. Except for the circumstance as described in the preceding paragraph, how to exercise the right needs the consent of all joint owners. Similar provision can be found in the copyright law of the PRC. The copyright of a joint work shall be exercised by the co-authors through consensus. Where consensus cannot be reached and there are no justifiable reasons, no party shall prevent the other parties from exercising rights other than transferring, permitting others exclusive use of, and pledging the copyright. But the proceeds obtained shall be reasonably distributed to all co-authors. Where a joint work can be used separately, each co-author may be entitled to independent copyright the part that he creates, provided that the exercise of such copyright does not infringe upon the copyright of the joint work as a whole. Regarding trade secrets, the Civil Code of the PRC contains relevant provisions for joint health technical secrets. Article 8 and 61 of the Code prescribes that the right to use and transfer the technical secrets resulting from recognition or cooperative development and the method for distribution of the benefits accrued therefrom shall be agreed upon by the parties. Where there is no such agreement in the contract, or such agreement is unclear, nor can it be determined in accordance with the trade practices, the parties shall all have the right to use and transfer the technical secrets prior to the grant of the patent right for the same technical solution. And we also have Article 20 of the interpretation of the Supreme People's Court on several issues concerning the application of law in the trial of cases on disputes over technology contract. Explains that what's the meaning of the parties have the right to use and transfer. That means includes the right of each party to use and license the use of technical secrets to others under a general license without the consent of the other party, and to exclusively enjoy the benefits derived therefrom. If one of the parties assigns the right to transfer of technical secrets to another person or license another person to use the technical secrets in the form of an exclusive or sole license without the consent of the other party's ratification, the assignment or licensing act shall be deemed invalid. All in all, it is the best protection of rights and interests for the joint owners of trade secrets to reach an agreement in advance on the exercise of rights and the distribution of proceeds. That's one. Thank you.
땡큐 저지에. 네, 이어서 김광남 판사님 발표 부탁드립니다.
예, 지식재산권의 공동 부유와 관련하여 상표법, 특허법, 디자인보호법, 저작권법 등에는 보시다시피 여러 규정을 두고 있습니다. 그러면 영업비밀 보호를 규정하고 있는 부정경쟁방지법은 어떠할까요? 예, 없습니다. 예, 다시 한번 저를 혼돈스럽게 만드는 부분인데요. 결국 이는 법원의 해석에 따라 판단될 수밖에 없을 것 같습니다. 이와 관련하여 제 생각을 말씀드리기 전에 영업비밀 공동보유자 사이에 침해가 가능한지 여부가 쟁점이 되었던 서울고등법원 사건을 소개시켜드리고자 합니다. 다만 현재 대법원의 상고심이 계속 중인 관계로 구체적인 회사명이나 어떤 분야의 기술이 문제되었는지는 상세히 말씀드리기 곤란한 점을 양해 부탁드리겠습니다. 예, 원고와 피고 1은 오랜 기간 함께 해왔습니다. 원고는 피고 1로부터 비밀 유지 계약서를 제출받았지만 여기에는 지식재산권에 관한 규정은 따로 없었습니다. 새로운 제품 개발에 있어서도 원고와 피고 원은 협업을 해왔는데요. 예. 원고가 피고 1에게 설계 방향 또는 대략적인 구조를 제시하면 피고 1이 이에 따라 세부 설계를 작성해서 원고에게 보내고 원고가 다시 피드백을 보내는 방식이 무한 반복되었습니다. 원하는 결과가 나오지 않으면 피고 1이 이처럼 새카맣게 타들어갈 때도 있었고요. 때로는 원고가 심하다 싶을 정도로 지시를 해서 피고 1이 새하얗게 불태운 순간도 있었을 것 같습니다. 다행히도 원고와 피고 1은 기술 개발에 성공합니다. 오랜 기다림 끝에 기술 개발에 성공한 원고의 심정은 바로 이와 같았을 것 같습니다. 매우 고무되어 있죠. 하지만 원고 입장에서 매우 놀라운 일이 발생했습니다. 바로 피고 1이 피고 2에게 직접 이 기술을 이용한 제품을 납입한 것입니다. 원고는 매우 화가 났습니다. 부들부들 떨고 있는 게 보이시죠? 매우 화가 났습니다. 그래서 원고는 피고 1, 2를 상대로 영업비밀 침해를 이유로 금지 청구와 손해배상 청구를 했습니다. 1심은 제 피고 1의 영업비밀 침해를 인정을 했습니다. 하지만 항소심은 결론을 달리했습니다. 먼저 서울고등법원은 복수의 주체가 공동 연구를 통해 생산 개발한 영업비밀에 대하여 별도의 약정으로 그 귀속을 정하지 않았다면 그 영업비밀은 이를 생산 개발하는 과정에서 실질적으로 기여한 연구개발 주체에게 공동으로 귀속한다고 보았습니다. 즉 원고와 피고 1을 영업비밀의 공동 보유자로 본 것입니다. 여기까지는 1심과 결론이 같습니다. 하지만 서울고등법원은 영업비밀의 공동 보유자는 영업비밀성을 상실하지 않는 이상 다른 보유자의 동의가 없더라도 영업비밀을 사용할 수 있고 영업비밀 침해 행위에는 해당하지 않는다고 보아서 원고의 피고들에 대한 금지 청구 및 손해배상 청구를 모두 기각했습니다. 영업비밀 공동보유자 사이에 영업 침해 행위가 성립할 수 있을까요? 솔직히 저도 잘 모르겠습니다. 하지만 제가 초반에 말씀드린 바와 같이 한국의 부정경쟁방지법은 영업비밀 보호와 관련하여 권리부여 방식이 아닌 행위규제 방식을 택했습니다. 따라서 권리부여 형식인 특허법과 상표법 규정을 그대로 참조할 수는 없을 것 같습니다. 제 사견으로는 영업비밀의 공동보유자라는 이유만으로 침해를 부정하는 것은 부정경쟁방지법 법문에 충실한 해석은 아닐 수도 있다고 생각을 합니다. 즉 영업비밀 공동보유자라고 하더라도 양자 간의 계약관계 등을 고려해서 공동보유자의 행위가 법문에서 규정한 영업비밀 침해 행위에 해당하는지를 살펴보아야 한다고 생각합니다. 즉 사안에서 피고 1의 행위가 계약관계에 따라 영업비밀을 비밀로서 유지하여야 할 의무가 있는 자가 부정한 이익을 얻거나 영업비밀의 보유자에게 손해를 입힐 목적으로 그 영업비밀을 사용하거나 공개하는 행위에 해당하는지를 별도로 살펴보아야 한다고 생각합니다. 감사합니다.
네, 수고하셨습니다. 그럼 마지막 주제 논의해 보겠습니다. 영업비밀 침해 소송의 경우에 그 쟁점이 복잡하고 또 주된 쟁점이 영업비밀에 관련된 것이라는 점이 증거의 수집이나 증거 조사에 있어서 특별한 절차적 고려가 필요할 수 있습니다. 각국의 영업비밀 침해 사건의 증거 보존 및 증거 수집 절차가 어떠한지, 그리고 영업비밀 침해 소송 절차에서의 영업비밀의 보호 방안 등에 대해 각국의 패널들의 고견을 청해 듣겠습니다. 이 주제에 대해서도 좀 아쉽지만 시간이 많지 않아 한 패널당 3분 정도 범위 내에서 발표해 주시면 감사하겠습니다. 먼저 에드먼드 챙 판사님 발표 부탁드립니다.
Thank you. In civil actions, the Federal Defend Trade Secrets Act does authorize ex parte seizures that are necessary to protect against the disclosure of trade secrets. And a unique feature of this civil seizure ex parte order is that although a private civil plaintiff files a lawsuit and asks the court for this seizure order, the seizure order is actually carried out by federal law enforcement officers. So it is a very serious step to take. And I usually encourage parties to instead, and often parties only ask for a temporary restraining order, which is still ex parte, but it simply directs the defendant to return the trade secret and also destroy any other copies that they may have. And that this way, federal law enforcement is not involved at all. There is always some danger when federal law enforcement arrives at a premises or has to conduct a search. And so most private parties do not ask for the civil seizure order. But it is available, and it is also something, if I have a concern that a defendant has not returned all of the information or all the copies of the information, that I can warn them that the next step is federal law enforcement looking through, for example, your company's servers. And the last thing that most companies want is for federal law enforcement to be reviewing their servers and phones and computers. With regard to evidence gathering, of course, the United States has a very extensive discovery system. And these tools are usually more than enough in trade secrets cases for both sides to develop the claims and then the defenses. And we do have significant discretion to impose various penalties for those parties who are resisting discovery without good cause. We can impose monetary penalties. We can impose negative factual inferences that you are not turning over information, and therefore the court or the fact finder, the jury, can infer that the information is adverse to the party. Or I can even dictate that a fact is established by a discovery violation. So we do have wide discretion in imposing sanctions for discovery violations. For overseas misconduct, the Economic Espionage Act, including the civil provisions of the Economic Espionage Act, explicitly applies to conduct that happens outside the United States if the infringer is a U.S. citizen or a legal permanent resident, or there is just one act of in furtherance of the misappropriation that happened misappropriation that happened overseas. But if there was any act in furtherance of that misappropriation that was committed in the United States, then the defendant can still be found liable for that. So there is some overseas protection in the Economic Espionage Act and the Defend Trade Secrets Act. Protecting trade secrets in court proceedings, it is very difficult. There are no federal rules or statutes that explicitly set forth how detailed the trade secret owner must be in putting the other side on notice of what's being alleged to have been misappropriated. I think most courts, though, balance this need between providing some notice, but the need to preserve the trade secret. So generally speaking, at the pleading stage, at the initial pleading stage, I am only looking for enough information to put the defendant on notice of the allegation. And then as we move through discovery, I might require more disclosure. But if I do require more disclosure, we have certain tools, as I'm sure many nations do, in terms of protecting the trade secrets, including attorney's eyes only provisions, for example. Like the attorney cannot disclose the information to the client, or limit the disclosure to an independent expert, an expert who is not really beholden to either side, and who also signs a non-disclosure agreement as well to try to protect that information. Sometimes it is true that there are abusive litigation or discovery tactics when, for example, the defendant wants more and more and more information about the trade secret. And one way I've been able to push back on that sometimes is to ask the defendant, well, do you treat this category of information as secret that you want from the plaintiff? And often they will answer, well, yes, we do. And so then my reply is, well, then you're asking for confidential information to be turned over, and they bring down the extent of their request. And then lastly, on case management, I'll just point out that I have found it to be generally effective to adopt patent-type litigation rules for trade secrets as well. Balancing the need to preserve the trade secret itself, I have asked trade secret owners to write out claims describing the technology as if they were prosecuting a patent. And I think the lawyers and the clients understand how to describe technology through patent claims. And so once we have that description, then the defendant is on much better notice of what is being alleged to have been stolen. And then at the same time, we also now know what kind of public information we're looking for to see if this is truly a trade secret. And that is like prior art references, in patent claims. So I think linking the two has helped greatly in case management. Thank you.
네, 감사합니다. 이어서 히로아키 이마이 판사님 발표 부탁드립니다.
Concerning evidence preservation and collection, I would like to mention some points. First, obligation to clarify the specific conditions of infringement and pursuing presumptions regarding a person using a technical secret they acquired. The burden to prove trade secret infringement is on the holder of the secret. However, providing infringement will be difficult when the allegedly infringing article is in the possession of the alleged infringe. UPCA therefore provides an obligation and presumption, Article 6 and Article 5/2. Second, order to submit documents. Providing infringement of the right related to the trade secret may be difficult for the holder of the trade secret. Therefore, to reduce the burden of the holder, UCPA provides the order to submit documents, Article 7. If a party does not comply with an order to submit a document, the court may find the adverse party's allegation concerning the details of the document to be true. Third, a presumption of damages. A causal relationship is required between an infringement and damage. According to the prevailing theory, a legal sufficient cause is required and conditional liquidation is insufficient. So, the presumption of damage in UCPA Article 5 outlined above includes a presumption of such causal relationship. Fourth one, the determination of reasonable damages. The burden of proof regarding lost profit is reduced by the presumption under Article 5. However, there is another provision of the damage presumption, Article 9. Concerning the leakage of the trade secret to overseas, there is not specific provisions. So I'd like to go on to the protecting trade secret in court proceedings. To obtain an injunction, the holder of the trade secret must specify the nature of the activities of the infringer to be enjoined. In practice, plaintiff must clarify the contents of the alleged trade secret on the extent to determine whether the contents satisfy the requirements of the condition prescribed by UCPA as a trade secret, but it is not requested to open all. More precisely, in order that the defendant may identify the grounds for that claim, it is required to provide specific information on trade secret and misappropriation, as well as on the conditions required for a trade secret. From a practical viewpoint, a general description could be enough for the defendant to identify the grounds for a claim, and therefore the specific details would need to be disclosed as appropriate in the course of the trial, while taking measures to maintain the confidentiality. Thank you.
네, 수고하셨습니다. 이어서 크리스토프 비간트 변호사님 발표 부탁드리는데요. 지금 시간이 거의 다 돼서 말씀드린 대로 3분 범위 내에서 발표 맞춰주시길 다시 한번 부탁드립니다.
Okay, Let's just a few words about evidence preservation proceedings and keeping trade secrets secret in procedures. I just wanted to point out that the GTSPA does not provide for any specific rulings for gathering evidences. And the GTSPA does also not provide any specific rulings for an inspection claim. So for trade secrets, we need to go to basically general rules. So taking the inspection claim from the German Civil Code and use a so-called independent evidentiary proceeding we have in the German Civil Procedure Code. So the courts in Düsseldorf use this, so it's called Düsseldorf model or procedure, and combine these mechanisms. So we have a procedure hybrid of evidence preservation and for obtaining an injunction, because the independent evidentiary proceeding can only be effective if the object to be inspected is publicly or freely accessible. And in most cases, it won't be like this. So this Düsseldorf model gives us, on the one hand, the possibility for a quick action for the owner of the property right or the trade secret, and on the other side, decouples the direct preservation of evidence from the possible later disclosure of the findings. So the party liable for the inspection is also protected in a justified way for secrecy interests. So the court appoints an expert. The expert provides an expert opinion about the trade secret, and based on this, the court assesses if there is a sufficiently high probability of an infringement. Under German procedure law, you need to specify in a motion on submission for an injunction the infringed form of a trade secret. Otherwise, you really cannot seek a respective convicting court decision. But obviously, the trade secret holder has an interest to keep his trade secrets undisclosed. So the GTSPA provides several rulings to protect trade secrets during civil proceedings. So first of all, the possibility to classify all or part of the information as confidential upon request and application. This and all the other measures are based on discretionary decisions. And even after the conclusion of the proceedings, the obligation to maintain confidentiality remains in force. Breach of the confidentiality obligation is fined and punishable. So the court can also adopt further measures to protect trade secrets, so can limit the access to documents and the oral proceedings to a certain number of reliable persons. But there is one limit. At least one person of each party and their representative has been granted access to these proceedings or documents by the means of the necessity of an appropriate defense.
예, 감사합니다. 이어서 중국의 단예 판사님. Judge, I'd like to ask your opinion on topic 4, and about this topic, would you please finish your presentation in 3 minutes?
Okay. With regard to the submission of evidence, the principle is that the parties should provide evidence through the claims they have made. Firstly, plaintiff needs to prove what the detailed intent in trade secret of its request for protection. Secondly, the plaintiff needs to prove that the alleged infringer has implemented a technical proposal and its main content in trade secret constitutes a substantial similarity. Finally, the plaintiff needs to prove that the defendant had access to plaintiff's trade secrets. At this point, the burden of proof is reversed to the defendant. We will not reduce the burden of proof on the plaintiff just because of the difficulties of proof for the plaintiff. Because in practice, we have also encountered the plaintiff using litigation as a tool to strike the defendant, which is his or her competitor. The court should remain neutral in litigation. We also often encounter some cases that plaintiffs have difficulty in establishing detailed content and trade secret for proof and cannot explain to the court what technology proposal needs to be protected through litigation. Under this premise, the court can only dismiss the claim. If there is a substantial similarity, then it can be determined by the authentication center entrusted by the court, but the plaintiff should pay the fee. In some cases, plaintiffs run the risk of losing because they are unwilling to pay the high cost of an appraisal. In addition, the possibility that the defendant had access to plaintiff's trade secrets may also be more difficult to prove. One case we used to encounter is that the plaintiff has proved detailed content of his trade secret, and there is a substantial similarity. But since the plaintiff cannot prove the defendant has accessed the plaintiff's trade secret by unlawful means, his claim is difficult to obtain support from the court. About the evidence preservation, in China, there is an interpretation about several positions of the Supreme People's Court on evidence in civil procedures involving IP rights. According to the interpretation, a court shall examine an application for evidence preservation filed by a party or interested party in consideration of some factors. For time is up, so I don't want to explain the interpretation in details. And with regard to the issue of overseas leakage of trade secrets, we have not encountered cases in judicial practice for the time being, so we cannot provide views in this regard. Thank you.
Thank you, Judge. 예, 그러면 이어서 우리 박은희 판사님 발표를 부탁드리겠는데요. 시간이 좀 많이 지체돼서 대단히 죄송하지만 양해가 되신다면 한 2분 정도 범위 내에서 발표해 주시면 감사하겠습니다.
소재기 전 증거를 보존하기 위해서는 증거 보존 신청을 할 수 있고 즉각적인 피해 구제를 위해서는 가처분 신청을 할 수 있습니다. 영업비밀 침해소송의 당사자는 증거 수집을 위하여 법원에 문서 제출 신청을 할 수 있고 침해로 인한 손해액의 산정에 필요한 경우에는 자료 제출 신청을 할 수도 있습니다. 영업비밀은 법원의 심리와 상대방의 방어권 행사에 지장이 없도록 그 비밀성을 잃지 않는 한도에서 가능한 구체적으로 특정되어야 합니다. 영업비밀의 특정 여부가 문제된 사안에서 법원은 채권자가 자료 원본 파일을 제출하여 그 내용을 특정하였고 관련 형사사건에서 특허 수사 자문관의 의견서 및 공소장의 내용을 바탕으로 하여 압수되어서 확보된 자료들 중에 추려졌다는 이유로 대상 자료가 법원의 심리와 상대방의 방어권 행사에 지장이 없을 정도로 가능한 구체적으로 특정되었다고 판단하였습니다. 소송 및 증거 수집 과정에서 영업비밀을 보호하기 위해서 침해소송 당사자가 제출한 소속 기록 등에 영업비밀이 포함되어 있는 경우에 상대방 당사자, 대리인 등에게 영업비밀 유지 명령을 할 수 있고 소송 기록이나 판결서에 대한 제3자의 열람, 복사를 제한할 수 있으며 문서 제출 대상 문서인지를 판단함에 있어서 비밀 심리를 할 수 있습니다. 남용적인 소외 제기 및 증거 수집 신청을 방지하기 위해서 문서 제출 신청에 정당한 이유가 있을 것을 요구하고 있습니다. 그 판단에 있어서는 문서가 쟁점 판단 및 사실 증명에 필요한지, 다른 문서로부터 자료를 얻는 것이 가능한지를 고려하고 문서 제출로 인하여 얻게 될 소송상 이익과 피신청인이 있게 되는 침해를 비교 형량합니다. 시간 관계상 축약하여 설명드렸습니다. 자세한 내용은 자료집을 참조하시기 바랍니다. 감사합니다.
네, 박은희 판사님 감사합니다. 수고하셨습니다. 예, 다음 세션 원활한 진행을 위해서 이 정도로 3세션을 마치도록 하겠습니다. 오늘 시간이 너무 짧아 충분한 설명을 못 드린 부분이 없지는 않은데요. 지금 배부된 자료집을 참조해 주시면 감사하겠습니다. 특히 이제 제한된 시간 내에 핵심적인 내용을 효율적으로 발표해 주신 각국의 패널들에게 다시 한번 감사드립니다. 저지 예, thank you for your participation and presentation. Have a nice day. 예, 그리고 긴 시간 동안 현장 및 온라인으로 참여해 주시고 경청해 주신 모든 분들께 감사드립니다. 고맙습니다. 마치겠습니다.
네, 유익한 세션 준비해 주신 모든 분들께 다시 한번 큰 박수 부탁드립니다. 네, 이제 4세션 시작 전까지 잠시 쉬도록 하겠습니다. 4세션은 5시 5분에 시작하도록 하겠습니다. 감사합니다. 예, 예. 네, 잠시 후 4세션을 시작하겠습니다. 여러분께서는 모두 입장하셔서 자리에 착석해 주시기 바랍니다. Ladies and gentlemen, we'll begin session 4 shortly. Please be seated. 잠시 후 4세션을 시작하겠습니다. 여러분께서는 모두 입장하셔서 자리에 착석해 주시기 바랍니다. Ladies and gentlemen, may I have your attention, please? We'll begin session 4 shortly, so please be seated. 네, 잠시 후 4세션을 시작하겠습니다. 네, 감사합니다. 이제 4세션을 시작하도록 하겠습니다. 4세션의 주제는 금지명령의 주요 쟁점으로서 금지명령의 요건, 기준, 내용, 범위, 집행 방법 등에 대해서 다룰 예정입니다. 진행은 우성엽 특허법원 고법판사님께서 맡아주시겠습니다. 큰 박수 부탁드립니다.
네, 안녕하십니까. 오늘 4세션의 사회를 맡게 된 특허법원의 우성엽 판사입니다. 예, 오늘 1세션부터 3세션까지 많은 세션을 들으시느라고 많은 고생을 하셨고요. 드디어 마지막 세션에 이르렀습니다. 조금만 힘을 내시면 행복한 저녁 만찬이 기다리고 있습니다. 네, 저희 세션은 특허권 침해로 인한 금지명령의 다양한 쟁점에 관해 세계 최고의 전문가분들과 함께 논의한 자리를 갖게 되었습니다. 저는 개인적으로 매우 기쁘고 영광스럽게 생각합니다. 세션 시작에 앞서서 4세션 패널분들께 깊이 감사드린다는 말씀을 드리고 싶습니다. 그럼 4세션에 참여하시는 패널분들을 패밀리 네임의 알파벳 순서에 따라 소개해 드리겠습니다. 자세한 양력은 자료집을 참고하시고 큰 박수로 맞이해 주시면 감사하겠습니다. 우선 제 옆에 에드먼드 챙 미국 일리노이 북부 연방지방법원 연방판사님입니다. 예, 그 옆에 리차드 헤이컨 영국 지식재산기업법원 부장판사님입니다. 예, 그 옆에 앉아 계시는 안나 레나 클라인 독일 뮌헨 제1지방법원 판사님입니다. 그 옆자리에 요시아키 시바타 일본 도쿄 지방재판소 부장판사님입니다. 예, 한국에서는 두 분이 패널로 참가하십니다. 먼저 이경은 춘천지방법원 부장판사님입니다. 네, 이어서 권보원 특허법원 판사님입니다. 네, 세션 진행 중에는 통일적으로 판사님으로만 호칭하겠습니다. 예, 그리고 본 세션을 시작하기에 앞서서 특허법상의 금지명령에 관한 간단한 배경 말씀을 드리겠습니다. 금지명령은 특허권 침해로 인한 권리자 보호에 있어서 손해배상과 더불어 가장 중요하고 강력한 구제수단입니다. 대륙법계 국가법원에서는 특허 침해 소송에서 침해 사실이 인정되면 특별한 사정이 없는 한 원칙적으로 침해 금지 명령을 발령하는 것이 주류적인 실무였다고 보입니다. 이와 관련하여 미국에서는 지난 2006년 미국 연방대법원의 이베이 판결 이후 전통적인 형평법상의 4가지 요건 기준에 따라서 금지명령의 발령 여부가 정해지고 있다고 보이고, 독일에서는 지난 2021년 특허법 개정으로 금지명령 조항의 비례성 요건이 새로 도입되었습니다. 이 세션에서는 특허권자의 권리를 효과적으로 보호하되 그 권리 범위를 넘는 과도한 보호가 되지 않도록 하기 위하여 금지명령의 여러 쟁점에 관해서 각국의 입법내와 실무에 관해서 논의해보고자 합니다. 예, 본 세션은 두 개의 파트로 구성되어 있습니다. 여기 슬라이드에 보시는 바와 같이 먼저 각국의 특허법상 영구적 금지명령과 임시적 금지명령의 발령 요건과 기준을 먼저 비교해보고 이어서 두 번째 주제로 각국의 금지명령의 내용과 범위 그리고 그 집행 방법에 관해서 논의를 해보겠습니다. 이번 세션의 주제에 대해서 패널분들께서 사전에 자세한 답변을 보내주셨고 그 내용은 자료집에 잘 정리되어 있습니다. 이를 참고해 주시면 감사하겠습니다. 시간의 제약으로 인해서 세부 질문들을 통합해서 질문과 답변을 하고 패널분들에게 충분한 시간을 드리지 못하는 점에 대해서 미리 양해의 말씀을 구하겠습니다. 자, 패널분들께는 패밀리 네임의 알파벳 순서에 따라서 답변 요청을 드리겠습니다. 아까 소개해드린 바와 같이 미국의 챙 판사님, 영국의 헤이컨 판사님, 독일의 클라인 판사님, 일본의 시바타 판사님, 그리고 한국 패널분들 순서입니다. 패널분들께서는 주어진 시간 내에 답변을 맞춰주시면 감사하겠습니다. 예, 첫 번째 주제는 금지 명령의 발용 요건과 기준에 관한 것입니다. 첫 번째 공통 질문으로 금지 명령의 원고 적격에 관한 간단한 논의부터 해보겠습니다. 예, 질문입니다. 귀국에서는 특허권자가 침해 금지 청구를 하려면 직접 또는 최소한 실시권자를 통해서 해당 실시권을 실시하고 있을 것이 요구되는지 아니면 특허권자의 특허권 실시 여부는 침해 금지 청구 요건과 무관한지에 관해서 설명을 부탁드립니다. 답변은 1분 이내에 해주시기 바랍니다. 자, 먼저 미국의 챙 판사님 발표 부탁드리겠습니다.
No. No, thank you, Judge Wu, for moderating and organizing us so well. But yeah, the general answer is no. To the Supreme Court, of course, held in eBay versus Merck exchange that there is no general requirement that the patentee practice the patent in order to obtain an injunction. And in fact, the Supreme Court emphasized that broad absolute rules, like you must practice a patent, is inconsistent with our traditional equitable principles. And that is, as President Grabinski mentioned, when we issue injunctions, we sit in equity. And that is very much a case-by-case evaluation. So a broad rule like practicing a patent is inconsistent with that. With regard to licensing activity, the Supreme Court has not recently addressed this issue, but the eBay case did cite, with approval, a case from 1908. It had to do with paper bag folding, a patent on paper bag folding. And that patentee did not practice the patent at all. He did not license the practice at all, the patent at all, and he was still able to obtain an injunction. So I suspect that if it were to reach the Supreme Court, even licensing activities would not be required. Thank you.
예, 치행 판사님 감사합니다. 그러면 이어서 영국의 헤이컨 판사님 답변 부탁드립니다.
Well, like Judge Chang, I can easily answer this in 1 minute. Again, the answer is no. The statute, the Patents Act 1977, gives the patentee a right to appropriate relief if its patent has been infringed, and that will always include an injunction irrespective of whether it's been practicing the invention or not, or even licensing the invention. It's a right if you win your patent trial.
예, 답변 감사합니다. 이번에는 독일의 클라인 판사님 답변 부탁드리겠습니다.
Thank you. Well, my short answer would be no, but. So a slightly different comparison than my colleagues from the US and England. So our section 139 of the Patent Act, which deals with injunctions, only relates to the aggrieved party, without differentiating between this party actually practicing the patent or not practicing the patent. However, like you mentioned, we did have an amendment back in 21, and this fact that the plaintiff is an NPE could actually be one factor to consider when assessing proportionality issues. However, we will look at a decision tomorrow of my court actually. The courts, after the amendment entered into force, did take the position that the plaintiff being an NPE as such as the single circumstance is not enough to show disproportionality. And I guess this is in line with, well, how we view patents, because if you want a patent to be a transferable good, then it follows that you should not focus on the fact that the plaintiff is an NPE. Thank you.
예, 답변 감사합니다. 그러면 이어서 일본의 시바타 판사님 답변 부탁드립니다.
Thank you all, and I'm very honored to be here. Yes, the answer is no. Yes, in Japan, the patent right is considered to have so-called inclusivity. So, in principle, injunctions are granted if there is infringement or likely to infringement. That's a simple answer. But Judge Grant said, NPE may be one factor, but I said after this. That's the answer.
예, 시바타 판사님 답변 감사합니다. 이어서 한국의 권보원 판사님 답변 부탁드립니다.
To follow the established precedent by Judge Chang, I would say no. Article 126 of Korean Patent Act states that a patentee or an exclusive licensee may seek an injunction against a person who infringes or is likely to infringe their rights. It's similar to Japanese Patent Act. They must be registered at the point of the trial level's closure to get an injunction, but practicing is not a requirement. However, I think it kind of aligns with a German Patent Act amendment. If a patent is not being practiced, it can still influence decisions on preliminary injunctions or damages calculations.
예, 답변 감사합니다. 예, 이상의 발표에서 대다수의 국가에서는 특허권자의 실시 여부가 침해 금지 청구의 요건에 해당하지 않는다는 사실을 알 수 있었고, 예, 다른 하나의 고려 요소로 고려될 수 있다는 점을 알 수 있었습니다. 예, 그러면 이어서 공통질문 1-2로 넘어가겠습니다. 공통질문 1-2는 영구적 금지명령에 관한 것입니다. 시간 관계상 공통질문 2-1의 세부 질문을 통합해서 질문을 드리겠습니다. 먼저 귀국의 특허법상 영구적 금지명령에 관한 법 규정의 내용과 발령 요건 및 판단 기준에 관해서 설명을 부탁드리고, 만일 금지명령의 발령 요건으로 특허권 침해 사실 외에 추가적인 요건을 고려하는 국가들의 경우에는 그와 같은 추가적인 요건의 구체적인 내용은 무엇인지, 추가적인 요건의 증명 책임은 누가 부담하는지, 그 증명의 정도는 어떠한지에 관해서 설명을 부탁드립니다. 그리고 혹시 귀국에서 피고의 특허권 침해 사실은 인정되었으나 추가 요건을 고려하여 침해 금지 명령이 발령되지 않는 판결 사례가 있으면 소개해 주시면 감사하겠습니다. 답변은 세부 질문을 통합하여 3분 이내에 해주시기 바랍니다. 예, 이번에도 먼저 미국의 최 판사님께 발표를 부탁드리겠습니다.
Thank you. In eBay, the Supreme Court decided that the traditional equitable requirements for the issuance of a permanent injunction apply to patent cases just like any other case. So this was an example of the Supreme Court, which is a generalist court, refusing to create special rules for patent cases. And so what that means is that beyond infringement, the patent owner must show the traditional 4 elements, which is that they would suffer an irreparable injury, that remedies at law, usually money, would not be adequate compensation. The court must balance the hardships between the plaintiff and the defendant for issuing the injunction, which is the proportionality I think others have spoken about. And then the 4th element is to weigh the public interest. And so the plaintiff must show all 4. And it is the plaintiff who bears the burden of proof by a preponderance of the evidence to obtain a permanent injunction. And just a couple of examples, and there's some more details of this in the written submissions, where the plaintiff, the patent owner, otherwise established infringement but still was not able to obtain a permanent injunction. There was a case in which the patent issue dealt with microscopic fluid droplets, and one of the defendant was a very small company, and the patent owner was a very large company, and the defendant, the infringer, because the company was found to be infringing, sold 2 product lines that the company was basically entirely dependent on. And there, the Federal Circuit Court of Appeals held that there should not be an injunction issued there. The reasonable royalty would be enough, because otherwise the small company might cease to exist entirely. So that's one example. And then another example is a situation where the patent owner sells to one segment of the market, and the defendant, the infringer, sells to another segment of the market. And there too, the Federal Circuit has approved the refusal to issue a permanent injunction where there is not an overlap in competition, and instead a royalty would be sufficient. So there are times when the patent owner, despite showing infringement, is not able to obtain a permanent injunction.
예, 챈 판사님 답변 감사드립니다. 그럼 이어서 영국의 헤이컨 판사님 답변 부탁드리겠습니다.
Both proportionality and public interest can be taken into account when the court is considering whether to grant a final injunction. But courts have been rather specific about what those two things mean. Proportionality means, is an injunction proportionate to the potential damage to the patentee if there is no injunction? So if, for example, the patentee has stopped infringing, hardly infringed at all, or as Judge Chang said, if they're in different market sectors, the court might consider that an injunction just is not proportionate to the potential damage suffered by the patentee, so no injunction. But they are very rare cases. Much more common, although still quite rare, are public interest cases, where the court says, well, the injunction would potentially damage the public interest. And I can give you an example. In fact, it was an example that Klaus Grabinski mentioned this morning that was in the English court. There was a patent action, actually it came before me, to do with a heart valve. And I found that the patent was valid, it was infringed, and therefore, in principle, subject to public interest. The patentee was entitled to an injunction. But I was told at the hearing after the trial, well, there are some patients who can only use this kind of valve, and there's a potential risk to their lives if you grant an injunction. And in fact, I said, well, you can't just turn up and say this. I need evidence. You need to come back, and this needs to be reviewed in more detail. When it did come back, I actually went to another judge because I was doing something else. But what the judge said is, yes, there is a potential risk to the health of this small cohort of patients who could only use this specific valve that the defendants sold and infringed. So what the judge did, he said, I will grant the injunction, but there will be an exception for 12 months. For 12 months, the defendant can continue to sell this valve to purchasers who will use it only on this particular kind of patient. And in fact, he went further. He said, within that 12 months, the patentee can come back and say, well, people have been trained up to use another valve now, and so they would then cut the exception short, so it would be shorter than 12 months. Equally, the defendant could come back and say, we're getting close to 12 months, we still have the same problem, we want an extension. So it was left flexible, but that was a public interest point because there was a risk to life. It was a case called Edwards and eValve Sciences. That's the kind of case where, fairly unusually, the court would refuse to grant a final injunction.
예, 헤이컨 판사님 답변 감사드립니다. 이어서 독일의 클라인 판사님 답변 부탁드리겠습니다.
Thank you. So, like you said earlier, we had this amendment in 21, and we will look at the wording in the next question, I guess, of our sentence that has been introduced concerning this proportionality test in section 139, subsection 1. Now, what I would like to stress is this proportionality test really relates to exceptional cases, and the injunction remains the absolute rule. It's not comparable to the eBay factors or anything. And this is not only my view, although I do share this view, but it's the legislator's view as well. If you look into the memoranda accompanying the bill, the draft bill, you will find that the legislator really had those extreme cases in mind. And also the courts who had to rely on this disproportionality test after the amendment came into force, took the stance that you have to look at exceptional cases. So really, I would rather say that this is not an additional requirement, it's not a proportionality requirement, but rather it's a disproportionality defense. This also means that the plaintiff does not have to in their statement of claim, address proportionality. They do not have to show that the injunction is proportionate or the request for injunction is proportionate. Only once the defendant raises the issue of proportionality to show disproportionality, then the plaintiff has to react. And only in those cases will the court look into proportionality issues as well. We will look into some details, the factors that can be considered tomorrow in our case study session. But it's really, this is the most important thing, it's a disproportionality defense. This also means, concerning burden of proof, if the facts that could lead to disproportionality are debated between the parties, it means that the defendant has to prove those facts. So really, it's on the defendant to show disproportionality. We did not have a successful disproportionality defense in Germany until now. I went back to this question 2 days ago. I did not find a case. I don't know of any case. I did not find a published case. So I think there's simply none. And although that's the fact, I would like to briefly agree with Judge Haken what the possible consequences of a successful defense would be. It's not that we would totally exclude the injunction, but in most cases, we would rather limit the injunction, for instance, in a time-wise manner. So we would give a transition period or great use-by period, so much like the Hartwolf case that you mentioned. Only in very exceptional cases, so the exception amongst the exceptions, will the injunction be totally excluded. But that's really a super seldom case. Thank you.
예, 답변 감사합니다. 예, 그러면 이어서 1번에 시바타 판사님 답변 부탁드리겠습니다.
Article 100, paragraph 1 of the Japanese Patent Act provides that the patentee may file a claim against a person that infringes or is likely to infringe that patent right or exclusive license for the cessation or prevention of the infringement. So, to grant a permanent injunction, the law requires the infringement or likeliness to infringement and doesn't require the establishment of additional elements. But in Japan, when the execution of the right to seek an injunction is considered to be an abuse of right, an injunction will not be granted. The abuse of right defense is an affirmative defense. So the defendant bears the burden of proof of this defense. There is much discussion. So when deciding whether the execution of the injunction is abuse of right or not, consideration may be given to relevant factors such as degree of contribution of the patent right to the finished product as a whole, the amount of damages caused to the patentee due to infringement, the possibility of recovery in claims for damages, the magnitude of disadvantage caused to the infringers by the injunction, public interest, etc. So, but in Japan, much discussion has been made about the factors of abuse of right defense. And the defendants sometimes assert this defense. But so far, there has been no court precedent in which the abuse of right defense in a narrow sense has been successful. So I think it's very exceptional defense. But we discussed this defense much. Thank you.
예, 답변 감사합니다. 이어서 한국의 권보원 판사님, 예, 답변 부탁드립니다.
As I mentioned earlier, and as Judge Shibata explained about Japanese law and practice, Korean Patent Act also only requires an infringement or the likelihood of infringement for an injunction. So to speak, the law does not impose additional requirements like public interest or proportionality. However, defendants can still argue abuse of rights, similar to Japan, under the general principles of the Civil Act. For instance, seeking an injunction might be deemed to be an abuse of rights if the patented invention lacks novelty or an inventive step. I'd like to introduce to you an interesting case recently rendered by one of the chambers in Administrative Division of the Seoul High Court on August 30th, 2023. The court found that the plaintiff of pharmaceutical company seeking a preliminary injunction against generic drug producers, knowing that the drug did not infringe upon its patent and fully aware that its own patent was registered based on fabricated bioequivalence test data, was an unfair exercise and abuse of patent rights. It was an administrative law case, so the result was to affirm a corrective order and a penalty surcharge by the Fair Trade Commission. Interestingly, the court explicitly mentioned its reference to two decisions of the U.S. Supreme Court. One was Professional Real Estate Investors versus Columbia Pictures Industries, and the other was Walker Process Equipment versus Food Machinery and Chemical Corporation. I feel like Korean judges are open to adopting well-reasoned foreign jurisprudence. I hope Korean courts' well-reasoned precedents can also be translated well and exported to other countries to promote our harmonization of IP laws. So to sum up, while the law does not expressly stipulate additional criteria such as public interest or proportionality, Korean court managed to strike a balance between safeguarding patent rights and fostering a fair and competitive market landscape, eventually to promote innovation. Thank you.
예, 판사님 답변 감사합니다. 예, 그러면 이어서 최근 개정된 독일법에 관해서 독일의 클라인 판사님에 대해서 개별적인 질문을 드리겠습니다. 이미 이전 질문에 대한 답변에서 많은 소개를 해주셨던 것 같습니다만 독일의 2021년 특허법 개정 이후에 침해 금지 명령의 발령 요건이나 증명 책임 등에 관해서 독일 법원의 실무에 어떠한 변화가 있었는지, 그 다음에 특허 침해가 인정되었으나 비례성 등의 요건을 고려해서 침해 금지 명령을 발령하지 아니한 판결 사례가 있었는지, 그리고 특허법 개정 이후에 침해 금지 명령이 발령되는 사건과 발령되지 않는 사건의 비율에 변화가 있었는지에 관해서 설명을 부탁드리겠습니다. 답변 시간은 2분 이내에 해주시기를 부탁드립니다.
So some of these questions I've already answered. If this defense is raised, obviously we will consider it very carefully. I would say it's an additional defense that's been brought to us in most SEP cases after the amendment entered into force. Not every SEP case, but like at least 80% of the SEP cases. So it's an additional defense that the defendants obviously will use. It's been not successful until now, and so I can't say that really there's been a change in granting injunctions. But what we did see is that some courts, especially Düsseldorf and Munich, we concerned ourselves with the relation between this new proportionality defense or disproportionality defense and the defenses that had been known until then. For instance, Düsseldorf had to decide concerning the relation between the possibility to get a compulsory license on the one hand, so these would be third parties or maybe a Hardwolf case, and the disproportionality defense on the other hand. And they ruled that the disproportionality defense was subsidiary. And the same was found concerning the friend defense and the disproportionality defense. We will go back to that tomorrow again in the case of the Regional Court of Munich 1. And we held that if a defendant is found to be an unwilling licensee under the friend defense, most probably his disproportionality defense will not be successful either. There have been other cases as well, most concerning the chance or the possibility to find a workaround. So where the defendant already has a workaround, or where he should have found a workaround by now because he did have enough time in an NEP case, also the court said, well, in those cases you can't rely on the disproportionality defense. So really the granting practice has not changed, but obviously there has been much case law, and in most SEP cases, we do concern ourselves with proportionality issues nowadays.
예, 답변 감사합니다. 예, 한국에서도 독일의 특허법 개정 내용에 관해 많은 관심이 있었는데 독일의 특허법 개정 이후에 침해 금지 명령에 관한 독일 법원의 실무 관행과 변화에 관해서 잘 설명해 주셔서 감사합니다. 예, 그러면 다음으로 공통질문 1-3으로 넘어가도록 하겠습니다. 이번에는 각국의 예비적 또는 임시적 금지 명령에 관한 실무에 관해서 논의를 해보겠습니다. 예, 귀국에서 도입하고 있는 예비적 또는 임시적 금지 명령 제도를 소개해 주시고 영구적 금지 명령과 비교하여 발용 요건이나 증명의 정도에 있어서 어떠한 차이가 있는지, 또 절차적으로는 본안과 별개로 신청할 수 있는지에 대해서 설명을 부탁드립니다. 개인적으로 답변 주신 거를 본 결과 미국은 조금 그 스탠다드가 좀 높은 것 같았고 다른 나라들은 그 본안의 영구적 금지 명령 요건에 비해서 조금 낮은 정도의 증명과 을 요구했던 것 같습니다. 그런 부분에 좀 관심을 가지고 답변을 들으시면 많은 도움이 될 것 같습니다. 그러면 먼저 미국의 최행 판사님 답변 부탁드리겠습니다.
Thank you. Yeah, in the United States, there are two forms of provisional relief: temporary restraining orders and preliminary injunctions, and this is governed by Federal Rule of Civil Procedure 65. For temporary restraining orders, those are issued without notice to the other side. They are ex parte. And the rule requires that the plaintiff show that they would clearly be irreparably injured if notice was given to the other side. And so they need the TRO immediately. And I always tell lawyers that if you ask for a true TRO, where I'm going to issue an order without giving the other side an opportunity to respond at all, then your client's hair should be on fire. I mean, it really should be very rare that I simply cannot get at least some, even a verbal response from the other side. Temporary restraining orders, because they are so extraordinary, they are initially valid only for 14 calendar days. They cannot extend initially beyond 14. As that 14th day approaches, if the plaintiff can show that the TRO is still justified, that they are still suffering or would suffer irreparable injury, they can ask for one extension of another 14 days. So a temporary restraining order can last at most 28 days. They are not appealable. Right? Either the grant or the denial of a temporary restraining order is not appealable. So this is a very important proceeding in the district court. Preliminary injunctions, on the other hand, of course you have given notice to the other side, and indeed, very often in patent cases, I will allow some very limited and very fast discovery, where the other side, I will authorize a limited number of document requests and depositions and interrogatories. So preliminary injunctions, they're still expedited, but the other side does have notice and an opportunity to respond. In terms of the burden of proof, the standard of proof for provisional relief, such as a temporary restraining order or preliminary injunction, is that the plaintiff must make a clear showing of entitlement to relief. So this is a higher burden of proof than receiving a permanent injunction. And that's because, at least in the United States, we consider these to be extraordinary remedies. We have not made the final decision. We have not had all the discovery we typically engage in. And so the plaintiff must make a clear showing. And then the motion is independent of the merits proceeding. This will be, we'll decide the temporary restraining order and the preliminary injunction, the provisional relief, and then down the road we will have the jury trial and decide the merits. The rules of civil procedure do allow the court to consolidate, right, to bring the preliminary injunction proceeding together with a trial and even with a jury. Whenever I ask, the parties always say no. They do not want to consolidate with the merits proceeding. And I think for most American lawyers and American clients, they want the full discovery before they reach the trial stage.
예, 답변 감사합니다. 이어서 영국의 헤이콘 판사님, 답변 부탁드리겠습니다.
In English procedural law, we call these interim injunctions. And we also have the distinction between an ex parte injunction, which is applied for by a party without the defendant being present, and the more regular interim injunction, which is after a hearing from both sides. Ex parte injunctions are very unusual. One, because it goes against the grain of basic justice to have an injunction granted against somebody who hasn't had the right to turn up and explain their side of the case. But if it's extremely urgent and it's very obvious that the claimant is going to suffer damage, then ex parte injunctions are possible. There are severe sanctions, there are sanctions against a party who obtains ex parte relief on evidence which is either misleading, which is very unusual, but evidence which is incomplete, which is more usual. So if the claimant has been careful about how much they show the judge, and that emerges later, then certainly the injunction will be discharged and there could be other sanctions. Otherwise, the more common injunction is the one that lasts between the hearing and the trial. And to get that kind of injunction, the claimant has to show three things. One, that there's a serious question to be tried. They have some kind of case. It's not a very high hurdle to overcome. Secondly, that they have the money to compensate the defendant if they are to lose a trial. And thirdly, that they're going to suffer irreparable harm between now and the trial if there's no injunction. What it means is harm that can't be compensated in money if they were to win a trial. So, for example, if they were to lose the right of monopolizing a particular market because the defendant were to enter into that market, that may be irreparable harm that could never be compensated. So if those three criteria are satisfied, the judge then considers whether the defendant would suffer irreparable harm if there is an injunction. And if it would, the judge tries to strike a balance between those two. If the balance is equal, then and only then is the judge entitled to look at the likely outcome at trial. But we really try and avoid that result because otherwise it turns into a mini trial before the trial. But if the balance favors the claimant, then the injunction will be granted.
예, 답변 감사합니다. 이번에는 독일의 클라인 판사님 답변 부탁드리겠습니다.
So in Germany, we do have provisional or preliminary injunctions, and they can be granted ex parte, but this is only very seldomly done, much like Dr. Grabinski mentioned earlier. So to get in a preliminary injunction, we need to show an infringement on all the other things that you need to show under Section 139 of the Patent Act. And then you have some additional procedural requirements. You need to show that there's some kind of reason for the provisional injunction. So you must need to show urgency, and you must need to show that a certain balance of the interests of the parties tips in favor of the plaintiff. Now, as it requires level of proof, it might be different because in a provisional proceeding, it might be enough to just show prima facie evidence, and for permanent injunction, you must need full proof. But I would like to stress that at my court at least, the threshold is quite high. Like I said, we very seldomly issue ex parte injunctions, maybe if there's a trade fair issue, but usually we at least have a written procedure between the parties, and in most cases we will have a hearing. And those hearings last for hours, like days, and so we really get into all the matters. We go into claim construction, we look at the attacked embodiment, and obviously in most cases we discuss validity issues. So really this is, what we do is a very fast mini patent infringement case. So the threshold is quite high. You don't have to have a merits proceeding to get a provisional injunction. This can be filed totally independently, and in many cases we only have a provisional injunction and there's never a merits case.
예, 답변 감사합니다. 그럼 이어서 일본의 시바타 판사님 발표를 부탁드리겠습니다.
We have preliminary injunction in Japan. So Article 23, Paragraph 2 of the Civil Provisional Remedies Act provides that preliminary injunction. The requirement for a preliminary injunction are likeness to infringement on the merits and the necessity or to preserve the right holder's position pending the final determination. So we need the necessity to preserve the right holder's position pending the final determination. The proof required for a preliminary injunction is a prima facie case, so like German case. So prima facie showing shall be made using evidence that can be examined immediately. So usually documentary evidence is used. A court will accept prima facie evidence that is above factual fact. The proof required in the permanent injunction on the merit is certainty beyond a reasonable doubt. So the level of proof in the preliminary injunction is maybe lower, but it's very high. And it's possible to file a separate injunction for a separate motion for a preliminary injunction independent of the merit proceedings. It's like German.
예, 답변 감사드립니다. 그럼 이어서 한국의 권보원 판사님 발표를 부탁드립니다.
In Korea, preliminary injunctions can be categorized into two, one concerning the object of dispute and the other to establish a provisional position, with the latter being the type used against patent infringement. As in other countries, ex parte injunction is very seldomly, rarely granted. Although provisional, it restrains the defendant from practicing the invention, just as a permanent injunction would, on the merits would. The issuance of a preliminary injunction requires proof of rights to be preserved and the necessity or need for preservation. Rights to be preserved in this case would be infringement or the likelihood of infringement. Preliminary injunctions demand a high level of the necessity for preservation due to the potentially severe impact on a defendant's business. It is evaluated based on various factors, including the anticipated merits decision, the likelihood of who would win, and the severity of damages the patentee may endure due to infringement, and factors like defendant's ability to compensate or whether the infringement was willful, potential impact on public welfare or national defense, the defendant's effort to avoid infringement, and the broader business context, such as a defendant's market share or business stage, can also be considered. To sum up, the court has, I would say, comparatively bigger discretion when it comes to granting a preliminary injunction. Preliminary injunctions are often granted with the condition that the petitioner provides security to cover potential damages incurred by the defendant due to the enforcement of the injunction. However, if subsequent rulings invalidate the patent or find there was no infringement, the injunction would be cancelled and the plaintiff would possibly be liable for the defendant's damages. Thank you.
예, 답변 감사합니다. 예, 지금까지 살펴본 첫 번째 주제는 각국의 본안에서의 금지명령과 예비적, 임시적 금지명령의 실체법적, 절차법적 차이에 관한 비교를 해볼 수 있는 좋은 기회였던 것 같습니다. 이로써 첫 번째 침해 금지 명령의 발령 요건과 기준에 관한 제1주제를 마치고 침해 금지 명령의 집행에 관한 제2주제로 넘어가도록 하겠습니다. 제2주제는 각국의 침해 금지 명령의 내용과 범위 그리고 소송 절차에서 피고 제품 또는 피고 행위 특정에 관한 것입니다. 공통질문 2-1에 관한 것입니다. 공통질문 2-1도 세부 질문을 통합해서 진행하겠습니다. 먼저 귀국에서 금지명령의 형식과 내용 및 범위 등에 관해서 정하고 있는 법이나 규정, 판례 등이 있으면 설명해 주시고 침해금지 청구 시에 구체적인 피고의 실시 제품이나 피고의 실시 행위를 특정을 해야 하는지 아니면 피고는 원고의 특정한 특허권을 침해 행위를 해서는 안 된다라는 형식의 광범위한 내용의 금지명령도 허용되는지 여부를 알려주시고 만일 피고의 제품을 특정을 해야 한다고 하면 구체적으로 어느 정도까지 특정을 해야 하는지에 관해서도 설명을 해주시고 그리고 마지막으로 귀국에서 실무상 허용되거나 허용되지 않는 금지명령에 구체적인 기재례가 있다면 소개를 해주시면 감사하겠습니다. 답변은 세부 질문들을 통합해서 3분 이내로 해주시면 감사하겠습니다. 먼저 미국의 첸 판사님 발표 부탁드립니다.
Thank you. In American law, there are actually very few statutes and rules that direct federal judges to explain their decisions. Of course, by judicial craftsmanship, and because we want to maintain our credibility with the bar and the public at large, and we also want to ensure that whoever does not prevail understands that we consider their arguments. We, of course, explain our decisions as much as we can, but there are actually very few statutes and rules that require us to do it. At sentencings, we do have to explain our decisions, that there is a statute that requires that. Temporary restraining orders and preliminary injunctions, that is one of the rare instances in which a rule explicitly directs federal judges to explain the reasons for its issuance. And the rule also goes on to say that we must state the injunction terms specifically and also in reasonable detail. We have to describe the acts that are subject to the injunction. And this specificity does arise from the fact that if someone violates a temporary restraining order or permanent injunction, we can find them in contempt of court. And I think there's another question that might deal with that, so I'll put that off for a moment. But it's a very serious step to find someone in contempt. So we do have to, under both the rule and the Federal Circuit precedent, we do have to specify the accused product and what is not permitted. And so in this international rectifier case decided by the Federal Circuit, this is just one example of an instance where the district court entered an injunction that was too broad, at least in part, because the injunction said that any device covered by one or more of claims 1 through 5 of the patent, you must not distribute that kind of device. Well, that's too broad. That just says do not infringe the patent. That is not a specific enough act in order to support an injunction in American law. The only, and I wouldn't even say this is an exception, this is the only additional point I think that is important is that the injunction does apply to a product that is not more than colorably different. Right? That's the term that the courts use, not more than colorably different than the accused product. So for example, if I have issued an injunction against a microphone array, right, an invention that has a microphone array, and the infringer reduces the number of microphones in the array from 12 to 11, and then they try to sell that as a different product, that is not more than colorably different, and so that would still be subject to the injunction, even though it's not the exact same product, right? But that's the only difference. So we do need to specify the product.
예, 답변 감사합니다. 그러면 이어서 영국의 헤이컨 판사님, 답변 부탁드리겠습니다.
Well, the statute doesn't say anything about the form a final injunction should take. And until about 22, 23 years ago, this was a subject of some debate in English courts as to whether the injunction at the end of a patent trial should be specific or should be general. And then there was a judgment of the Court of Appeal which said it should be general. And broadly, because the Court of Appeal thought that it causes more problems than it solves to grant a specific injunction. So how does this work? Well, it usually arises, for example, if the patentee comes back after the trial and is seeking damages, and let's suppose the trial was all about the defendant's Model X infringing, and the judge has decided Model X infringes. And then the patentee comes back and says, oh, well, the defendant is selling Model Y as well. We want damages for that. Well, it will depend in large part on what the judgment, the reasoning in the judgment said. If the judgment said, well, features A, B, and C in your product taken together mean the product infringes, and A, B, and C are all found in Model Y as well, then an injunction, the judge will rule that the generally phrased injunction not to infringe patent number, whatever it is, will cover Model Y. Or if feature C is trivially changed, as Judge Chang, in the manner Judge Chang was talking about. So it crops up then, or sometimes it crops up when there's a question of enforcement. The patentee comes back and says, they are in breach of your broad order because they're selling Model Y. The same question would arise. Or very occasionally, the patentee comes back and says, we want a declaration from the court to make it clear that not just Model X, but also Model Y, perhaps Model Z, are also included in the injunction. And then the judge at that stage will clarify exactly to which products the injunction applies. But in the first instance, it's always generally phrased that the defendant is restrained from infringing patent number, whatever it is.
예, 답변 감사합니다. 그러면 이어서 독일의 클라인 판사님 답변 부탁드리겠습니다.
Thank you. So the injunction order is part of our decision. It's part of the operative part of the tenor, and like we learned, both Germany and Korea obviously put this in front of the decision. So the reasons for the injunction must be set out in the injunction decision, and still you must see that the injunction order should be understandable on its own terms. So just by looking at the operative part, somebody should understand what this entails, because this is so very decisive for the parties, much like Judge Chung just said. However, the operative part may refer to attachments, for instance, to photos, and in cases of doubt, it may also be interpreted. Now, do we allow broad injunctions? It depends on when you ask me. Some years back, when I first started out in patent law, I was told that we should always try to specify the attacked embodiment as specifically as possible. And this goes back to Federal Court of Justice's decisions stating that we should always try, even in the first instance, we should always try to be as specific as possible. And I will cite one of those examples in my presentation. at the same time, back then we did have a lot of mechanical issues. Nowadays we do have a lot of mobile phone things. And so it's very hard to describe a mobile phone. You can give a photo of a mobile phone in a tenor, but this won't help you in any way. So nowadays we actually allow the parties to only cite the claims in suit, and also we, in our tenors, we usually only use the claims in suit. If in some decisions it's necessary to really specify the attacked embodiment, then you can use photos, you can use a literal explanation of the attacked embodiment. It's very important to stress this, the court will not go beyond the prayers of the parties. So in most cases, especially in SAP cases, the plaintiff will refer to the attacked embodiments and state that with this claim, they really want to attack all the products of the defendant that use a certain standard. So it's a very broad attack. And if there's reason to give this injunction, we will follow suit with the wording of our injunction. But there are cases where the plaintiff limits themselves, for instance, to a certain phone model. And so in those cases, obviously, we will not go beyond the scope of the plaintiff's prayers. So if you see different versions of tenors, this might always depend on the prayers that we get from the plaintiffs. Thank you.
예, 답변 감사합니다. 그러면 이어서 일본의 시바타 판사님 발표를 부탁드리겠습니다.
So there is no provisions about this issue, but in Japan it is so that target product and specific conduct, the subject of the injunction should be specified in the injunction. Broad injunction without identifying the accused product or conduct of the defendant are not allowed in Japan. In terms of the effectiveness of injunctions, injunction must specify the target product and the target act, we think. So in the scope of what is prohibited, if the scope of what is prohibited is not clear, the defendant cannot know what action is prohibited. Furthermore, when carrying out compulsory enforcement, it must be clear which acts violate the injunction. Whether or not the target product is specified, generally speaking, depends on whether or not it is possible to distinguish the target product from other products according to the social norm. But in Japan, it is common Japanese courts practice that the target product is specified by the product name or model number if the target product has a product name. So maybe just the name has changed model X to model Y. So what happens? So, but we think that the patentee will petition for a preliminary injunction against the product with a new name. And preliminary injunction would be issued quickly if it is proven that the product is not different from the origin. So we think that this court practice is reasonable. Thank you.
예, 시바타 판사님 답변 감사드립니다. 그러면 이어서 한국의 이경은 판사님 답변 부탁드리겠습니다.
네. 금지명령의 내용과 특정의 정도에 관해서는 한국에서도 그동안 상당히 논란이 있었던 것 같습니다. 그런데 하지만 지금은 어느 정도 이제 실무의 태도가 정리된 것 같고요. 그래서 저는 제 발표 내용은 이제 그런 정리된 현재의 실무 태도를 기준으로 하겠습니다. 특허 침해 금지 명령에 관해서 가장 기본이 되는 규정은 앞서 언급된 특허법 제126조입니다. 그리고 금지를 구하는 피고의 행위는 피고의 침해 형태, 즉 특허권의 실시 형태에 따라서 구체적으로 특정이 되어야 됩니다. 특허법이 제2조 3호에서 실시에 해당하는 구체적 행위를 규정하고 있어서 이 규정에 해당하는 행위로 금지 대상 행위가 특정되게 됩니다. 뭐 예를 들어서 물건의 발명인 경우에는 그 물건을 생산, 사용, 양도, 대여 또는 수입 등을 하는 그런 구체적인 행위가 되게 됩니다. 그리고 제품 및 방법의 특정 정도에 관해서 대법원 판례는 그런 민사소송 청구 취지 특정의 일반 원칙에 따라서 사회통념상 다른 것과 구별될 수 있을 정도로 구체적으로 특정될 것을 요구하고 있고 서울고등법원 판결에서는 이것을 좀 더 구체화해서 침해 여부의 판단, 및 집행 대상의 식별에 지장이 없도록 구체적으로 특정되어야 된다라고 한 바 있습니다. 이런 판시들은 이제 금지 대상이 피고가 현재 침해하거나 침해하려는 행위이기 때문에 원고가 이제 청구 취지에서 피고가 실제 침해하거나 침해하는 행위 그리고 그 제품이나 방법을 구체적 개별적으로 명확하게 집행 가능하게 특정해야 한다는 것을 의미하고요. 금지명령 역시 이에 따라 발령이 되게 됩니다. 그래서 이런 관점에서 한국에서는 피고는 원고의 특허권을 침해해서는 안 된다는 형태의 금지명령은 발령하지 않고 있는 것으로 알고 있고요. 그다음에 특허권의 특징적인 구성 요소를 기술하고 이를 구비한 피고 제품이라는 형식의 금지명령 역시 발령하지 않고 있습니다. 이런 금지명령들은 그런 법률상의 추상적이고 일반적인 금지 의무를 기재한 것과 다름이 없어서 기판력의 범위가 확정되지 않고 집행 단계에서도 특허권 침해 여부에 대한 추가적 판단을 필요로 하기 때문입니다. 그러니까 기판력의 범위와 집행 가능성이 가장 중요한 기준이라고 보시면 됩니다. 그래서 특정의 모습을 좀 더 구체적으로 말씀드리자면 피고 제품이 제품명이나 모델명, 제품 사진 등으로 특정되면 좋고 그렇지 않더라도 집행기관 식별에 지장이 없도록 도면이나 제품 구성에 대한 설명으로 명확하게 특정이 되면 됩니다. 방법 발명 같은 경우에는 피고가 사용하고 있는 구체적인 방법 또는 제조 공정을 기재함으로써 그 방법을 특정하게 됩니다. 그리고 제가 특별히 아주 넓거나 아주 좁은 수준의 금지명령 사례는 찾기 어려웠지만 침해 제품을 제품명과 구성, 형상으로 특정한 다음에 여기에 더해서 제품명을 달리하지만 구성 형상은 동일한 제품을 그 금지 폐기 대상으로 할 수 있는지에 관해서 서로 다른 입장을 취한 두 개의 판결이 있어서 소개합니다. 여기 PPT 화면에 나오는 그런 사진과 사안을 참고해서 같이 보시면 좋겠는데요. 먼저 서울중앙지방법원의 582904 판결입니다. 화장품 용기에 관한 그 특허 발명 침해가 문제된 사안인데요. 금지 대상을 피고가 실제 실시하고 있는 제품과 제품명, 사진 뿐만 아니라 이제 각 구성에 대한 설명까지도 덧붙여서 특정을 했습니다. 원고는 이제 여기에 대해서 실제 실시하는 제품과 동일한 구조와 형상을 가진 다른 명칭의 제품들도 포함해서 금지를 구하였는데 이 판결에서는 그 부분, 다른 명칭을 가진 제품들 부분은 집행 가능성이 부족해서 특정되지 않았다고 판단하였습니다. 반면에 다른 입장을 취한 두 번째 판결이 있는데요. 571828 판결입니다. 이 판결 같은 경우에는 금지 및 폐기 대상 제품을 특정한 그런 특정된 제품명에 한정하지 않고 특정 구성을 갖춘 경우까지 포함하여 인정하였습니다. 개인적 의견으로는 두 번째 태도 정도가 적절하지 않은가 생각하고 있습니다. 감사합니다.
예, 답변 감사드립니다. 예, 그러면 이어서 공통질문 2-2로 넘어가도록 하겠습니다. 예, 이 질문은 만일 피고 제품 중의 일부 구성이나 일부 부품만이 특허권 침해에 해당되는 경우에 금지 명령의 범위에 관한 귀국의 실무와 판단 기준을 소개해 주시기 바랍니다. 답변은 1분 이내로 해주시기 바랍니다. 먼저 미국의 최 판사님 발표 부탁드립니다.
Generally speaking, a patent owner must show that the infringement causes the harm that is targeted by the injunction. When there is a device with multiple components and only one component infringes the patent, then the courts say that there must be a causal nexus between the infringing acts and the harm. And I'm sure all the interpreters paused on causal nexus quite understandably because it is a very legalistic term. What the Federal Circuit has explained further is that all that means is that there must be some connection, right? Some connection between the patent features and the demand for the infringing product. Right? The patent owner does not need to show that the infringing component is the exclusive or even the dominant reason why consumers demand the product. And I think that is an outgrowth of the idea that in a multi-component product, very often consumers are deciding based on their purchasing decision based on many of the components. And so it would be too difficult for a patent owner to show that the infringing component was the exclusive or predominant reason for the purchase. So just some connection is needed.
예, 미국 최행 판사님 답변 감사드립니다. 이어서 영국의 헤이컨 판사님 답변 부탁드리겠습니다.
Well, if the patent only covers a small component in a large product, then selling the large product will still infringe the patent. So, in principle, the injunction will stop the sale of the large product. It's possible that here an argument on proportionality could arise. The defendant could say, oh, well, your patent is only for a new clever kind of screw, and we've used only one in our huge product, and if the court grants an injunction, we're losing profits on the whole product, whereas we're only infringing just this little screw part. That could be a reason for considering whether to make an award of damages instead of an injunction, but I've never heard of such a case. And I think the reason I've never heard of such a case in English law is because on the facts, you can always replace this clever new screw with a slightly less clever old screw, or whatever it happens to be. And in truth, what the defendant is saying is that by infringing, we're making our product a bit more competitive because we're using this component. And the answer is, well, you can't. The injunction would stop you. So the answer is to go back to using slightly older technology, which may mean your product is a bit less competitive, but that's the consequence of infringing. So I've never heard of a proportionality case that covers that, but in principle it could.
예, 답변 감사드립니다. 예, 그러면 이어서 독일의 클라인 판사님 답변 부탁드리겠습니다.
Thank you. I agree with Judge Haken, and basically on yes, if an injunction may address the whole product, even if only a very smallish part in this complex product is infringing the patent. And obviously complexity of the product might be a proportionality factor to consider. I actually remember a case as a judge rapporteur, and it's the one case where of the tenors that we just saw, where we did use a photo, so you can always go back to those materials and find the case if you're interested, where actually it was about a very small-ish valve in a car, and this car, well, and there we had the discussion of proportionality even before the amendment entered into force. But also in this case, we did not find for disproportionality. Now, concerning the second part of the question, manufacturing equipment, this may be destroyed if it's predominantly used for manufacturing infringing products. So really there must be at least 50% of usage for these infringing products. And there's a special disproportionality test concerning this destruction. So an additional proportionality issue, at least. Thank you.
예, 답변 감사합니다. 그러면 이어서 일본의 슈바타 판사님 발표 부탁드리겠습니다.
Yes, the same as two countries. So, as I said, in most cases in Japan, the target product is specified by the target model name or brand name. Product was specified by the product name. As long as the object is specified as one product, the injunction shall prohibit the sale of the entire product that is specified as product name. This is a principle. So the infringing part is small, is the issue of whether or not the defense of abuse of right is successful or not. Thank you.
예, 답변 감사드립니다. 그러면 이어서 한국의 이경은 판사님 발표 부탁드리겠습니다.
네, 전체 제품의 일부만이 특허 침해에 해당하는 경우에는 해당 구성이나 부품만 금지 및 폐기 대상으로 하는 것이 원칙인 것으로 보이고, 주된 판단 기준은 그 특허권 침해하는 일부 구성이나 부품이 전체 제품과 분리 가능한지, 그다음에 불가분적으로 결합되어 있는지 또는 별개로 거래되는지 뭐 이 정도인 것 같습니다. 제가 자료집에 2개 판결을 소개를 해놨는데요. 그 중에 이제 첫 번째 특허법원 판결에 대해서만 이 자리에서 말씀드리고 싶습니다. 2016-1745 판결이고요. 이 사건 같은 경우에는 모터 체결기구에 관한 특허권 침해가 문제된 사안입니다. 그래서 원고는 모터 체결기구가 사용된 RC 감속기라는 제품 전체의 생산 금지 및 폐기를 구했는데 이 판결에서는 이제 이 둘이 불가분적으로 결합되어 있는지 일체화되어 있는지를 기준으로 삼아서 일부분인 모터 체결기구와 그 생산에 제공된 설비 제거 청구만을 인용했습니다. 근데 제가 이 판결에서 이제 조금 재미있게 본 부분은요, 제가 판시 부분을 자료집에는 인용을 해놨는데, 금지 대상의 범위와 관련해서 비례성 원칙을 언급하고 있다는 점입니다. 그래서 앞서 금지명령 발령 요건에서 봤듯이 한국은 금지명령 발령 여부와 관련해서는 어떤 비례성 원칙을 고려하고 있지는 않지만 이 판결을 보면은 그 금지 대상이나 대상의 범위, 그 다음에 폐기의 범위와 관련해서는 비례성 원칙을 고려할 여지가 없는지 또는 이미 고려하고 있는 건 아닌지 이렇게 생각이 좀 고민을 하게 만드는 그런 판결인 것 같습니다. 예, 감사합니다.
예, 답변 감사합니다. 예, 드디어 마지막 공통 질문 2-3입니다. 예, 드디어 마지막 질문에 도달을 했는데요. 예, 공통 질문 2-3도 세부 질문을 통합을 해서 질문을 드리도록 하겠습니다. 먼저 금지 명령의 실효적인 집행을 위해서 귀국에서 채택하고 있는 구제 조치들과 그 집행 절차들에 대해서 간략히 소개를 해주시고 이와 관련하여 귀국에서 다소라도 광범위한 금지 명령의 발령이 가능한 경우에는 집행 절차에서 피고의 판매 제품이 침해 제품으로서 집행 대상이 되는지 여부에 관한 판단이 누구에 의해서 어떻게 이루어지는지에 대해서 설명을 해주시고, 또 마지막으로 침해 금지 명령이 내려진 이후에 피고가 침해 제품의 구성이나 내용을 일부 변경하였으나 여전히 해당 특허권을 침해하는 것으로 보이는 경우에 특허권자로서는 피고의 변경된 제품이나 행위에 대해서 기존의 침해금지 명령에 기한 구제 조치를 할 수 있는지, 아니면 별개의 침해금지 청구의 소를 제기해야 하는지에 대해서 각 국의 판단 기준이나 실무 사례가 있으면 소개해 주시기 바랍니다. 예, 답변도 세부 질문을 통합해서 2분 30초 이내로 해주시면 감사하겠습니다. 예, 먼저 미국의 최 판사님 답변 부탁드리겠습니다.
Yeah, if a party violates an injunction, then we do have, as federal district judges, substantial discretion in imposing penalties and trying to coerce compliance. I can impose monetary sanctions, can require the defendant to disgorge any profit that they have made from the violation of the injunction. And if I really need to, I can order the United States Marshals, the federal law enforcement agents, to seize inventory. I was very tempted in one case to do that, ultimately decided not to. But if a defendant is untrustworthy and you do not believe that the inventory has been returned or will not be distributed, then we do have that authority as well. And I think when I find a defendant in contempt of an injunction, that also does create very serious reputational harm. Companies are very, very concerned when a federal court holds them in contempt. And thankfully, we still have the credibility as a federal judiciary that when someone clearly and knowingly has violated a court order, that is taken very serious by the business community as well. That their vendors and others will treat them differently. With regard to, we do not have the broad injunctions, but if in deciding whether or not a product is not more than colorably different, it's the same judge who issued the injunction who decides that. It's not a different judge or a different case. But if there have been enough changes that it is now more than colorably different, but we don't know whether it infringes, that's a new case. That is not going to be part of a case that has already been resolved at a permanent injunction. However, the patent owner can ask for the case to be reassigned to the same judge who issued the first injunction, and in that way, the judge will already be familiar with the law and the parties. Thank you.
예, 답변 감사드립니다. 그럼 이어서 영국의 헤이콘 판사님, 예, 답변 부탁드리겠습니다.
The system in England is broadly similar. A court doesn't monitor its own injunctions. What happens is the plaintiff rather, alleges that the defendant is still infringing and is in breach of the court order, and then can make an application to the court for what we also call contempt of court. You're in breach of the order. And if that's established, usually the first sanction is to fine the defendant company. If they carry on or they repeat it, then the sanction can escalate to committing directors of the company to prison, or if it's an individual defendant, to commit him or her to prison. It very rarely happens, and the reason is usually in patent cases the companies are well established, and for reasons that mentioned by Judge Chang, they don't like a finding of contempt made against them, so this isn't very usual. If the issue on the contempt proceedings is rather like my Model X and Model Y example, the defendant comes back and says, well, you gave a judgment about Model X, and of course we're not in contempt because we're now selling Model Y. Well, it will turn on the issues I mentioned earlier. If Model Y contains all the essential features of the product found to infringe, that will be a contempt of court, or only a minor colorable difference. If in effect the judge cannot decide whether Model Y infringes without a whole new trial, then that will be a separate matter and certainly won't be an immediate contempt. It will require a whole new trial to investigate it, and then that will have to be arranged separately. But otherwise, that's the way we go forward.
예, 답변 감사합니다. 자, 그럼 이어서 독일의 클라인 판사님 발표 부탁드리겠습니다.
Thank you. So a lot has been said already that I can rely on. In case of non-compliance, the court has the discretion to fine the defendant, and in extreme cases, there's also the possibility of detaining the legal representatives of the defendant. Now, it's the court of first instance who is responsible for those orders, so ideally this means that we will have the same judges again. Not in all cases, depending on the timeline that has been passed between the first decision and then coercive measures, but in many cases you will have the same judges who already know the case deciding this order. Now, in cases of broad decisions or broad tenors, we will usually be able to look into the decisions. So, for instance, if a certain standard was at the core of debate between the parties, then we will look into the attacked embodiment that is now in debate between the parties, and we'll find out if it uses a certain standard. We will not issue an order in enforcement cases without hearing the defendant first. So if there's any facts that are debated between the parties, we will get to know about this because we have at least a written procedure between the parties. Now, if there are alterations made, sometimes there's a very slim distinction. The idea is that if you can only read the first decision or reread the first decision, and then decide if the newly attacked embodiment with slight alterations still falls within the scope of the injunction, then you will be able to decide this case with just coercive measures. So really you can kind of rely on products that are essentially alike to also fall within the scope of the first injunction order. But if you have to go back to the patent, if you have to go back to claim construction, maybe discuss the same feature from another aspect, then you will have to file a new suit as a plaintiff. For an example, I've referred to my written answers, and we had a couple of series of cases in a couple of years back, where actually the plaintiff was not sure if it was a new injunction case or if it was merely coercive measures. So they filed both on the same day, if I'm correct. So really, sometimes this distinction is very hard to make, even for professionals. Thank you.
예, 답변 감사드립니다. 이어서 일본의 시바타 판사님 발표 부탁드리겠습니다.
If the defendant fails to comply with the court's injunctive order, the court may order the defendant to pay to the plaintiff money of a certain amount that is found to be reasonable for securing performance of the obligation. That is a principle. Judgment ordering the destruction of product can be enforced by so-called substitute execution. Substitute execution is based on the authorization decision by the court. If no executor is specified in the authorization decision, the obligee or any other person may remove the infringing material at the debtor's expense. And so, as I said, Model X and Model Y cases, in Japan, I think it is necessary to file a new lawsuit. But a patentee can file a petition for a preliminary injunction, and a preliminary injunction would be issued quickly if it is proven that the modified product is not different in terms of the technical scope from the old product. Thank you.
예, 답변 감사합니다. 이제 마지막으로 한국의 이경은 판사님 발표를 부탁드릴 텐데요. 근데 우리가 그 저녁 마지막 세션에 예정된 시간을 이미 5분 정도 초과를 했습니다. 물론 저희가 5분 늦게 시작을 했지만, 그래서 아까 우리가 이 세션에서 배웠듯이 금지 명령도 공공의 이익에 의해서 제한될 수 있는데, 공공의 이익을 위해서 답변 시간을 한 2분 정도로 좀 줄여서 간략하게 말씀해 주시면 감사하겠습니다.
네, 노력해 보겠습니다. 한국에서의 금지명령 집행은 민사소송 일반 집행 절차에 따라 이루어집니다. 그래서 특허권 침해 금지명령의 실효성 확보를 위해서 별도의 제도가 마련되어 있지는 않습니다. 그래서 금지명령은 부작의 의무를 명한 것이기 때문에 간접강제 방식에 의하게 되고요. 그래서 1일 얼마를 지급하라 이런 식으로 이행강제금 지급을 명하는 형식이 됩니다. 그리고 금지명령하고 함께 발령된 폐기명령 같은 경우에는 대체적 자기 의무이기 때문에 집행관에 의한 대체 집행이 가능한데, 제품이나 생산 설비의 소재지를 주문하고 금지명령의 주문과 바꾸거나 하는 경우에는 그 집행이 어렵게 됩니다. 그리고 금지명령 발령 이후에 새로운 위반 행위로 제조한 제품 같은 경우에는 이제 이 대체 집행이 그 집행관에 의해서 이루어지기 때문에 그 대상 여부 판단이 어려울 것으로 좀 예상이 됩니다. 그리고 한국 실무에서는 구체적으로 특정된 피고의 침해 제품 외에 이와 유사한 제품과 같은 형식의 금지 명령은 허용되지 않는 것으로 알고 있고요. 그 다음에 피고가 회피 설계를 통해서 그 구성이나 방법 일부를 변경한 경우에도 특허권자는 별도의 금지 소송을 통해서 금지 명령을 받아야 합니다. 네, 2분이 안 된 것 같습니다. 이상입니다.
예, 이경은 판사님 특별히 감사드리겠습니다. 예, 이것으로 이번 세션의 모든 주제에 관한 논의를 마쳤습니다. 예, 시간 플로어에서 질문을 받고 싶긴 한데요. 예, 그 시간이 많이 지난 관계로 플로어 질문은 생략을 하고요. 혹시 간단하게 시간이 된다면 발표자들께서 추가로 하고 싶은 말씀이나 인사말을 짧게 해주시면 감사하겠습니다. 한 30초에서 1분 정도. 먼저 최영 판사님 혹시 간단한 말씀이나 인사 말씀 하실 게 있으시면 하시고.
Thank you. I just appreciate the chance to learn more about other nations and how they approach injunctions. I think in American law, because injunctions govern conduct going forward, it's not compensating for something that was done, as a historical fact. Judges in America, we do not want to legislate from the bench, and that sounds a lot like legislation. When you issue an injunction governing conduct going forward into the future. So I very much appreciate the chance to learn. Thanks.
이어서 헤이콘 판사님, 예, 간단한 말씀 부탁드리겠습니다.
Thank you very much. Well, as I think quite often happens when you hear views from different jurisdictions, although the detail of the approach may vary from one country to another, the similarities are much more striking than the differences. And, well, that's encouraging. And I think it's explicable because we're all aiming at the same broad end to achieve a just result. So it's not only encouraging, I think it's quite striking that on the whole, the answers we gave were broadly similar.
예, 이어서 클라인 판사님, 예, 말씀 부탁드리겠습니다.
I totally agree with Taken. This is what I kind of expected, but still it's very interesting to see how much we really come to the same conclusion in the end, even if we sometimes take slightly different ways. Thank you.
예, 감사합니다. 예, 시바탄 판사님, 예, 혹시 예, 말씀.
Yes, you know, the very different approaches, but same conclusions. It's very interesting. Thank you.
예, 감사드립니다. 이어서 예, 권범 판사님부터 순서대로.
Yeah, it was a great honor to participate in this meaningful discussion, and it was also interesting to find out how different the level of specification were among the countries. And let's have our delicious dinner together. Thank you.
이경 판사님, 간단한 말씀 부탁드립니다.
네, 앞에서 보니까 이제 여기 계신 분들이 정말 힘들고 졸리고 배고프고 하실 텐데 정말 뭐 자세도 바꾸시면서 여러 가지로 끝까지 경청하기 위해서 노력하시는 모습들이 다 너무 잘 보여서 되게 재밌으면서도 정말 감사한 마음이 들었습니다. 그리고 발표 들으신 분들 느끼셨겠지만 한국 같은 경우에는 뭐 기판력의 범위나 집행 가능성에 초점을 둔 나머지 이제 좀 그 금지 명령의 효력이나 범위가 굉장히 좁게 이제 발령이 되는 경향이 있는데요. 오늘의 이런 비교법적인 검토가 정말 우리 실무에도 시사하는 점이 많다고 생각이 됩니다. 네, 발표해 주시고 그다음에 경청해 주셔서 정말 감사합니다.
예, 이상으로 4세션을 마치겠습니다. 경청해 주셔서 감사합니다.
네, 감사합니다. 4세션 참가자들 수고하셨습니다. 이것으로 2023 국제특허법원 콘퍼런스 1일차 일정을 모두 마치겠습니다. 정말 수고하셨습니다. 공지사항이 있습니다. 잘 들어주시기 바랍니다. 2일차 일정은 내일 오전 10시부터 특허법원 청사에서 진행됩니다. 잊지 마시기 바랍니다. 그리고 오늘 태블릿을 받으셨을 텐데요. 떠나시기 전에 태블릿과 통역기는 자리에 두고 가시면 감사하겠습니다. 그리고 공식 만찬 참석자분들께 알려드립니다. 만찬 때는 좌석 배치가 변경이 될 예정입니다. 만찬 참석자분들께서는 통역기와 태블릿을 테이블에 두신 후에 개인 소지품은 모두 들고 로비에서 기다려주시면 감사하겠습니다. 만찬은 6시 50분에 시작하겠습니다. 자리가 변경되기 때문에 만찬에 참석하실 때는 안내를 받으시거나 배치표를 확인해 주시면 감사하겠습니다. 네, 모두 수고하셨습니다. 감사합니다.